if it can be taken up at 3:30, my lord. From 2 o'clock, there is a matter fixed, my lord. Mr. Mitra will be on legs. So he'll take 15 minutes to conclude. He was to conclude at the 3 p.m.
That
Item number
restitution
5.
matter, my lord. Restitution.
Item number 5, my lord, which is fixed at 3 p.m. today.
Achha.
Instead of 3, if it can be taken up at 3:30. Only request, my lord. He'll take 15 minutes.
Then 3:45 other matter is fixed.
Yes, because that's why 15 minutes only he'll take. Because he has.
I have no. Let it be concluded today, my lord. It's been
Yes, but
very
he'll
long, my
conclude,
lord. He has been.
15 minutes at 3:30, my lord. Grateful, my lord. Deeply obliged.
Lord, with notice to the other side, my lord, I am mentioning this matter, my lord. The matter was heard by His Lordship, the Honorable Justice, because Court tonight on 10th, my lord. My lord, kindly see this, my lord. His Lordship directed where, my lord, the Howrah Municipal Corporation stated the date is fixed on 27th January 2025 for, my lord, demolition of the deviated portion, my lord. My lord, we preferred appeal against the order, my lord, dated 21st May 2024. The appeal was heard by, and in the appeal there was direction to hear all the points raised in the appeal by the my lord, by the trial court, my lord. We, my lord, filed an application for passing an interim order so that, my lord, the demolition is told on list, my lord, on 27th, which is fixed on 27th January, my lord. My let this, my lord, application appear in the list, my lord. This is very urgent, my lord.
What the appellate court has held? Any stay?
Appellate court, my lord. No, on all points kept open, that will be decided.
Not decide any rights of the parties of the litigation, such as we are not intended to interfere with the present affair.
My lord, I will pray only for interim protection, my lord.
What the order was passed by the Justice Patnaik?
10th January, my lord. 10th January, my lord. It is informed by the learned advocate for the Howrah Municipal Corporation that 27th January 2025 has been fixed for taking steps in respect of demolition of the G+1 structure. That is, my lord, deviated portion only. And deviated portion, that is also, my lord, disputed. They have not decided the deviated portion properly. Department is directed to place the application in the case file positively on the next date fixed since the same is unavailable. And His Lordship fixed up 14th January 2025 because of the urgency, my lord. Then, my lord, determination changed.
So 14 January, it not.
No, His Lordship took up the matter up to 12. And that was item number 14. That I have also the list. I have also given the list, my lord, and not reached, my lord. Up to
yesterday,
up to 5, my lord. Up to, my lord, item number 5. That was reached, my lord.
Yesterday I mentioned, my lord.
Very urgent, my lord. Kindly.
Tomorrow 3:45 khali hai na? Tomorrow at 3:45. Tomorrow inform the other side.
My lord. Great.
I mentioned. We have sub notice.
Lordship, may I be permitted to mention a matter, Lordship? This matter, the interim order is expiring tomorrow. It's not running in your Lordship's list.
Mention tomorrow, I will take.
Lordship, it's a non-commercial matter.
No problem. At 4:13, whatever the.
Lordship, but it is not running in your Lordship's list.
No problem. I will take.
Lordship,
mention. Bring the last order.
Lordship, I'll mention tomorrow.
Lordship, not mention at the time of rising of the court after at 3:34, whatever it may be. 4:15, I have given the time at 4:15. If it is 3:30, then mention at 3:30.
Lordship, may I mention in determination code number 39? The urgency is the Panchayat authorities demolished by the petitioner's property. Panchayat authority wants to demolish the petitioner's property. Kindly.
So if you have constructed the illegal, what the Panchayat will do? They will demolish only. If you make a illegal construction, the municipal council will demolish only. They will not allow you to construct, or they will not provide the materials to further make construction.
Kindly allow this.
For what? Is the Panchayat had issued any notice of demolition? Is the Panchayat issued any notice of demolition?
Yes.
When? When the notice was issued? Come.
My lord, may I be permitted to mention a matter?
Kindly.
The matter.
No. First you have to show the urgency, sir. This court is only taking the urgent matter. If you are having any urgency, show the urgency, then the court will consider.
The matter pertains to the termination of a eligible entrepreneur.
Termination of?
Eligible entrepreneur. Entrepreneur.
Entrepreneur, yes.
Entrepreneur. And he was illegally terminated.
When he was terminated?
16 March 2022.
Then?
Now kindly allow the matter for the hearing.
When you file the writ application challenging termination?
2024.
Then what is the urgency now?
My lord, he is the sole earning member.
Maybe March it was, it has been terminated. We are in the January, more than 9 months has been passed.
My lord, on the last
Place
occasion.
before the, yes, place before the regular bench, madam. Sorry. Yes.
My lord, may I be permitted to mention one matter, my lord? It is a suit matter of your lordship's regular determination, my lord. My lord, the suit pertains to permission of the of this honorable court for sale of a Devottar property. My lord, the Devottar property, the building standing in the estate, my lord, is in dilapidated condition, and the rental income from that building is so meager that the daily pujas are.
What you want?
My lord, I want listing and
Have
urgent
you
hearing.
filed an application? Filed the suit?
Yes, my lord, there was a direction of this honorable court for taking steps for service of summons upon the defendants. That has been complied with,
So,
my lord.
but where is the returnable date?
My lord, it was in sometimes in April 2024.
The notice was issued to the defendant. What is the returnable date in the notice?
That instruction I am not presently
No.
having, but it was sometimes in the
In the
2024.
notice, what is the confirmed from the department? If the returnable date is over, mention the matter, then the court will.
Returnable, my lord.
Correct. You go to the department, consult what is the returnable date of the notice. If the returnable date is over, then come.
My lord, may I come back tomorrow, my lord?
Maybe you bring the details when it was, what is the returnable date?
My lord, I will come back tomorrow.
My lord, I beg to mention one matter from the list and determination of Honorable Justice Bivas Patnaik, my lord. Group
what?
5. This is related to, my lord, tender, my lord. This is tender, my lord. The Panchayat Pradhan issued tender notice violating the
When the notice, tender notice was issued?
September 2024, my lord.
Urgent, yes. Call the
My
list.
lord,
And I have also checked up, my lord. It was, my lord, affirmed on 17th of December 21, and according to my lord,
That yes.
we have not been supplied
No,
with it.
subsequent, the department has brought this.
Oh,
Go through.
my lord, I have maybe given a copy, my
Give
lord.
the copy.
and there may be an endorsement
So
of
that's why you not
acceptance
signed the
on-
order. It was filed in terms of the order.
Yeah, accept for it. Plaintiff.
Plaintiff
Book of
filed the
file with
additional.
plaintiff.
Actually, it is additional. They have cut down the additional.
Oh, but well, I need a copy, my lord.
Yeah, I'll serve them a copy.
2022, 21,
22-1. As per
2020.
the order.
Very well, my lord. Kindly direct them to provide a copy in course of the day.
Very well. Copy for you.
20 January and the leave was granted on 18 January. Census suffering for the plaintiff, census suffering for the defendant. Though the matter was listed before this court yesterday, that is कल क्या date था देख लेना क्या था 16 20 but the additional written statement filed by the plaintiff was not placed before this court. Subsequently, the additional written statement to the counterclaim filed by the plaintiff was placed before this court. Accordingly, the matter was is listed as to be mentioned. Full stop. It is fine from the record as per the leave granted by this court dated 18th January 2022, the plaintiff has filed additional written statement to the counterclaim on 20 January 2022. Police counsel for the defendant submitted the copy of the written statement has not been served upon the defendant. Full stop. Learned counsel appearing for the plaintiff is directed to serve the copy of the additional written statement to the learned counsel appearing for the defendant in course of the day. Full stop. So I am passing a direction.
Yes, yes.
The other direction.
Other direction will
makes it
remain, my lord.
in discovery inspection and my lord,
As
we can deny
the written statement, both the parties have filed their respective written statement with regard to the plaint as well as the counterclaim. Accordingly, the parties are directed to complete the discovery and inspection of the document within 3 weeks.
3 weeks.
Full stop. After completion of the discovery and inspection, the parties are directed to file their affidavit of admission and denial of the document within 2 weeks thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues.
Very well.
But maybe also come back with the JS brief of documents, my lord.
Full stop. The plaintiff is also directed to file the judge's brief of document in the meantime. Let the matter appear on 5 weeks. Na?
For framing of issues.
For framing of
2, 3, 4, 5. Let the matter appear on 28th of February 2025 for framing of issues.
Grateful.
Or 4th March.
4th March.
4th March for framing of issues.
Deeply obliged.
Framing of issues and filing judges before court. Yes.
Item 2, my lord, I beg to appear for the plaintiff.
I beg to appear for the defendant.
What you have done?
My lord?
What you have? You are having the plaint
Yes, my lord.
and you are having the exhibits.
Yes, my lord.
Yes. Kindly come to the exhibits. The purchase order is of 42 lakhs for 70,000. That is annexure C. Plaint. You are having the plaint.
Yes, my lord.
Purchase order which you are relying upon, that is the 42 lakhs 24,400. Page 11, annexure A.
Oh, my lord.
You are having the plaint.
My lord, I appear to have got the wrong brief, my lord. Yes, my lord.
Having the plaint.
Yes, my lord.
42 lakh 24,400.
Yes, my lord.
Correct.
Yes.
There is no problem at all. Now come to annexure C, your invoice.
Yes, my lord.
What is your invoice? 42 lakh 70,868.
Yes, my lord. Yes, my lord.
What is the legal notice? 42 lakh 70,000.
Yes, my lord.
Correct.
Yes, my
There's
lord.
no problem.
Yes.
Now kindly come to your plaint. In the plaint, kindly come to the page 524, paragraph 5. 42 lakhs 42,000 24,400. What is the claim? Principal. Page 4. 42 lakhs 20. How it can be? Your legal notice is 42 lakhs 70,000.
Yes, my lord. There appears to be a mathematical
Total
error.
contradictory. Plaint and your documents which you have exhibited total contradictory.
My lord,
What
the
can be done?
purchase, yes, my lord, the purchase order was for 42 lakh 24,000.
Correct.
But my lord,
42 lakhs, thereafter TDS 3,672.
yes, my lord.
So then you have come to the 42 lakh 70,000.
70,000, yes, my lord.
You have
Yes.
given the demand notice of 42 lakh 70,000,
Yes, my
but you have claimed in the plaint with regard to the 42 lakh 24,000.
Yes, my lord.
But you have exhibited the document 4 lakh 70,000.
70,000. My lord, because, my lord,
So what the court, how the court can pass a decree? Contradictory document, a contradictory pleading.
yes, my lord, there has been an error, my lord. I missed that, my lord.
So can I could have been dismiss your suit, but it's the undefended suit. I don't want to dismiss your suit.
There appears to be an error, my lord, because the purchase.
So what do you want to do?
My lord, if your lordship, my lord, if your lordship
I am
permits,
keeping tomorrow. No, tomorrow commercial nahi hai na? I am fixing tomorrow. Take it.
Lord, may keep it on Friday. Lord, I appear for the defendant.
Correct. Let the
the suit is actually not undefended.
But you are not appeared on that.
no, it is, my lord. The orders are there.
On the last date, my lord, I tender my apologies. My lord, on the last date, the matter was called on, my lord, 10 minutes before.
The matter is listed as to be mentioned for clarification. Police counsel for the plaintiff press for time. Accordingly, case adjourned. Let the matter appear on आज क्या तारीख है 24 under the same heading.
Grateful, my lord. Grateful.
Yes, next.
Your Lordship, inadvertently there has been, I'm seeking leave that if liberty could be granted, that leave under clause 12 has not been pleaded. I was seeking leave if the same, Your Lordship, part cause of action has arisen within jurisdiction, para 9, page 5 of the plaint. The bank guarantee was executed in jurisdiction of Park Street, which is at page 44 onwards, Your Lordship.
So what you want?
Your Lordship, leave that.
What cause of action arose out
Your
of?
Lordship, the bank guarantees, page 44. This is, we were seeking delivery of goods from the defendant, Your Lordship. Part deliveries were made and bank guarantee was executed within the jurisdiction of this Honorable Court, which is at page 45. 44 is the bank guarantee which is executed in 15 Park Street. Page 45 is the bank guarantee which has been executed within the jurisdiction, Your Lordship.
45 in Delhi.
Your Lordship, bank guarantee was executed at Park Street, which is, Your Lordship, page 44.
44.
The Kotak Bank, Mahindra Bank is at 15 Park Street, C Block, ground floor, APJ House, Kolkata, 16, Your Lordship.
Okay.
The bank guarantees were, and the money was also received in the bank account.
Kolkata branch?
Your Lordship, Kolkata.
At Kolkata branch?
Your Lordship.
Where it is?
Your Lordship, page 48, third paragraph. We are forwarding here with bank guarantee. We confirm the signatories of the bank. Bank guarantee should be addressed to bank guarantee 15. And this is the account.
So appearing for the plaintiff. The matter is listed as under the heading presentation of the plaintiff. On the basis of the report of the London Master and Official Referee dated 15th of January 2025. Counsel for the plaintiff submit that though part cause of action arose within jurisdiction of this court and part cause of action outside the jurisdiction of this court, but inadvertently the plaintiff has not prayed for leave under clause 12 of the latest patent, either in the prayer portion or in the concise statement. Or in the concise statement. According, counsel for the plaintiff prays for leave to add the prayer in the prayer portion of the plaint as well as in the concise statement.
And writ of summons, Your Lordship, as well.
And in the writ of summons with regard to leave under clause 12 of the latest.
Sincerely obliged.
In view of the submission made by the counsel for the plaintiff, leave is granted to the plaintiff to add the prayer in the prayer portion from a concise statement and in the writ of summons for grant of leave under clause 12 of the latest patent in course of the day.
Your Lordship, in course of the day.
In course of the day, by giving the countersign in the said portion. After the
Your Lordship, the
amendment
file
carried
has
out,
to go back to the master's
after the
house for the leave.
within 3 days, sir. Within 3 days. In course of the day, within 3 days. After the amendment is carried out, let the matter appear before this court for presentation of the.
Sincerely obliged.
Isko bhej dena. Yes, next.
Please, Your Lordship. I am for the plaintiff suit for declaration for return of the bank guarantees. Plaintiff within jurisdiction. Defendant number 1 carrying on business in Chorungi Road within jurisdiction. Defendant number 2 carrying on business within jurisdiction. The bank guarantee, page 71, been given, issued from within jurisdiction of the court from Chorungi Road branch. Both the bank guarantees. My pleading is at page at page 20, para 54, if your lordships kindly have a look at that. And yes, I'm also seeking leave under 12A for the simple reason, usually we do not show judgments of this court at the time of plain presentation, but this is an unusual circumstance, as I mentioned to your lordships yesterday. Let's kindly have a look at page 214, volume 2 of the plaint. This is an order passed by my Lord Justice Shobhoshachi Bhattacharya on 19 July 2024 in a proceeding under Section 9 of the Arbitration Conciliation Act. It's a very detailed and reasoned order.
Okay.
By which, if your lordships, it will just take perhaps 3 minutes, a detailed order. If your lordships kindly have a look at this. Hmm. ইনজাংশন করা নষ্ট
Yes.
Now, this was confirmed by my Lord Justice Shompa Sarkar on 7th November 2024 at page 224. My Lord Justice Sarkar allowed a Section 11 application, appointed an arbitrator, and this confirmed this order, page 224. Now, my Lord extended it by 3 months. I'm sorry.
Yes.
Now, my Lord, what has happened? The learned arbitrator has been appointed. We had our first sitting, my Lords, on the 24th of December. My Lord, the Section 9 was to be treated as a Section 17. Now, my Lord, during the course of, my Lord, the arbitration proceedings, my Lords, my Lord, the learned arbitrator was of the opinion that, my Lords, observed, my Lord, and I think my learned friend was also present, and I was also present, that, my Lords, perhaps no order can be passed by the bank. He's facing some jurisdictional issues. So, my Lord, he said that it's advisable that you go file a suit. What I did was, my Lord, as an abundant precaution, as I told your Lordship yesterday 6 p.m. we had the third sitting of the arbitral tribunal, and my Lord, we have withdrawn the Section 17. Now, my Lords, I was enjoying this protection, my Lords, for the longest period, my Lords, from July 2024 onwards. And my Lords, that 3 months protection, my Lord, I have, my Lords, from my Lord Justice Shompa Sarkar, my Lord. But my Lord, I had to, my Lords, withdraw this because, my Lord, the learned arbitrator. So my suit is only restricted to the issue of bank guarantee.
But
so, my Lord,
how suit can maintain?
I'll tell you, Lordship, my Lord, because it's a tripartite contract. But I ideally could have come to a suit. But my Lord, now also judgments there are there, my Lord, that Section 9, I can impede the bank if I had to do that. But at the same time, I could have filed a suit because I'm only on the tripartite contract, the bank guarantee contract, which does not have an arbitration clause. So, my Lord, what has happened is I've withdrawn it and come before your Lordship, my Lord, for the suit. I have all the judgments also. But I'm just seeking leave on the 12th because of the urgency, my Lord, and my Lord, also, my Lord, under order to rule 2.
But if the arbitrator, why you have withdrawn? If the arbitrator has let
No, my Lord,
other channel.
No, so, my Lord, we did not want to lose time, my Lord. What we have done is, that's why we have disclosed the proceedings. Regarding my claim in the arbitration proceedings, my Lord, I am proceeding with that. But regarding the bank guarantee, I have expressly pleaded here, my Lord, that, my Lord, I'm just only coming and filing of the suit. Because that, my Lord, I can perhaps, my Lord, file a suit regarding that.
Yes.
At the presentation stage, I can't say anything. Now let the plaint be served.
Just one indulgence. I've served the plaint and the petition both.
Only the petition perhaps has been filed.
Well, very well. I'll serve the plaint as well. I'll do that. Well, yesterday your Lordship granted me leave, but my Lord, what has happened when I filed it online? My Lord, the department could not, due to some technical error, they said that they could not trace that e-filing. My Lord, I was just humbly praying if your Lordships can, perhaps take it up.
Problem is that
yes, my Lord.
Justice Sarkar's order already 3 months, and you can proceed with the arbitrator.
That my Lord, with the statement.
So you're proceeding
regarding my money claim. Regarding my money claim.
Correct.
Which is under the subject matter of the arbitration agreement.
Correct.
Now, my Lord, regarding the bank guarantee, my Lord, this is a tripartite contract. That does not. Your Lordships kindly will have a look at, my Lord, the bank guarantee once, my Lord. That's at page 71 of the plaint. The two bank guarantees, one at page 71, my Lords, if your Lordships kindly have a look at. This does not have an arbitration clause.
No, this does not have an arbitration clause, but it's connected with the contract.
Like this was given there under that. Now, of course, there are judgments of this court, many judgments of your Lordships as well, that when it comes to a question of bank guarantee, I can always come and file a suit because with the bank, I do not have an arbitration clause. So, what has happened is regarding, I have also taken leave. I have withdrawn the 17 with the leave. And regarding my money claim, of course, I can't come and bring it here before your Lordships. Regarding the money claim, I'll go before the tribunal. And my pleadings are also there, to that effect. I was just praying that my GA injunction application can be taken up today anytime, my lords. Because, my lord, I am ready. I have the hard copy, my lords. I have
today, my lord, not today.
No, because if
kindly
they
keeps it tomorrow or on Friday, my lord, not
if
today.
You are preparing for bank.
No, I am preparing for the different number to
You
the
are invoking
beneficiary.
the bank guarantee.
The bank guarantee is that the stay is already there. It's not that it's going to expire today. The stay is
let
there. I
them
can't
say that,
depo-
my lord, let
No,
them,
I can't
let them
say
The
that.
3 months is going to be expired.
My lords, I'll tell your lordship, let them not interpret that I've withdrawn the 17 and
No,
that the
When
stay.
the 3 months is going
My
to
lord,
be
kindly,
expired.
kindly sees, my lord, 220 for 3 months will get over, my lord, on first. Huh?
November. It is February.
That is why, my lord.
7, not 7 November, 7 November.
7 November.
28 days you have to calculate it. That's what.
November 2024.
Yes, my lord.
The interim order continue for a period of 3 months.
Yes, my lord. Yes, my lord.
3 months. So
Yes, my lord.
November, February.
Very, very well, my lord.
So
February
that-
first week, my lord, will be first, second, yes.
We have been served today morning at 5:21.
No,
I don't
he
know
didn't-
how Mr. Awasthi was awake at that time.
No,
but-
that's because he received that email at 10:30, my lords, and then, my lords, something. I have to be fair to my friend also, my lord.
Leave under clause 12. Section 12. 12A. Okay. Ordered. So appearing for the plaintiff. The plaintiff has filed the present suit for declaration that the bank guarantee is dated December 26, 2022 and July 13, 2023, furnished by the defendant number 1 on the request of the plaintiff to the defendant number 2 are required to be returned, and allied prayers including the prayer for perpetual injunction. Prayer for perpetual injunction. Police counsel for the plaintiff. The plaintiff has prayed for leave under section 12 of the 12 capital A of the Commercial Court Act, as well as leave under order 2 rule 2 of the Code of Civil Procedure. Counsel for the plaintiff submit that though the arbitration proceeding has been initiated and the plaintiff has filed an application before the London arbitrator under section 17 of the Arbitration and Conciliation Act, but the arbitrator was not inclined to take the same on record, and as such the plaintiff has withdrawn the said application and filed the present application. Police counsel for the plaintiff submit that in terms of the earlier order passed by the coordinate bench in AP Com 695/2024, wherein the interim order was extended has been given for the period of 3 months, and that is only up till 6th of February 2025. And at this stage, the plaintiff will go for the pre-mediation process, there is every chance that the mediation process will take further time, and in the meantime, the bank will invoke the bank guarantee. Defendants will invoke the bank guarantee. Police and thus, due to the said reason, the plaintiff has shown the urgency to file the present application without initiation of pre-mediation process. Also, counsel for the plaintiff further submit that though the plaintiff has filed the present suit in an urgent manner, and as such, there is every chance that further relief of compensation can arose. And as such, if the leave under 2 Rule 2 is not granted, of the CPC is not granted, the plaintiff will suffer irreparable loss and injury in future to claim further claim. In view of the submission made by the counsel for the plaintiff, peruse the pleadings, this court find that sufficient cause has been shown for non-initiation of the pre-mediation process, and there is an urgent relief is required to be, and the plaintiff has prayed for urgent relief. Thus, leave under section 12 capital A of the Commercial Court Act is granted. Commercial Court Act as well as under order 2 rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny by the department.
May I seek one humble indulgence? My GA, the application, Mr. Chaudhuri is leading me. Can I move it unlisted at 3 o'clock today? Because there is a slot. We saw
not today, not today, I'll let tomorrow on Friday.
I am fixing on Friday. You serve the copy. I will take the matter on Friday.
I just hope they do not act in the meantime.
Already there is an order.
Yes.
How can I act? I don't know. That is what I'm
I
saying.
have recorded in
Very
for
well.
leave. That's why I recorded.
Very well.
Question of
Very well.
Friday.
you Friday saw the copy
Friday.
and And mention it will be taken.
Very well. I'm so grateful. I'm so grateful.
Great.
So grateful.
अच्छा, 11 Appellate side, appellate side.
Appellate side.
One matter is appellate side, then I will take the other.
Item number 1.
We have no chance. 2 minutes.
Slow.
বাপি চলে যাবো আমরা আমাদের 1 minute 2 minute আমাদের I'm just praying for what 2 minutes from Mr. Mitro's time
Yes.
Service is effected through email this is with
That is the urgency.
Urgency is they are going to open the tender tomorrow. I'm sorry, today
itself.
What happens is, if your lordship sees, this is with respect to a ferry ghat. Kindly sees the government's notification or government's policy. It's at page 24, where a tender which is beyond 5 lakhs, it has to be done by an e-tender. Have a look at page 24.
Yes.
5 lakh and then reduced to 1 lakh. This is the government policy. I must apologize, that one document which is very important is in vernacular. I'll read it out for your lordship. Kindly do not take that amiss, because it's done in very high haste, and your lordship is aware of Bangla. I know that. You're very.
I don't know Bangla language.
But whatever is required, I'll tell your lordship. So this is the
initial it was a 50 lakhs.
5 lakhs,
No,
and then
now
it brought down to 1
initially
lakh.
it was come down to 5 lakh.
5 lakh, and then process is reduced to 1 lakh.
For interest of interning, now reduced to 1 lakh.
1 lakh.
Correct.
This is the government policy.
Correct.
Comes to the tender once at page 21. This is for that ferry ghat, your lordship.
Page 21.
21.
Yes.
This is the ferry ghat matter, your lordship knows. There is a tender process by the panchayat, where the ferry ghat is given to tenderers to use the ferry for people to use the ferry from one ghat to the other. This is floated for a sum of 36 lakhs.
36 lakhs.
36 lakhs. And there is no eater. This is a simple point, nothing beyond that. That 36 lakhs, your lordship will find at the.
This is not the translated copy.
No, it's at number 3. Panchayat Shomitir Prathomik Dakmullo Barshik 36 লক্ষ টাকা. So the translation is the Panchayat Shomiti's initial money which is involved is 36 lakhs. So you can't do it without an e-tender. This is basically they want to give it to a particular person. That's why this has been done and sent to us on email.
When it was published?
It was published on 22nd of January 2025.
What is the last date?
Today.
27.
That your lordship will find right at the first line, 21st January 2025, Dupur Acta.
Is that 21st January?
Yes, 21/1/2025.
At 3 p.m.
3 p.m. 1 p.m.
1 p.m.
Acta Shomoy Shaithia Panchayat Shomiti. So that's my urgency.
Who are the respondents?
The respondent is the Panchayat.
Who has published this?
The
executive officer.
Shaithia Panchayat Shomiti. That is number 4.
Who are you?
I am the one of the members of Bonogram Gram Panchayat.
You participated?
I am a part of the Panchayat process. I am a Panchayat itself. I myself am saying that you can't do it.
Achha, you are one of the Panchayat.
I am saying that you can't do it. So it is a government body.
So you are against your authority?
Yes. You can't do it without law. Can't do it. Because I know what is actually happening, that why he is trying to do it in this fashion. Though I can't come out with the entire thing before your lordship, but the law, what it is, that this cannot be done without a tender process. E-tender process. যখন ফাইনাল হিয়ারিং হবে তখন এখন ইন্টারিম অর্ডারের জন্য
Where is the affidavit of service?
Served on the GP by email because of the urgency, my lord. GP hand service. GP is hand service and the others, my lord, by mail.
So bring for the petitioner. The petitioner has filed the present writ application challenging the tender notice
For collection of toll tax in respect of Bolshunda Bhagwati
number
Ferryghat.
5/Santhia PS dated 2nd January 2025 5, wherein the respondent number 4 has called for a tender for
Collection of toll tax in respect of Bolshunda to Bhagwati Ferryghat.
For collection of toll tax with collection of toll tax in respect of
Bolshunda
BOLSUND Bolshunda
Bhagwati
dash
Ferryghat.
Bhagwati Bhagwati Ferryghat for a period of 1 year.
There are 5 years.
You stated 1 year. You stated 1 year. Yes.
5 years. Take your.
Yes. Yes. Take.
I'm sorry, my lord.
Take your.
Sorry, sir.
Anna.
My lord.
No problem.
No.
Sit down. It's relax.
Okay, it's okay. Sorry, my lord. Yes. My lord, in this matter, Mr. Nirotpal Chatterjee is appearing, my lord. Mr. Nirotpal Chatterjee. Lord, he is on his legs, my lord. May the matter be passed over and taken up at any point after 2 p.m. or.
That's why this code is only half an hour is given. And 1 p.m. is your tender. So if 2 p.m. your tender will be open, then what will happen?
Then, my lord, kindly fix at 12 or 12:15, my lord.
My other matters are fixed, sir. My other matter is fixed.
Let be, my lord, there be an interim order for some time and let him come back with instruction and whatever.
Not to open today. I am giving 1 week time. Till the regular court is coming and to move before the regular court. Okay. 1 year. It is 1 year, it is mentioned.
5 years.
Where it is?
Paragraph 6. And in the notice, your lordship will find at page 21.
For 5 years. Yes. With effect from 1st March 2025 till 28th of February 2030. The main contention of the petitioner challenging the impugned tender notice is that by way of a notification dated 27th of July 2022, the government of West Bengal has reduced the amount of e-tender process from 5 lakhs to 1 lakh, and the present tender process is of 36 lakhs. That is much higher than the 1 lakh. But ignoring the said notification dated 27th of July 2022, the respondent number 2022, the respondent number 4 had issued the tender, the impugned tender. Consider the submission made by the counsel for the petitioner, perused the tender notice dated 2nd January 2025 and the notification dated 27th of July 2020. From the record, it reveals that the tender notice, the impugned tender notice dated 2nd January 2025 is not the e-tender. And as per the notification dated 27 July 2022, if the tender is valued more than 1 lakh rupees, it should be a e-tender process. Thus, this court finds that the find that the petitioner has made out a prima facie case and balance of convenience and inconvenience. Full stop. In view of the above, the impugned tender notice dated 2nd January 2025 is stayed for a further period of stayed till when the circuit bench will be over.
15 days this Friday, that পরের Friday. Friday কত? Third.
Till 7th of February 2025 or until further order, whichever is earlier. Let the matter fixed before the regular bench. Full stop. The petitioner is directed to fill out the copy of the writ petition along with the documents to the defendants, respondents, and to file their affidavit of service on the returnable date.
Great.
Extremely.
I just 2 minutes of your.
I was asking you who's his real client. I was asking
I was only paying for 2 minutes of his
who's
time.
paying his fees.
No, what he has done, morning has gone to the cart and he has tagged all the boards. Until the fees will not be given, then Mr. Chatterjee will not appear.
We have worked civil court lawyers, we do ferry guard, he would do yachts.
Yeah.
Yes.
Lordship, this was that rejection of plaint on the ground of limitation, discovery of fraud. It is between two dates. Lordship,
that one.
Is that was that chart given to my lord or
which chart?
The dates for the commencement of limitation between 2 dates.
Yes, this one.
Yes. No, my lord. No, not this.
Possibly our chart.
That is possibly their chart, their datelines versus our deadline. We have given a copy. And you want... This was given, I mean, it wasn't engrossed last day, but unengrossed lordship. I'm the only one where the lordship is made in note. Otherwise, lordship had not made note, then it's fine.
No, there is no.
I'd given them also. Lordship,
yes, it is.
Well, yes. We have given the different dates when, according to them, our cause of action could arise. Cause of action and discovery of fraud are that we just take out now, Lordship, 9th January was a reminder to continue holding the goods in the warehouse.
Correct.
I am saying not started.
9th January reminder to the
9th January reminder to the defendant number 4. Don't release the goods without the original bill of lading. The original bill of lading will be surrendered at the bank against payment, and then I will get my money.
Yes.
It is against pledge of these goods that I have given this packing credit.
Yes.
Now, 18 January is a defendant number 4's reply informing that he needed a legal opinion since Vincom was going into liquidation. Vincom is the principal borrower. This is not a claim arising out of contract. This is a claim arising out of fraud. Contract, I will have a claim against Vincom, which is in liquidation. But I am now suing others who are guilty of conversion of these goods illegally. Defendant number 4 was entrusted with the goods, and defendant numbers 1, 2, 3 who was acted in connivance with defendant number 4 and the beneficiary. Then 16th February 2018 is the day when the defendant number 1 filed its suit, where they have admitted that they have taken the goods out. But this suit was served on us only, it is in serial number 9.
October 19.
October 19. Now, Lordships will see serial number 5 is what they are saying is my cause of action. And discovery of fraud was on that date. 14th March, there is a letter written by the defendant number 1 claiming money. Written to the defendant number 1 claiming money for the goods on the suspicion, that's my pleading, and the suspicion that the defendant number 1 might have taken the goods from the defendant number 4. At this stage, there was merely suspicion of fraud. And the letter specifically records this is a hearsay knowledge I have learned from the logistic provider. This letter is at page 262 of GA1.
Yes, 262.
Oh, no, I have marked one. Oh, no, just come.
So your case is that only that letter, that cause of action not arose?
Yes.
And their contention
at
is...
that time, it was suspicion stage.
Correct.
So section 17 test wouldn't be met. This is a letter Lordship will see 262, where the third paragraph, third, fourth, sixth line.
Accordance with the context and to the banks.
Sixth line of third paragraph, page 262. This is a 14th March letter. Furthermore, we had to learn from logistics service provider.
Correct.
So this was from that you have, without being in possession of the original document, already taken possession of the goods, being so and so empty of PVC.
So that's why the defendants are taking the benefit of this word. You have the knowledge, and
this is from somebody else. So this is really a hearsay knowledge. And my pleading apropos this, today we are on the demurrer stage. Or you can see paragraph 16. I was showing the plaint from the amendment application, page 55 of the amendment application, paragraph 16.
Amendment application?
GA4. GA4 is where we were showing the Lordship was seeing the plaint from, because the law is that amendment has to be.
GA4 nahi hai kya original?
GA4. Oh, Lordship, you can look at it.
Paragraph?
Page 55, paragraph 60. In these circumstances, on March 14, 2018, suspecting the defendant number 1 to have taken possession of them.
Yes.
Plaintiff right. So it was on suspicion.
Yes.
My knowledge is confirmed when I receive the plaint. After that, I lodge a police complaint, that is serial number 6. And that is the serial number 7. Defendant number 1, in reply to the letter, does not say that, yes, I have taken the goods. If you see the reply to the letter, page 267, what they have said in the plaint, I have taken the goods, they don't say that. Because they are holding onto the plaint, they are not serving me. We had received a letter and are shocked and surprised. At the very outset, we regret to inform you that although the said letter is referred to various contract numbers purportedly enclosed, no such enclosures have been there. We would further like to draw your attention to the fact that we have had no mutual contract with you. And in circumstances, we have no option but to request you to contact your Wincom. We would, however, like to inform you that the matter is sub judice. So, what they said in the plaint, specifically that they removed the goods according to them, the goods are defective, so they will not pay, they are silent. This week, so on 6th April, serial number 7 in the chart, we made the police complaint.
Yes.
16th May 2018, the police registers an FIR against all the defendants, since they were all suspected. But even if you go from 16th May 2018, but that is their internal FIR, it is within limitation. But serial number 9 is, according to me, when the knowledge of the fraud. And that, according to Mr. Charan Gupta, this has come for the first time in the plaint. That is factually incorrect, because paragraph 29 of the plaint, that is the pre-amended plaint, not before the amendment, that is mentioned there. Page 61. Page 61, paragraph 29. So this was pre-amendment. This was already on record. And amendment we just clarified that upon service of the claim, fraud was fully discovered, beyond doubt. Now I come straight away to the judgments, my lord. When it comes to fraud, when it is section 17, Lordship, remember, Lordship had seen the Limitation Act, section 17, the language.
Give the limitation.
Even in our police complaint, we didn't name all the defendant because it was on suspicion.
Yes, you pointed out on the last one. I had taken note
Section
of it.
17.
Correct. Effect of the fraud and mischief.
The suit is based. We are on 1B. The knowledge of the right or title on which a suit or application is founded is concealed by the fraud.
Correct.
Of any such person as aforesaid, and read with after D, the period of limitation shall not begin to run until the plaintiff or applicant has discovered them with reasonable diligence, or could have discovered with reasonable diligence. And on limitation, what is the interpretation? Whether the court at the demurrer stage will go by the plaintiff case as pleaded, or impute me with the discovery of fraud on an earlier date on the basis of defendant's submission. Because that is the question at the demurrer stage. The first judgment I am relying upon is the Calcutta High Court judgment of 22 Calcutta. Iman Chandra. This is All India Reporter, 1922 Calcutta. What is the copy here? Page 157. 18 is in the old act, now 17, paragraph 4.
Yes.
No, Lordship, paragraph 5. Paragraph 5. Paragraph 5. It has been conclusively established in this litigation, notwithstanding the allegation of the defendant to the contrary, that the disputed money belonged not to him but to his niece, and had been fraudulently misappropriated by him. May I come straight away to that part? I'll read that part too. Yes, Lordship, can you see paragraph 5, the third, fourth, fifth line, last one. The fraud of concealment of the true state of facts has been persevered in by him not only up to the time of the present suit, but also during its progress. The burden consequently lies heavily upon him to establish not that the plaintiff had clues and hints, which if vigorously and actively followed by him, might have perhaps led him to a complete knowledge of the fraud, but that the plaintiff had clear and definite knowledge of the fraud, knowledge of the facts of the fraud.
So that's why you're taking the section 3, section 17.
Knowledge of
the fact.
Because knowledge is when I get the
So as per your submission, knowledge, the total fact. Yes, as per your pleading, the total fact when the police has registered the case and came to know.
Police registered based the FIR.
Correct.
And also that's the FIR not available with me. When their plaint in the suit filed in 18 is served on me in October 19, there they admit that I have removed all the goods. That's when I know. Police FIR is still at the investigation stage. Though, of course, even if you go from the FIR registration date, also I am home. It is within limitation.
But as per contention, Mr. Gupta, that is also part by.
So that I will show. That is I will show if one excludes the COVID period, then that is within limitation. But the latter part, Lordship, 14th March letter was only on suspicion, and their reply throws us again off track. They say no privity of contract, so sub judice, you go and ask Vincom, throws us completely off track. Then we lodge the complaint not only against defendant number 1. We don't even know who is responsible. FIR is registered against all 4. And the charge sheet has come much later. The charge sheet? No charge sheet here. It is still under investigation.
No charge sheet is filed till date.
No. There was the closure report.
Or the closure report
was filed, which was set aside. Now they're recalling. The reinvestigation order is there. Yes. Recalling is before.
No, it's there.
For the investigation direct.
Twice.
Right. So, FIR not yet registered, and it is in that case that 10 crores had to be paid by them.
Yes.
Now, Lord, you kindly comes. Yes, what you kindly see, I should have placed paragraph 4, my junior rightly points out. Paragraph 4. Section 18 in 8. So far, Section 18 in 80, so far as it applies to the case before us, provides that where any person having a right to institute a suit has by means of fraud been kept from the knowledge of such right or of the title on which it is founded, the time limited for instituting a suit against the person guilty of the fraud shall be computed from the time when the fraud first became known to him. FIR is registered, FIR never served on him. And that too, there is only an investigation. Became first known to the person injuriously affected thereby. It may be observed that this is not precisely identical with the provisions of Section 26 of the Real Property Limitation Act, which makes time run from the date when the fraud is, or with reasonable diligence, might have been first known or discovered. This distinction was possibly not brought to the notice of the court in Bisbee Solomon, so and so. The principle is perhaps best stated in the words of Lord Chancellor Westbury in Rolfe versus Gregory. When the remedy is given on the ground of fraud, it is governed by this important principle that the right of the party defrauded is not affected by lapse of time, or generally speaking, by anything done or omitted to be done, so long as he remains without any fault of his own, in ignorance of the fraud that has been committed. This was quoted with the approval by Lord James in delivering the opinion of the Judicial Committee in Bilt Court, where he added the contention on behalf of the appellants that the statute is a bar, entitles the wrongdoer. Why did you the SCP print out? You've given the SCP print my note, but in the here you've given me the Manupatra print out. So long as it remains in ignorance of the yes, but entitled the wrongdoer to prove that he had taken active measures in order to prevent detection is opposed to or to common sense as well as to the principles of equity. To this must be added further the valuable statement by Lord Hobhouse in Bahim Boy so and so. When a man has committed a fraud and has got property thereby, it is for him to show that the person injured by his fraud and suing to recover the property has had clear and definite knowledge of those facts which constitute the fraud at a time which is too remote to allow him to bring this. The true position then is what is that where a suit is on the face of it barred, it is for the plaintiff to prove, in the first instance, circumstances which would prevent the statute from having its ordinary effect. A person who in such circumstances desires to invoke the aid of Section 18 must establish that there has been fraud and that by means of such fraud he had been kept from the knowledge of his right to sue or of the title whereon it is founded. Once this is established, the burden is shifted onto the other side to show that the plaintiff had knowledge of the transaction beyond the period of limitation. Such knowledge must be clear and definite knowledge of the facts constituting the particular fraud. As Lord Hobhouse points out it is not sufficient for the defendant to show that the plaintiff had some clues or hints which perhaps if vigorously and actively followed up might have applied. As for instance, in Nath Singla, so and so, so and so, and so. The cases most clearly in point are the decisions of so and so, 13 MWN and Lakpat so and so, where the plaintiff had, without knowledge of the defendant, recovered from a stranger money jointly payable to the plaintiff, and the defendant had concealed from the defendant and had concealed from the defendant the fact of such realization. The
And bad concealed from.
And had concealed. Can we exceed print out? So it is, I'll have to establish at trial that I could not have discovered the fraud till I got their plaint, where I got evidence. And it is not at the demurrer stage for them, or even later to say that I got a clue from suspicion I had by hearing from somebody else that the goods were removed, that I should have immediately, without knowing they have filed their suit, possibly searched all the records and taken out a plaint. Now, Lordship, the next judgment.
Mr. Mitra, how much time will take?
Take half an hour.
Further.
Now, Lordship has the time matter fixed, I know.
Mr. Gupta,
any day barring 24th.
He has made a complaint. You have made out a case from the date when he has issued the notice. That is the first knowledge. That is your case, correct? But now the judgment which
I shall show. It's only jugglery of words which is being
not jugglery. So what this court is of the view, once the FIR is lodged, that is only came to know fraud has been committed.
No. Before that, I shall show.
That you show.
I shall show. Before that, he has full knowledge. He's given full particulars. It's only jugglery of words, nothing else.
Okay.
Nothing else.
Okay. No problem.
I'll only show from plain documents, nothing else. The Lordship need not deduce anything. Plain and simple.
Suffering for the plaintiff.
Nothing.
The counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. That Friday 11:30 है क्या?
On any day barring 24th.
Any day barring
24th. Well, any day.
कब है? देखो कोई
24th मतलब taking that. But utilizing that holiday on the on 23rd मतलब 24th मतलब.
Many people will.
I know. Advocates first see the calendar.
Yes.
Friday, Saturday, Sunday, or Monday. 28.
Any day.
28 and 11:30.
Oh, but 20 is only day I'm not there. 28 and 5 apart. Any other?
31st.
31st I'm there. First half I'm there.
31st. Fix it.
This will be first half. This will be first half I am there.
So 30.
When?
No, not the Friday thereafter, because my lord, there's a fixed matter for review going on.
What
Act item 1 on Friday.
Where?
Before Justice Shobhashaji Bhattacharya. It's a fixed.
Every Friday?
No, on that Friday it is fixed. Because he only sits singly, first half only on Fridays. That's the only
29th, in case Lordship takes up 29th, 30th.
Or the week thereafter, any day.
Not because I wanted to give in this a commercial matter. No?
Yes.
This Friday you're not there.
This Friday.
Can I argue? You would like to be there?
Then come 10 and 11. 10, 10 और 11 भी fix है.
But can you keep 2 days then?
10 और 11? हाँ. Fix है. 10 and 11 February 11:30. So you will get 11:30 to 12:30, 1 hour.
I am writing.
11:30. 10 and 11 February, yeah?
Grateful. Extremely obliged.
Fix at 11:30. Item number 3 of the non-commercial.
Well, Lord, I have made my submissions completed. There is only one thing I wanted to clarify. Your Lordship last year, that just a penalty made. There is only one defendant. In the event, your Lordship I prayed for a decree for eviction against one defendant. That's the only defendant. Because privity of contract is with that defendant. Section 106 is also against defendant. Your Lordship said there are other subtenants, so what happens? You have not made them parties. My Lord, the answer is provided in Order 21, Rule 97 to Rule 101. It says,
My lord, it's
Implied.
only at the time of execution.
Implied.
If I want to throw a person out who is otherwise entitled to a different sentence, that has to be decided at the time of execution.
That's correct, but they have an authority, then they will file an order
They
21
can,
rule 97.
that they can
The
do.
right is to be decided by the court without instituted a procedure.
If I dare to execute the decree against those people,
Correct.
then they have a right to protest under that's the law, Milord.
97, then there is no separate suit is required.
No.
The court will decide.
No,
that.
I'm just wanted to my junior said, please point it out.
Okay, no.
Otherwise, yes, that. Milord, may I take your leave? There's a matter.
Yes.
Malord. चले ना चले ना
वो चलता नहीं है
चलছে working
yes
Malord, what are the submissions of the plaintiff? His principal submission is this is a lease for more than 1 year. Therefore, registration was necessary. And since there was no registration, so these documents cannot be looked into. On that, he has cited about 9 judgments. His next submission is that the defendant has accepted the rent. So, by acceptance or agreement between the parties, the rent has increased. And the enhanced rent brings it outside the purview of the West Bengal Presidency Act. And his third case is that notice is not replied. He has relied upon that 2018-6, that is.
Yes, first opportunity, you are not avail that. You are not avail the first opportunity of the giving the
First
reply.
opportunity. Of course, that will beg the question: what is meant by first opportunity? That begs the question. So these are his submissions, and was the case cited by Mr. Sarkar contrary to law? Well, that is besides the issue. I'm not dealing with that. So first, I have to see that whether these agreements require registration. Now, he has in his opening notes, if your lordship takes up the opening notes at para 9 at page, I believe 3 of the opening notes by the plaintiff.
Notes.
This is a thin paper like this. Because he has already filed a written opening submission, it's better to deal with that. At a copy.
उसमें रख दिया करो फाइल में रख दो साइटेशन करके ना
Opening submissions, yes.
Yes, opening submission.
So paragraph 9, if your lordship comes to page 3.
Yes.
Any instrument exceeding 1 year is compulsorily registrable. And he has cited 1995, volume 6, SCC 520.
Yes.
There are 2, it's not 2F, it's 2 and 8. And one judgment we have cited 1997, 3 SCC, cited by different misleadings, it relates to term 11 years or less than. That is his submission crystallized in his notes. Correct. Now let lordship can see that what is the language of section 107 of the Transfer of Property Act and Registration Act, 17(1)(d) of the Registration Act and Transfer of Property Act also. It is given. Lordship has been given Registration Act?
Yes.
Lordship. Lordship, kindly take up paragraph 17(1)(d). I'm not reading the head. The following documents shall be registered. What a D says: leases of immovable property from year to year, the yearly lease, or
for any term, Lordship can mark the word term, exceeding 1 year.
Yes.
It's not any lease exceeding 1 year, there has to be a term. Or my lord, this is in case of tenure leases or term leases.
Correct.
Monthly tenancy does not come under this.
Term lease.
Term leases.
Term exceeding 1 year.
1 year. So it's a term leases or reserving a yearly rent.
Yes.
If it's a year to year or for any term, very conveniently the word term has been excluded in the notes. So the term is the catchword, not the 1 year.
What is the term?
What is the tenure? These are applies to tenure leases. Lordship might recall, none of these leases have any term. So under 17(1)(d), these leases were not compulsorily registrable.
Yes.
Lordship. Now, Lordship, look at section 107 of the Transfer of Property Act. (107) is identical.
Yes.
5, 6, 8, 7. Leases how made?
Yes.
A lease of immovable property from year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by a registered instrument. It echoes the 17(1)(d) of the Registration Act. So a lease of immovable property from year to year, which is the in present case is not applicable. Then for any term exceeding year, these are for there has to be a term.
Correct.
And the term has to be more than 1 year. Here, none of the leases are term leases. 5 years, 6 years, 2 years, 10 years, 100 years. There's no term or reserving yearly rent. No yearly is monthly rent is very clear in the lease documents. Now, this submission made any instrument exceeding 1 year. This submission was made on the basis of 2 clauses of the agreement. My lord, may I bring my lord's kind attention. This is the agreement starts as page 95
of your application.
Of my application, my lord.
GA2.
GA2, my lord. এগুলো দিচ্ছি না যখন my lord will see paragraph page at 95 starts at page 96 paragraph 1 at the bottom of the page.
Yes.
And the last sentence of page 96, last sentence.
Yes.
Rent and service charges will be increased by 5% on expiry of every 10 years. Showing this, it was argued that therefore the lease must be more than 1 year. Must be more than 1 year, my lord. This surmise and conjecture. There is no term fixed in this lease. So, and the section very clearly says for any term, it has to be a term lease and the lease has to be more than 1 year. Only then section 107 or 17(1)(d) is applicable.
So the rent and service charges will be increased by 5% on expiry of every 10 years.
10 years.
So
If I am evicted before that, it won't be increased. It is a contingent clause.
Correct.
It doesn't make the any tenure, doesn't fix any tenure or term. It can be on every 10 years. First of all, this is illegal. I'll come to that. And secondly, it does not make it a term lease. It doesn't say after 10 years it will cease or that lease.
So as per your submission, only by saying that the rent will be increased by 5%, 10%, whatever it is,
year?
it cannot be term as it cannot be said to be a
Make
term.
this lease a tenure lease.
It cannot be said it is only for the 10 years.
It can be 20 years, 30 years. I mean, it's a monthly tenant will continue and this increase might be there is a contingent liability, my lord. My lord, this clause has been explained by Honorable Supreme Court.
Okay.
this clause, whether this makes it a term lease,
Yes.
it has been explained, my lord.
Okay.
If your lordship takes up 2020, oh, lovely. Oh, তোর জন্য copy নিয়ে এসেছি। Since it's a new case, Mr. Bose will have a right to deal with it. I'm giving a copy to my learned friend also, so that he can distinguish. This 2020, 2026 SCC, page 288, lordship straight away come to paragraph 21. It is placitum E on the right hand side, at page, I'm sorry, at page 296, paragraph 21.
Yes.
Placitum E.
It indeed.
Clause 9. Lordship got it?
Yes, clause 9.
Clause 9, which noticed the promise of the tenant of payment of rent by increasing 10% each year, was a promise contingent on tenancy being continued beyond 1 year, but cannot make the tenancy year to year or tenancy for a period of more than 1 year. Very clear, madam. I'm not reading the entirety, my lord. This is the ratio of the judgment. Okay. If there is a clause of increasing a certain percentage after a certain year,
yes,
that will not make the lease as a term lease or a tenancy for more than 1 year.
Yes.
That was the argument made, my lord. There is a direct Supreme Court contrary to that proposition of law.
Okay.
This is one. Now, they have cited one decision 1995 6 SCC 520. Lordship kindly, I think it must be in their compilation. They have filed a compilation with them.
Compilation.
What is it?
1995 volume 6.
1995 volume 6 SCC 520.
Yes.
They have cited, my lord.
Yes.
1995. Here, if your lordship takes up paragraph 7 first. Though Sri Pramod Swarup, learned counsel for the appellant, sought reliance on the judgment of this court in Anando Behar and so and so, so and so and so, they render little assistance to the facts in the present in these cases. Therein, the question was whether the right to catch fish is a lease or a license. This was a fishery license.
Correct.
In view of the language of documents in those cases, this court considered that it would be a license and not a lease. Since the document has not been placed before us, we cannot decipher whether it is a license or a lease. Since the controversy was not put in issue before the division bench, we proceeded on the premises that it is a lease. Under the circumstance, we are to consider if the division High Court is right in its conclusion that it is a lease, and being the value more than 100, upward is complete registry of 17(1) in Registration Act. Now, my learned friend cited paragraph 8.
Correct.
Under section 17 of the Registration Act, read with section 216 of the Indian Stamp Act, lease means a lease of immovable property and includes a patta, a kabuliyat, or any other undertaking writing not being a counterpart of a lease to cultivate, occupy, or pay, or deliver rent for immovable property, etc. Right to catch fish is a profit, a prendre, and benefit to arise out of land is an immovable property. So, right to catch fish is an immovable property. For the purpose of stamp duty, it would therefore be clear, since it is a right given the appellants to catch fish in the tank, it is a profit, a prendre, attached to or benefit to arise out of the land. Therefore, it is an instrument for the purpose of stamp duty. Now, since, Ashokali mark this word, duration of the lease is a term or duration which is important.
Correct.
since the duration of the lease in LPA, there are two matters. LPA number 21 of 1994 is only 9 months. It is not a compulsory registrable instrument in operation of section 17(1)(c) of the Act. The civil appeal arising LPA number 20 of 1994 relating to Santosh Jaiswal is therefore partly allowed. It is an instrument which requires to bear appropriate stamp duty but is not a compulsorily registrable instrument. Now, in appeal arising out of LPA number 22 of 1994 of Surendra Shukla, since again the duration of lease is more than a year, it is an instrument and compulsory registrable by operation 17(1)(c) of the Registration Act, liable to stamp under the Indian Stamp Act. They acted up unless duly engrossed with stamp duty and register. So it is a duration which is important. It is 2 years. This was released for 2 years.
Yes.
The other one, Lordship, give me a minute. Lordship, come to paragraph 2. These appeals by, I'm sorry, facts of the case, my lord.
Yes.
These appeals were specially arising from the judgment dated Swan's division of the High Court of Madhya Pradesh instead of Swan. So, the two matters, the question canvassed before the division was whether the right to catch fish in the tank granted in favor of applicants was in the nature of a lease or license, an instrument compulsory registrable on the Indian Registration Act, liable to stamp duty on the Stamp Act. The division bench held that there were leases in respect of Santosh Jaiswal case for a period of 9 months and Surendra Shukla case for more than 1 year. It in the counter affidavit filed by it was stated the lease was for more than 2 years. So it was a 2-year lease. So the term was there.
Duration is there.
Duration is there.
Yes.
In my lease, my lord, Lordship, I have placed in the beginning, my lord, it is not a duration. There is no duration. It's not a term lease.
Correct.
So this case cited by the plaintiff is of no use, or rather helps my case.
Yes.
Because duration, the main catch word is the term or duration.
Yes.
Now, I have cited a case 1997 in the notes. It says the 97(3) SCC cited different is misleading. It relates to term of 11 years or less than that. My lord, it's not a correct statement. My lord, the fact it is different. Now, Lordship comes back to 1997(3). SCC 679. I have cited well. আমার কেসগুলো দেবেন দেওয়া আছে মানে subject to my lord's convenience, may I take back this, make a index and make a compilation?
That will be better.
My lord.
1997
volume 3 SCC 681. I'm sorry, 679.
Yes.
679. If your lordship takes up paragraph 4 first.
Yes.
4 is not relevant. 7. Paragraph 7. The question therefore, the question therefore that arises whether a lease of immovable property from month to month, Lordship will mark the word, for month to month,
for 11 months.
Or 11 months. They cover both the situations. Month to month
or 11
months. Is a compulsory registrable document.
Correct.
Though it was reduced to writing as an instrument defined under section 214 of the Stamp Act. So somebody say you simply induct a tenant, deliver possession, there's a tenancy is created. There's month-to-month tenancy. But if a document is created, what will happen? Here is a case where is a month-to-month or for 11 months and reduced into writing, and it is an instrument. A conjoined reading of the first part of section 107, I have placed just now, read with section 71D of the Registration Act as extracted here before, does indicate that a lease of immovable property from year to year or for any term again exceeding 1 year or reserving an yearly rent should be made by registered instrument. All other instruments, though reduced to writing and possession is delivered thereunder, are not compulsorily registrable instruments. It is a residual clause. All others are not registrable except these three situations: tenure lease, year to year, and yearly rent.
Year to year, or for any term exceeding 1 year.
1 year.
Or reserving any
So
yearly
this
rent.
judgment I have cited includes month to month or 11 months both.
Correct.
And in such situation at paragraph 8, my lord, it was held as follows.
No document requires termination. Yes.
The paragraph 9, if lordship looks at.
Yes.
The proviso is not applicable in the facts of this case, and therefore it is not necessary to look into the exceptions engrafted vis-a-vis receipt of a document comprising of 3 circumstances mentioned there, namely, unregistered document used for enforcement of specific performance under the Special Relief Act, or used as evidence of part performance of the contract under Section 53A of the Transfer Property Act, or using evidence for collateral transactions. The combined effect of all the provisions is that an unregistered lease deed executed from month to month, logically word the word month to month, because their case is this is not applicable because here it was a lease for less than for 11 months, less than a year. But here Supreme Court has dealt with both the situations, month to month, for a period not exceeding 11 months, though reduced to writing and possession is delivered thereunder to a tenant, is not a compulsorily registrable instrument, and therefore the prohibition contained Section 49 of the Registration Act is inapplicable. Therefore, the document is admissible evidence to consider the effect of immovable property contained therein, to receive as an evidence of any transaction vis-a-vis such property. So, it includes both the situation, and this applicable. This opening note says it is misleading since it relates to term of 11 months or less than that is not a correct submission. This is contrary to this judgment, because the judgment covers both the situations, month to month and less than 11 months.
Correct.
So, my lordship, these are the main branch of argument of the plaintiff, that it is more than 1 year. I have shown that the clause enhancement of rent, Supreme Court says that doesn't make it a lease for more than, it's a contingent. It's a contingent clause. If he is in possession, if the tenancy continues, then the rent will increase. Correct. It doesn't make it a tenure lease. And then agreement I have shown that the similar clause 70D 107 both says duration or term. Here there is no term, and this submission is also little misleading. That any instrument, paragraph 9, exceeding 1 year, that is not the law. The law says for any term exceeding 1 year. So it must be a term lease, like 5 years, 10 years, 30 years.
Taken note, term lease.
Right. So this is the main. Now there are 9 cases submitted on this, that if it is not registered, it cannot be looked into.
Correct.
Individually, I can deal them. I'll deal it later, my lord, after I conclude the main submissions. Let me summarize the main branch. Let me, as they call it, catch the bull by the horn. So, of course, Mr. Bose nowhere resembles a bull. I remember, my lord,
So
in one matter.
It is a bull.
That's said. I remember in one matter, Mr. Siddhartha Shankar Ray, as he was there, he was leading me. Other side was Mr. Somnath Chatterjee. And Mr. Ray stood up and said, my lord, he has argued this, let me catch bull by the horn. Somehow I know he was absent-minded or some other way disturbed. Mr. Somnath Chatterjee took exception. I am not a bull. And the court came down from there.
Cold
I'm adjourning it. Please, you are two senior members of the bar. Please, you settle between yourself. Then he invited both of them to his chamber, had a coffee. So these words are sometimes very tricky, my lord. So the first limb or the principal limb of submission of the plaintiff, that this is a registrable document, that is not, that submission has no sanction of law. The law is otherwise.
Correct.
And factually, this is not a term lease. This is the first submission, madam. There is one, but 2006 dibi. There is one more thing, my lord. 2006 na? 6 to. Para 7 na? Sorry, it's not now. This is not. No, this is not now. Now the next point, the defendant accepted increase of rent. Because a rent can be either fixed by the rent control or the parties by agreement can fix it. Now, Lordship might recall that I started my submissions with a letter dated 24th of July 2019, which is at page 107. Lordship, come to page 107. Straight away. Possibly the last page of the my application. Application
J2 कहाँ गया?
Application दिन तो बार को दिन तो
J2. Yes. 107.
107, my lord. The last page possibly.
Yes.
And before that, let me summarize his submission. He says that I have raised bills for 7 lakhs and odd, and you have paid exactly the same amount. So you have accepted it.
Correct.
1. 2, you have paid TDS amount month to month on that enhanced rent. So you have also accepted
the
rent. Now that Bombay decision on TDS was sought to be distinguished, saying that was a order 37 suit. Well, I am not on that. What is the ratio there? Ratio is a payment of TDS like an advance tax. It cannot be accepted as an acceptance. It cannot be said to be an acceptance or an acknowledgement of the debt. That was the ratio. Not a single decision has been cited where payment of TDS has been taken as an acceptance.
Okay.
No. And this case has been very bypassed, not dealt with. Bypassing is order 37. Well, it may be order 37 in a normal suit. It can be a commercial suit. But the ratio is payment of tax deducted at source cannot be taken as an acknowledgement of debt or an acceptance. That has not been distinguished. So, Lordship, kindly look at this document first at page 107.
Yes, I am there only.
I paid that 7 lakhs and not exact figure. Now,
Correct.
This, my lord, was never referred to by plaintiff in his submissions. Very conveniently omitted to mention even. This we are writing to the plaintiff, defendant writing to plaintiff. Respected Sri Sandeep Ji, this with reference to your August 2017 rent increment, because in August they have sent a letter increase the rent. Premises number so and so, when you requested for a conversation with you for the same, we were informed by your representative that we should make the due payment as per your bills first, and the meeting can be held post it. Pausing here for a moment. What does it mean? I'm accepting it.
Correct, because you have made the submission on the last occasion.
Yes,
This
my
is
lord.
only with regard to
It
your
is like a deposit. He said,
deposit,
I will not discuss
subject to
with you
acceptance.
even if, unless you pay this amount. I say, very well, I paid this amount. Let's have a discussion. And that discussion never held. So there was no acceptance. Never any acceptance. So we initiated the payment in October. Why you have paid? He explained, my lord. And it's not a lawyer's letter. We should, Lord, you can see. Payment October 18 as per the bills provided, fully paid as on the date. We say so. We have been requesting a representative since then to schedule a meeting, but in vain. So it was paid as a precondition to hold a discussion. And discussion never held. As requested by representative to pre-inform the purpose of the meeting, I would like to share the same. I look forward to discuss the increment and rent since August 2017.
Correct.
And also voice a few words shared with your between your father, the Birendraji, and myself. So, Lordship, they are known to each other. He had a talk with his father of the
subject to discussion.
Subject to discussion, and there was no agreement. So rent did not increase. Rent remained at rupees 3,000 and rupees 2,150. Statutory.
Yes.
So, my lord, this letter very clearly shows, which was very conveniently not even mentioned in the submissions of the plaintiff and doesn't appear in the opening submissions either, that we have paid this amount, the exact amount, as their instance to hold a discussion only. And the discussion was never held. So the amount remained undecided. No increment has been finalized between the parties. So that is why I say in opening submission, they ought to have approached under section 21 rent controller. That they have not done. So the rent remains 3,000 and 2,150 only.
Yes. What is the rent? 3,000?
3,000 and 2,150.
Acha.
There are two separate agreements. There are two rents.
Yes. Yes.
So that 7 lakhs exact figure paid at their pressure to hold a discussion. And that discussion never held. So there was no acceptance. Next, I have paid month to month.
So as per your submission, the 7 lakh which has been paid, that cannot be treated as a rent.
And I have clearly said I have paid since your man
Only
insisted.
you have paid till the finalization of the discussion.
It is
Unless
a deposit.
And that has not been finalized, so it cannot be said that it is a rent. Has been
There is an agreement between them. It doesn't show there is an agreement between the parties. Not a single document shown there is an agreement between the parties on enhancement of rent.
Correct.
One. Regarding TDS, Lordship, at the cost of repetition, may I bring that 2008 Bombay, my lord. 2008 Bombay, my lord.
Yes.
Yes, Lordship. Paragraph 6, Lordship, may I place, my lord. However, the learned counsel appearing for the respondent argued that no such ground has been raised in the application for leave to defend. And as such, the appellant was stopped from raising this issue before the court. The suit as framed would be maintainable under Order 37 of the Code as the TDS certificate is even an acknowledgement and reflects a written contract between the parties. The exact same submission, what was being made here. It may be a Order 37 suit, it can be a commercial suit, non-commercial suit. That is not the ratio. Ratio is whether a TDS certificate is an acknowledgement or reflects a written contract between the parties. Through that, this our court, the Bombay Division Bench, my lord, Justice Swatantra Kumar, our ex-Chief Justice, as his lordship then was, at paragraph 8, bottom of the page, lordship, you can see the issuance. The issuance of tax deducted at source certificates does not amount to an acknowledgement of defendant within the meaning of section 25 of the Indian Evidence Act, and the full bench judgment of this court in the case of Jyotsna puts the matter beyond doubt.
Yes.
So TDS, payment of TDS
Does not amount to an acknowledgement of the
acknowledgement
defendant within the meaning of section 20.
of the evidence.
Yes.
And TDS certificate is primarily to acknowledge the deduction of tax at source.
Yes.
The certificate does not refer to any amount of loan or even the rate of interest, which is payable on the said principal amount. It does not refer to any contract between the parties, even a transaction. TDS does not refer to any contract. For agreement to the higher rent, there has to be a contract. TDS is not a contract. So, well, two limbs.
So the court is of the view that TDS with regard to the party can save the tax to
fine penalty.
Fine
penalty can be saved.
Correct.
If he doesn't pay,
then the penalty will.
Because tomorrow, suppose they have asked for 30,000, we agree to 20,000. Then I have to pay the arrear tax. Then arrear tax, I have to pay fine penalty because already 5 years gone. Fine penalty, I have saved that.
Yes.
As advised by income tax consultant, we have saved that fine and penalty. And that amount also is like a deposit lying to their account.
Correct.
So two limbs on acceptance. One is I have paid the exact amount that is nullified by this document of 24th July 2019.
Yes.
And second, their case is TDS, is a contract, is an acknowledgement. And there is a division bench of Bombay High Court says that TDS is not a contract, is not an acknowledgement. So there was the
it cannot be said that the TDS can be treated as an agreement.
As an acknowledgement. So therefore, the submission that I have accepted the increase of rent has no legs to stand on.
Yes.
That goes. Now, my lord, I have relied on section, Lordship takes up kindly the Westmoreland Premises Tenancy Act. Section 13 first, my lord. No, I'm sorry.
Yes.
No tenant shall, notwithstanding any agreement to the contrary. So there can be agreement to the contrary.
Correct.
My lord. So the parties can by agreement fix a fair rent. Be liable to pay to the landlord for the occupation of premises any amount in excess of fair rent of the premises unless such amount is lawful increase of the fair rent in accordance with the provision of this act. So what is the provision of this act? Now she come to page 17, paragraph section 17.
Fixation of fair rent.
Well, fixation of fair rent.
Correct.
The controller shall, on application made to him, either by the landlord or the tenant in the prescribed manner, fix the fair rent in respect of any in accordance with the provisions of this act.
Correct.
So it can be by agreement between the parties, where I have shown there was no agreement, or it can be fixed by the controller, which they have not applied. So my rent has not increased. It continues to be till today, 3,000 and 2,150.
Yeah.
And Lordship kindly also sees section 18.
Section 16.
18, my lord.
Yes.
The fair rent, I'm sorry.
Yes.
The fair rent initially fixed shall be automatically increased by 5% every 3 years. That is the permissible under the law. Here they want to increase by 5 times.
%5 every 3 years.
3 years.
So if you go with the rent controller also, that cannot be.
They cannot.
Unless.
And what they have increased, Lordship, can you look at their letter of increase of rent at 1st August, 2 letters, page 37.
Yes.
You are a monthly tenant under us in respect of tenanted space, paying monthly rent of 3,000
and service charges.
Rupees 0. No service charge, only rent 3,000.
Correct.
Your tenancy is covered by the West Bengal Premises Tenancy Act 1997. It's an admission. It's admission. As amended with Act 97, amended by so and so. In terms of the provisions of in terms of the said act, you are liable to pay the enhanced rent. Under which provision, my lord? Service charges, rent 18,000. From 3,000 to 18,000. 6 times. That's not permissible under section 18.
Yes. Yes.
So this letter itself was illegal. Illegal. And the next page, Lordship, takes page 38, Lordship.
Yes.
You are a monthly tenant.
Same.
Under us 2,150, service charge 1,000, that's 3,150 total. It will increase to 12,900.
2,115, 12,009. Yes.
I mean, unilaterally they cannot. Here, my lord, we have relied upon a decision of Justice Bhaskar Bhattacharya, 2006 SEC Online, Calcutta. (417).
Yes.
Here, what has happened here, the landlord had filed a writ petition.
Yes.
Directing that let the respondent reconsider and increase rent. So from 5 rupees, they increased to 6 rupees. Then again, second time came, say that 6 rupees is unreasonable. You ask him to refix again. The learned single judge said, you set aside, you reconsider. Against that, the appeal was made. In the appeal, my lord, landlord took a point that except rent controller, I mean the head of the department of the defendant there or respondent there, cannot even consider increase of rent, because either agreement, there is no agreement, so it has to be only through rent controller. Now, this judgment was sought to be distinguished that it is a writ petition. Well, it's true, but what the court held is
question, point of view.
The ratio was that whether a civil court or a writ court. I'll come to that portion. Lordship, can we come to paragraph issue 17, 16? No. Right. Paragraph 16, Lordship, can you see? Yes. The question, so sorry. I'm so sorry, my apologies.
No.
Sorry. Paragraph 16. The question is whether a writ court can permit a landlord to enforce a void contract simply because the tenant is a state with the meaning of Article 12 Constitution. If this part, my logically mark this word, if by a regular suit, the same cannot be done by taking recourse to Article 226 Constitution, the same relief cannot be achieved simply because the defendant happened to be a state. For a writ court, direct the state to comply with a void agreement.
Yes.
So, whether it can be done by regular suit, forget about a suit, about a writ court.
Writ court, yes.
Now, paragraph 18, Lordship comes. Or Lordship comes to paragraph 21.
Yes.
Moreover, in the matter of creation of tenancy, as well as the terms of enhancement of rent, according to the provisions contained in the Transfer Property Act, the agreement must be a bilateral one. And as pointed out earlier, once a tenancy is continuing under the provisions of the West Bengal Premises Tenancy Act, in case of further change of rate of rent, the parties are required to approach the controller, and even civil court's jurisdiction is excluded. That is the ratio, my lord. May I please, my lord?
Further
In the
change.
case of the agreement must be a bilateral one.
Correct.
And as pointed out earlier, once a tenancy is continuing under the provision of West Bengal Premises Tenancy Act, in case of further change of rate of rent, the parties are required to approach the controller, and even civil court's jurisdiction is excluded.
Correct.
This is the ratio, my lord.
Yes.
In such situation, in our view, the learned single judge erred in directing the zonal manager of the appellant to force the appellant to agree to pay rent according to determination. So that is the factual part. Logically leave apart. The ratio is that if he is a tenant on the West Bengal Premises Tenancy Act, which they admit in their letter of 1st August, both the letters they say that you are a tenant under West Bengal Premises Tenancy Act.
Yes.
Act. So further change of rent by the party are required to approach the controller. There is section 17.
Correct.
And even civil court's jurisdiction is excluded. That is the ratio. This point has not dealt with. It simply has said, my lord, it is a judgment in a writ proceeding, so not applicable.
Correct.
But that's not the ratio. Writ, the finding is not relating to writ only.
Yes.
So, my lord, it is very clear that it can be bilateral. Here, there is no agreement or acceptance of rent on the part of the defendant, and their only remedy was to approach the rent controller
for fixation of the
fixation, which they have not done. And this case is squarely applicable in our case, the ratio, as in held in paragraph 21.
Yes.
Now, and paragraph 18 and 19 also, my lord, I'm repeating, I have already placed.
That already placed, I have
placed,
taken
my
note
lord,
of it.
my lord, I'm not
I have taken note.
But 21 is a ratio.
That is a ratio.
Ratio.
18, 19, the facts has been decided.
Factual parts.
Next.
My lord, next point, my lord, they have said that I have given 3 notices. I have given eviction notice. He has not replied to any of the notices. So they are waived from taking any point now. My lord, the first blush, the argument appears to be very catchy. Well, then I went through the judgment of apologizers. Lordship may kindly come to the judgment. 2018, 6 SCC 744, it must be in their compilation. Serial number compilation bolto. It is, I think, 5, serial number 5. No,
2.
Serial number 2, apologizers.
Page 3 to 19.
Yes. No, apologizers Calcutta case is there. I want the Supreme Court. Supreme Court is page 20. This is a decision cited in 2018 6 SCC 744, and they have relied on paragraph 54. Lordship, paragraph 54 has been relied on by the plaintiff.
Of the Calcutta,
No, of the Supreme Court.
Supreme Court judgment. And that is appearing at page?
Page 2020. Running page, I'm sorry. Yes. At paragraph page.
Paragraph 54.
Paragraph 54. This court held. Lordship got it? Paragraph 54.
Yes.
This court held that if the defendant does not raise any objection to the validity of the quit notice, Lordship can mark the words, at the first available opportunity. Lordship can mark that word. First available opportunity. The objection will be deemed to have been waived. So that begs the question, what is first available opportunity? I'll come to that. But what this judgment says, let us see that. They have relied upon an earlier judgment of Parvati Bai, which paragraph 6 of Parvati Bai is quoted here.
Yes.
This singular question to be examined in the present case is whether the tenancy was terminated in accordance with the provisions of section 106 of the Transfer of Property Act. The receipt of notice of the defendant is admitted in the written statement. Mark the written statement. The defendant has not raised any specific objection as to validity of notice. Where? In the written statement. They have not raised any specific objection as to valid notice in the written statement. So they are admitted the notice, receipt of notice is admitted. An objection as to invalidity or infirmity of notice under section 106 TP Act should be raised specifically at the earliest. Else it will be deemed to have been waived even if there exists one. So therefore we said that the notice in the present case suffered from an infirmity. That was the case. So here written statement filed.
No plea has been taken.
And no objection was taken in the written statement that notice is bad.
Correct.
Now, two questions I find here, that what is meant by first available opportunity. Lordship, can you...
How much time will take, Mr. Saka?
My lord, another 10 minutes. Or Lordship keeps next.
I am keeping next.
Or may finish this.
Yes, you finish it then. You finish the first available opportunity.
This is 2011, volume 11. Volume 11. Hey, copy language. 2011, paragraph 26, my lord, only one paragraph is sufficient. At page 682.
Yes, got it. Yes.
In view of the above legal position, we shall now advert to the facts of the present case. The tenant, at the first available opportunity, same words, well, the phrase is used, that is, in his written statement. So, first available opportunity means written statement. Here, my lord, we have merely made an application for extension of written statement. We will take all the points in my written statement. Filed on so-and-so, about the paying rent, so-and-so, so-and-so, so-and-so. So, this is only for explanation of the term first available opportunity. First available opportunity, as in Apollo Jeepers or any other case, means the written statement.
You have to deal with that.
I have to deal with it. If I don't take a point,
the plaintiff is taking the plea with regard to the 106, so you are the first opportunity to deal in the written statement.
Written statement.
It is not that you are not given the reply to that.
Right.
So that
Lordship. That submission was not in accordance with law.
Got you.
Lordship. Well, I come back.
Thanks. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. The senior advocate appearing for the defendant is argued at length, but due to paucity of time, hearing could not be completed. According cases adjourned, let the matter appear on. 11:30 का भी खा लिया 6th February. 6th February at 11:30. 6th February, 11:30.
I'm deeply obliged, man.
Number 20 of the non-commercial. 28 of the non-commercial.
My lord, this is my application.
Just a minute. हिस्ट्री का क्या है कुछ बोल ही नहीं क्या हो जाता लेकिन भेज देना है देख कॉपी लेट सेट हो जाएगा टेस्टामेंट्री yes 28
Yes,
you are
my lord.
appearing
This is my
yes
non-contentious business, my lord.
huh
Non-contentious matter.
and contentious cause all formality is completed
Yes, my lord.
where is the will
Will is at annexure C, my lord.
the probate or letter submission
Probate, my lord. Probate.
where is the will
At annexure C, my lord.
next is C I could not find the will here. Yes. In the white paper?
Yes, my lord.
Yes. What is the date of the will? 5th March 2022.
Yes.
What is the name of the testator? Testator, testatrix?
Testator, my lord.
Testator, Robin Javeri.
Robin Javeri.
Robin Javeri. Yes. Dated 5th March.
Yes, my lord.
Where is the name of the testator, executor?
The next page at the bottom, executor, it's a heading. Mrs. Smita Javeri, the wife of the deceased, my lord.
Smita R. Javeri.
Yes.
Smita R. Javeri as executor of my last will to do all such necessary termination. In her absence, inability, I appoint Mr. Yes. So who is the petitioner herein?
Smita R. Javeri, my lord.
She herself filed.
Yes, my lord.
Smita R. Javeri. Yes. When he died?
He was died on.
Robin Kunsen Javeri died on 4/4/2022.
4th April 2022, my lord.
Yes. Where is the legal heirs details? Mita is the
At
wife.
page 3, my lord.
Mita is the wife. She is the petitioner herein.
And 2 daughters.
2 daughters. They have given consent.
Yes, my lord.
Where is the consent?
Consent is at, there's no page. Annexure D, my lord.
Amrinta
Arminta Robin Javeri and Alisha
Alisha Shah.
2 daughters.
Yes. No objection. Then who is the attesting witness?
2 of them at the very last, my lord. Ashley Ripul Javeri and Hanish Haresh Choksi.
Choksi. Both have given affidavit. Or
Yes, my lord.
Both
at the very last annexure.
Harsley People Javeri and Hanish Choksi. Both have given.
Both.
So and so appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 5th of March 2022 of the testator Robin K. Javeri. The testator died on 4th April 2022, leaving behind his wife and 2 daughters. The petitioner says that the testator has executed his last will and testament by appointing his wife as executrix of his last will, and in her absence, his brother, Mr. Ripul K. Javeri. The present application is filed by the first executrix, that is the wife of the testator. Counsel for the petitioner submit that the wife is the petitioner in the present case, and two daughters of the testator have filed their affidavit stating that they have no objection for grant of probate to the petitioner in terms of the will. Petitioner further submit that the two attesting witnesses of the will have also filed their affidavit stating that the testator has executed his last will and testament by appointing the petitioner as executrix while possessing good health and fit state of mind. Counsel for the petitioner submitted as the petitioner has proved the will and is entitled to get the probate. Had the learned counsel for the petitioner peruse the original will, comma, death certificate of the testator, comma, affidavit of the legal heirs, that is the daughters of the testator, and affidavit of two attesting witnesses. Considering the above, this court finds that both the daughters have filed their affidavit of consent stating that they have no objection for grant of probate. The attesting witnesses in their affidavit have categorically stated that the will was executed by the testator in their presence while possessing good health and fit state of mind by appointing the petitioner as executrix. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioner of the will dated 5th March 2022 upon compliance of all formalities. At the time of grant of probate, copy of the will be made as part of the probate. PLA 256 of 2023 disposed. Next.
29.
None appears on behalf of the petitioner. No accommodation is sought for. Let the matter go out of the list. Next.
30 minute.
None appears for the petitioner. No accommodation is sought for. Let the matter go out of the list. Yes.
But item 30 malad appear for the petitioner. The probate proceeding which has been transferred to testamentary suit.
Is that testamentary?
Yes, it is now a testamentary suit. But the issues are required to be framed by the Honorable. Good malad, I am carrying a suggested issues. I have covered the defendant's issues also.
All inspection completed.
They have no document disclosed by them.
This is with regard to will, my lord.
Nothing.
That
So I am recording that. You will not disclosing any further document. I am.
Let me take instruction, my lord. But for further documents, my lord, if it is required, my lord.
What document? Fix a date for witness action for me, and in the meantime, what?
Yes, my lord.
For me, there is no document. There's the attesting witness.
What is your stand?
I am opposing, my lord.
What is your ground for opposing?
Opposing, my lord.
Medical ground, not a fit state of mind.
Yes, my lord. The testatrix, my lord, at that time, my lord, was not of sound mind, my lord.
Correct. That is the thing.
My lord. That is the thing, not a sound mind.
So you are having any medical document? You rely on
that medical document. Whether
you're relying upon anything?
My lord, right
not
now,
disclosed.
I don't have anything, my lord.
I've covered to the extent that issue number 3 and 5, I think, is the defendants.
Can I have a?
Sure.
Yes.
There's a
Issue
mistake.
3.
There's a mistake that I've corrected. Pardon me for that.
No, my lord, this, my lord.
Yes, issue 3 is there.
Issue
3. 3, 5, and 6 is their issues. Practically, I have incorporated them also.
This is with regard to, my lord, undivided property, ancestral property of my mother, my lord, of our mother. So, my lord, that was undivided, and my lord, no development agreement took place, my lord. Before that, my lord, how she can be given? So, these are the.
To take the
testamentary. It's testamentary. Yeah.
So applying for the
testamentary.
plaintiff, applying for the defendant. The plaintiff has filed the suggested issues. Full stop. Counsel for the defendant submitted that she has not disclosed any document and if one opportunity is given to the defendant, comma, if required, comma, the document and the defendant will disclose the document to the plaintiff for inspection. Considering the submission made by the counsel for the plaintiff, this court is of the view that only for the disclosing of the document the suit cannot be adjourned at this stage. Accordingly, the following issues are framed. Yes, sir. 1, 2, 3, 4, 5, 6, 7, 8. Let the matter appear. You will adduce
Yes,
witness?
yes,
Let the matter appear on. Give that. 13th of March at 3 p.m.
3 p.m.
for witness action of the plaintiff. Full stop. It is made clear that in the meantime, if the defendant intend to disclose any document which the defendant relied upon, comma, the defendant shall disclose the said document to the plaintiff within 2 weeks from date. 2 weeks from date, and if the document is disclosed by the defendant, comma, the plaintiff shall inspect the document within a week thereafter.
Well, liberty be given to me depending on their document what they come in the event.
Full stop. After going to the document, if any disclosed by the defendant, comma, the plaintiff is at liberty to disclose any further document, if any, to the defendant within a week thereafter, and the defendant is at liberty to inspect the said document within a week thereafter. Within a week after the disclosure of the said document. Full stop. Both the parties shall file their affidavit of documents if required, if any, at on or before 13 March.
The date is the holy weekend. 13th, 14th, 15th. This
on or before,
session break
on
also
or
for the
before
sun.
8th of March, on or
Whatever.
before
এটা অন্য ডেট করে দাও
10th of March,
Whatever.
10th of March
10th, yes.
2025. List the matter on 19th, 17th March 2025
17th.
at 2 p.m.
Mile.
At 2 p.m. for witness action.
Deeply. 17 তারিখ 2 p.m.
Next.
Oblige.
Number 31.
Yes.
Your say,
You're appearing?
Yes, sir. I am appearing on behalf of the executor.
Caveat.
Pursuant to your lordship last order dated 13 December 2024, the department had issued the testamentary number. I am praying for direction of discovery and inspection.
You are appearing for
the caveator.
Caveatrix. Caveator or caveatrix?
Caveator.
Record. So appearing for the plaintiff, so appearing for the defendant. Full stop. The parties are directed to complete the discovery and inspection of the document within 2 weeks.
Lordship, the advocate and record is unwell. Kindly grant a long.
Within 3 weeks from date. Full stop. Affidavit of document be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. List the matter on 24th of February 2025 for framing of issues. Next.
My lord, in item 32, my lord, I am for the petitioner for the grant of probate. My lord, the deceased.
Formalities completed. All formalities
All
completed.
formalities. It is a non-contentious matter, my lord. The deceased died on
Jayanta
23rd.
Mittar.
Yes.
Where is the will, sir?
Will of 20th of December 2023.
20 December 2013.
Yes.
2013.
20th December 2013.
13.
That is the date of will.
Name of
lord,
the name of the executor.
Name of the executor is Shushmita Mitra, who is the petitioner before your lordship. And she was the only sole executor.
Where it is? Where it is mentioned in the will?
Page 3 of the internal page 3 of the will, my lord. Para 5.
Correct. Yes. When she died?
My lord, he died on his the wife is the sole executrix.
When he died, testator?
On 2nd of November 2023.
2020.
Death certificate is Anith, my lord.
Yes.
He died at Baliganj
And
at
where is the
Calcutta.
where is the
And
legal heirs?
Wife, one son and one daughter. My lord, son and daughter, Jayashil Mitro and Srimati Mitro, son and daughter, they have given their consent in writing.
Joshil Mitto.
Yes.
I am giving consent. Another is
Another is
Srimati Mitto.
Srimati Mitro.
Consent. Yes. Then
My lord, attesting witness was Devobroto Banerjee. He affirmed an affidavit stating that he was the
Devabhrata Banerjee.
Devobroto Banerjee.
Attesting witness present and put the signature. Yes.
The deceased was having the bank account within the jurisdiction and immovable property outside the jurisdiction near Baliganj. My lord, I have filed the application for grant of probate.
Consent appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 20 December 2013 of the testator Jayanta Jayanta Mittar Mittar. Counsel for the petitioner submit that the testator has executed his last will and testament by appointing the petitioner, who is the wife of the testator, as sole executor of his last will in presence of two attesting witnesses. Full stop. Counsel for the petitioner submit that the testator died on 2nd November 2023, leaving behind his wife, who is the petitioner before this court, and one son and one daughter. Full stop. Both the legal heirs have filed their affidavit of consent, stating that they have no objection for grant of probate of the will to the petitioner. The attesting witness, namely Debabrata Banerjee, has also filed the affidavit stating that the testator has executed his last will and testament in his presence while possessing good health and fit state of mind by appointing the petitioner as sole executrix of the said will. Counsel for the petitioner submit that the petitioner has proved the will and is entitled to get the probate. At the learned counsel for the petitioner peruse the original will, death certificate of the testator, affidavit of consent of both the legal heirs, affidavit of the attesting witness. Both the legal heirs have categorically stated in their affidavit that they have no objection for grant of probate. The attesting witness in his affidavit has stated that the testator has executed his last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executrix of his last will and testament. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate of the last will and testament dated 20 December 2013 on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA number so and so is disposed of.
Lodge.
Item number 33.
I'm appearing for the petitioner, Lordship. This is an application for grant of letters of administration in the goods of Anuradha De Kolochia. She passed away.
With will or without will?
This is without will. She died intestate. She passed away on the 23rd of October 2021.
Anuradha
De Kolochia.
Yeah.
She passed away on 23rd of October 2021, leaving
3rd of
behind
October?
2021. Yeah.
Where is the death certificate?
It has been annexed as Annexure A.
Page number?
This is 7, I think. Yes, 7, page 7.
Where is the death certificate, madam? I did not find any death certificate.
Your Lordship.
Annexure A.
Yes, Annexure A.
Date? Where is the date?
It is in Italian, so we have also annexed the translated.
Copy. Where is the
Yes,
translated copy?
Your Lordship. Right after the annexure A, we have annexed this page where the translated words have been put down. And we had separately submitted a copy to the department where the translated version of the will was given.
Country Italia. Roma. Date of death 23rd October 2021.
21.
Yes. So leaving behind how many legal heirs?
2 legal heirs, the husband and 1 daughter.
Where do you mention? Which paragraph you mention, madam? Husband
Yes.
and daughter.
Yes. Paragraph 2 and 3.
Both have given no objection.
Yes, the daughter is applying for the letters of administration.
Like daughter.
The daughter, yes, she's the petitioner here, and the husband, he has given no objection, and it has been annexed as Annexure B.
What is the name of the daughter?
The daughter's name
Nayantara
is
Coluccia.
Nayantara Coluccia, and the husband's name is Antonio Coluccia.
Where is the property situated?
The property is in Bolpur, Birbhum district. The same has been laid down in the affidavit of assets. It is the only property of the belonging to the intestate deceased.
Yes, where is the affidavit of assets? What is
Lordship,
the
it has
what,
been annexed as
what is the value? 1
about,
crore 61 lakh 18,000.
211, yes.
11. So appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration to the estate of the deceased Anuradha De alias Anuradha De Coluccia. देखना यहाँ से देखो Coluccia. Full stop. Counsel for the petition submit that the deceased died on 21st of October 2021.
Yes, Your Lordship.
23rd October 2021, leaving behind her husband and 1 daughter as her legal heirs. Full. The petition submitted. The daughter has filed the present application for grant of probate, for grant of letters of administration, and the husband of the deceased, namely
Antonio Coluccia.
Antonio Antonio Coluccia, has given his affidavit of consent stating that he has no objection for grant of letters of administration to the petitioner. First, at the learned counsel for the petitioner peruse the application, death certificate of the deceased, affidavit of consent of the husband of the deceased and husband of the deceased. This court find that husband the deceased died leaving behind 2 legal heirs, that is the husband and the daughter, and daughter has filed the present application for grant of letters of administration, and the husband has given no objection for grant of letters of administration to the petitioner. Accordingly, this court find that the petitioner is entitled to get the letters of administration of the estate of the deceased. Accordingly, the department is directed to issue the letters of administration to the petitioner to the estate of deceased, furnishing bond of rupees 17 lakhs with 2 sureties of the like amount on compliance of all formalities. PLA number so disposed of.
Number 34.
Yes.
Yes, in this matter, Senior Advocate Manju Agarwal is appearing for the executor. There has been a bereavement in her family, so please adjourn this matter for a period of
You got the
fortnight.
opportunity. What is the application for? Probate
Actually,
matters.
I don't know the matter. I am very new in her firm, so
How many years you are having practice?
I have passed out in this year.
Thank you. As per the prayer made by the counsel for the petition,
Thank you.
the case is adjourned. Let the matter appear on 5th of February.
Obliged.
5th of February.
Number 35.
Milo, this is my application for grant of probate.
Yes.
The deceased died on 23rd of February 2024 and the registered last will is dated 18th of June 2005.
Where is the will, madam?
The will is Annexure B and the death certificate is Annexure A.
18
But
June 2005.
yes, but subsequently there was a codicil also, which is Annexure C, dated 3rd of August 2021. By the codicil, my lord, the executorship has only stood amended because initially in the registered will, the wife of the deceased testator was named as the executor. But in the codicil, after her death, his son has been made the executor. And there are 2 attesting witnesses in respect of both the will and the codicil, and one of whom is a common factor because Mr. Mola Kumar Sheel is the attesting witness to both the registered will as well as the codicil. So he has affirmed an affidavit and also declaration, which is Annexure D
Where
to
is the
the
name of
petition.
the executor in the codicil, madam?
The name of the executor is the son, Shamikendranath Sengupta.
Where is it? Where it
Yes,
appears?
I'll just take your lordship to that. It's Annexure C. Annexure C, internal page number 2.
Executor of the will.
Yes, in the following order. In the following order. So the first preference has been given to the son, Shamikendranath Sengupta, who has applied before your lordship for the grant of probate. And Shalini Sengupta, the daughter of the testator, has given a no objection to the grant. And Naira Menon is the granddaughter who is a minor. On her behalf, her mother has also given a no objection. These are all annexed to my petition. And the natural heirs I have stated in paragraph 5 at internal page number 3 of the petition.
Shalini Sengupta and Shamlukennath. And Shamlukennath Gupta is the son.
He is the
He is
son.
the petitioner and the son.
Yes, the no objection is there, which is Annexure D. And the affidavit of assets is Annexure E to the petition.
This is a, yes.
The natural heirs have been given the property, which is the only property.
Okay. So offering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 18th June 2005, read with the codicil dated 3rd August 2021. The counsel for the petition submit that initially the testator has appointed his wife Sharmila Sengupta as executors of his last will and testament dated 18th June 2005. But after the death of his wife, the testator has executed the codicil by appointing the petitioner as first executor of the said will. Accordingly, the petitioner has filed the present application for grant of probate. The counsel for the petitioner submit that the testator died on 23rd of February 2024, leaving behind the petitioner being the son and another legal heirs, namely Shalini Sengupta as daughter. Full stop. The counsel for the petitioner submit that the daughter has given her no objection. Affidavit of no objection stating that she has no objection for grant of probate to the petitioner as per the will of the testator. Heard the learned counsel for the petitioner peruse the original will and the codicil and the no objection certificate issued by the no affidavit of no objection of the daughter. The one of the attesting witness is the common in the will as well as the codicil as well. Accordingly, the said attesting witness, namely
Mr. Malay Kumar Sheel.
namely Mr. Malay Kumar Sen,
SEAL.
Seal has also filed the affidavit stating that the testator has executed his last will and testament as well as the codicil in his presence and in presence of the other witnesses while possessing good health and fit state of mind. Initially he has appointed his wife as executrix, but after the death of the wife, the petitioner was appointed as the first executor of his will by way of a codicil. Was executed by way of codicil. Considering the above document, considered the original will, original codicil, death certificate of the testator, affidavit of the legal heirs, that is the daughter, affidavit of attesting witness. This court find that the petitioner has proved the will and is entitled to get prove the will and the codicil and is entitled to get the probate. Accordingly, the department is directed to issue probate to the petitioner of the will dated 18 June 2005, read with codicil dated 3rd August 2021 upon completion of all formalities. At the time of grant of probate, the copy of the will and the codicil be made part of the probate. PL number circumstances disposal.
Number 36.
I am appearing for the caveat,
Should appear for the executor of the.
The notice has been issued by the petitioner, I mean the probate application, but without copy of the
When you receive the notice?
Notice has been master's notice and application is filed.
When you have received the notice, sir?
And issued, he is 7th December.
7th December.
7th December, I issued notice to him asking for a copy, and on 10th and 11th, 12th, they supplied the copy.
12th of December, they supplied the whole document to you.
Supplied the documents and copies. Then I prepared the everything. In the meantime, sir, 23 days delayed. So I made an application and with the master summons, and accordingly, matter is come to the
Have you
list.
served the copy?
Yes, sir.
Yes.
I do not want to stand in the way of condemnation of the delay, but one point which I would like to point out before my lord is that the caveator has filed a title suit before this learned city civil court, claiming that the testator has died intestate and that she is entitled to all the bank deposits and everything.
But addition suit?
No, my lord.
Declaratory suit?
Declaratory suit. And they are, my lord, enjoying an ex parte injunction which is being continued even till date, where I am being, my lord, as the sole beneficiary under the will and also admittedly the sole nominee of the bank accounts, I am being deprived from withdrawing those bank deposits. Now, my lord, the will states that the
in the will also the bank account is mentioned, affidavit has said.
Everything, my lord, has been given. Movable, immovable, my lord, everything has been given to me.
To you. Who are you?
My lord, I am the son of the testator.
And who is he?
My lord, he is the
widow.
The widow, the second marriage, my lord.
Second marriage.
And I am the son from the first marriage.
But I have submitted all documents, registration documents.
No problem, no problem. I am not deciding this.
My only prayer is that, my lord, if my lord is inclined to allow the petition, my lord, kindly let it be expedited, my lord, this probate proceeding, my lord, because
what is the stage of the suit?
My lord, this.
What is the stage of the suit which you are enjoying the interim order?
Suit, the interim order, the last occasion, I was directed to amend the plaint, order 6, rule 17, accordingly filed.
For what?
For some relevant, some documents which was not available at the relevant point of time.
Who are the defendant in the suit?
In the suit, the number 18 bank and main defendant number, yes, the such. Defendant number 1 and 18 bank. 18 number of banks.
Bank with regard to the all
Or the
bank.
have fixed deposit and all. He himself,
What is the amount involved?
um,
So I am doing one thing. I am calling this suit before this court, and both the suit will tag together and be proceeded. That will be better. You are filing. I am allowing your caveat. I am accepting your affidavit in support of caveat. Correct. That it will be treated as a contentious cause.
Supreme Court judgment of Justice Rumapal.
What?
That reflects the decision of the Justice Rumapal. I don't know the cost title.
Not Rumapal, but the conflict decision. Justice Rumapal, it is several decisions are there. So I am
the identical decision passed by the Honorable Supreme Court. So
well aware. Then,
so I have nothing.
what is the submission?
My submission at this stage, submission was that the
Because he is the party to that in the proceeding. Let it become. And what the bank is nothing to do. If the court will allow you,
main dispute in between the plaintiff and defendant number one.
if the court will prove, he will prove the will, then he will. If you disprove the will, then it will be decided in terms of the law. In accordance with the Hindu law, whether you are entitled or he is entitled. That's why. If the not also, then it will be decided. So-and-so appearing for the petitioner. So-and-so appearing for the caveator or caveatrix? Caveatrix.
Cavity.
So-and-so appearing for the caveatrix. The caveatrix has filed an application being GA1 of 2025. Praying for. Where is the Master Summon?
Pandunda delay 23 days. AB.
Praying for condoning the delay of 23 days in filing an affidavit in support of caveat. In support of caveat. And to allow the caveatrix to file the affidavit. File the caveat in support of affidavit. File the affidavit in support of caveat. Counsel for the caveatrix submit that though the caveatrix has received the notice but had not received the copy of the PLA application and the documents, and accordingly the learned advocate for the caveatrix has sent a notice to the learned advocate for the to the petitioner for supply of the documents and the PLA application. Accordingly, the same was supplied to the learned counsel for the caveatrix, but while preparing the affidavit in support of caveat, there was a delay of 23 days. And as such, he prays for condoning the delay of 23 days for filing affidavit in support of caveat. Learned counsel for the petitioner raised objection on the ground that the caveatrix had already initiated a title suit.
Title suit number 105 of 2024.
Title suit number 105 of
2024.
2024 before the learned court of
10th bench City Civil Court.
10th bench City Civil Court, wherein he is enjoying the interim order, wherein he has enjoying the interim order. Full stop. Heard the learned counsel for the respective parties. This court find that the petitioner has filed the heard the learned counsel for the respective parties. This court find that the petitioner has filed the present application for grant of probate. The caveatrix is the step mother of the petitioner. And as such, the petitioner has made the caveatrix as party. As disclosed your this is the stepmother.
Her status has been disclosed as
Disclosed, na? And the petitioner has disclosed the name of the caveatrix in the probate application. Thus, this court is of the view opportunity should be given to the caveatrix to contest the probate application. Accordingly, the delay of 23 days in filing the affidavit in support of caveat is condoned. Full stop. The affidavit in support of caveat is accepted. Have you served? Full stop. Accepted. Subject to scrutiny by the department. Full stop. The petition, the learned counsel appearing for the caveat is directed to serve the copy of the affidavit in support of caveat to the petitioner in course of the day. Full stop. As the caveat as the affidavit in support of caveat is been accepted. Accordingly, the PLA proceedings has become contentious cause. So the department is directed to assign the testamentary number in the suit. Full stop. It is also fine from the submission of the learned advocate for the parties that the caveatist has also filed an title suit before the London City Civil Court with respect of the assets of the deceased. Thus, to avoid the multiplicity of the proceedings and conflict decision in the matter, it would be appropriate that the title suit pending before the learned 10th Judge, City Civil Court, Kolkata, be brought to this court, and both the suit may be taken together for analogous hearing.
Not, may I submit one thing? Not, there is the plaintiff number 2 is the son of the step brother of the petitioner hearing.
Okay, no
He is the party head there.
No
Next point is this, Lord, the interim order is till 4th April. That
4th
should-
April.
fo-
Okay, I
4th
am
April.
fixing before that. I am fixing before that. No problem. কি বলে?
Lord, so for servicing question, kindly allow me 2 days time to Xerox and everything.
By Friday.
Analogous hearing.
By 5 days, Lordship.
In view of the above, the learned judge and learned judge 10th bench City Civil Court, Kolkata is directed to transmit the record of title suit number
105
of
2024
2024 within bracket क्या नाम दिए दिन first title
Chandrani Ghosh Chaudhary.
name in written
Chandrani
versus
Ghosh
so and so,
Chaudhary.
so to this court
Slip
within 2 weeks from the date of receipt of the copy of this order. On receipt of the said record from the learned 10th Judge City Civil Court, the department is directed to assign the EOS number and to place before this court along with the titles along with the testamentary suit arising out of PLA 108 of 2024 before this court on 27th of February on 5th of March 2025.
Title suit number ta likhiye.
GA number so and so disposal.
Lord, service within Friday. Saturday, Friday.
Today बोला
Friday, not today, Friday.
Copy of the in course of the day within 2 days from now.
Within 2 days.
I'm for the petitioner, mother. This is a probate application, my lord.
Yes.
Other legal here are not given consent, my lord. They are.
I can't hear you, madam.
My lord, this is a probate application, my lord. Other legal heirs of the petition are not given consent, my lord. That's why citation.
Citation.
required, my lord.
Citation.
Yes.
How many legal heirs? None has come forward. None.
No, my lord.
Where is the legal heir? Details of the legal heirs.
Legal heirs.
One is the son.
Petitioner is the daughter of the deceased and 3 sons.
3 sons.
Yes,
and
ma'am.
Umara is the petitioner.
Yes, ma'am.
Umara is the petitioner.
Yes, ma'am.
She is the executrix.
Yes, ma'am.
So and so bring for the petitioner. Petitioner has filed the present application for grant of probate of the last will and testament dated 21st December 2018. The counsel for the petition submitted the testatrix. The testatrix Lakshmi Rani Ray died leaving behind 4 legal heirs, including the petitioner herein, who is the daughter. So the counsel for the petition submitted the other legal heirs, that is the 3 sons, have neither come forward to give consent for grant of probate, nor have filed any affidavit, nor have filed the caveat or affidavit in support of caveat. Accordingly, counsel for the petitioner prays for issuance of a special citation and general citation. In view of the submission made by the counsel for the petitioner, prayer A and B of the application is allowed. Next.
My application for probate, my lord. There are two testator and testatrix, my lord. Will is dated 28th of August 2025. 17th October 2007. The
Who?
date of the will. my
Date
lord.
of the will.
Date of the will. Testator passed away on 21st of July
Both the
2004.
joint will.
Yes, joint will, my lord.
Testator and testatrix both. Husband,
Yes, husband,
wife,
husband,
both.
wife, my lord.
They have executed the will on
17th of October 2007.
17th October 2007.
2007, my
When
lord.
the testator died.
Testator died on 21st July 2014 and testatrix died on 28th August 2021.
14 and 2021.
Yes, my lord.
Correct.
My lord will find page number 10 and 11 is the
Yes,
death
got it,
certificate.
got it.
And the legal hair, there's only one legal hair, their daughter. I mentioned in page number 3, paragraph 5. Yes,
Srimati Mitra.
my lord, before marriage, her name was Mitra Bhumik. Then she got married to someone whose so full name became Mitra, my lord.
Full name become Mitra.
Yes, my lord. She has given her consent, my lord. Son-in-law is the executor.
Who is the where is the name of the executor in the will?
Executor's name, my lord, will find
Swami Bhumik.
Yes, my lord. In page number 14, my lord, paragraph number 2. Tapan Kumar Mitra.
Tapan Kumar Mitra, jointly and severally probate. Where is the executor? Name of the executor?
Yes.
Word executor. Where is the word executor?
Executor, my lord.
Joint executor.
No, jointly or severally, my lord. If kindly sees the penultimate line.
Executor is executrix of this will who shall be. So then what about the other one?
Jointly or severally.
Correct. What was the other one? Bharti Bhumik. What has happened to her?
My lord, severally they have filed, my lord. He has solely filed because
Yes, solely filed. Where is the notice up to the other?
Because provision was there, my lord. My lord, she is not the legal heir also.
Maybe, but he is the beneficiary of the will, sir.
No, she is not the beneficiary of the will.
Executor.
Executor.
She
My
is
lord,
one of the executors.
beneficiary was only Mitra, her daughter. She has given consent. My lord, kindly sees. I'll just show you, lordship. My lord, kindly sees paragraph number 1, page number 14.
Correct. I am there only.
Yes. It says, my lord, that
4-story building and premises
Yes.
so and so, Khalsa, Kolkata,
yes,
and more or less so and so.
to our
with
daughter Srimati Mitra, wife of Swapan Kumar Mitra. She is the only legal heir and beneficiary.
Why she has been made as executrix?
Executrix has been that, my lord. That time they have made, I don't know why, my lord, but provision was there, my lord, for jointly or severally.
That's correct, but you have to issue the notice.
My lord, kindly, notice is only against, my lord, subject to correction against the legal heir, my lord. Class 1 legal heir as per Indian Succession Act. Legal heir is the Mitra. She has only, she has filed her affidavit of consent, my lord.
But issue the notice to him.
My lord, provision was there for jointly or severally, my lord.
Correct, I understand. I am fully with you. But one opportunity, otherwise you will be in trouble in future. Anything will happen.
Then, my lord, kindly grants me some time if she files the affidavit of consent.
I am directing
Yes.
either issue the notice or come with an affidavit.
I will come with a affidavit of consent,
I
my
am
lord.
not passing any order. You will come with
Very
the
well. I
affidavit.
will kindly adjust it for 2 weeks. I will take instruction, my lord.
As per the prayer made by the consensus and suffering for the petitioner. Full stop. As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 12th February.
Very well, lord.
Next.
My lord, this is my application for the grant of probate, my lord. The testatrix, she died on 10th day of July 2023.
Ready? Compliance all?
Yes, my lord. Non-contentious, my lord.
Huh?
Non-contentious.
Where is the application? Where is the will?
Will is at page 8.
Page 8. Vidya Devi Chaudhary, testatrix.
Yes, my lord.
Vidya Devi Chaudhary. Where is the name of the executor?
Executor, point number 8, Mr. Pritesh Chaudhary.
I hereby appoint Pritesh Chaudhary as executor. Executor shall be entitled to probate. Yes. Then
my lord, it's
what is the date of the will, madam?
Date of the will is 10th day of July 2023.
23. How many witnesses?
2 witnesses, my lord.
Anuj Chaudhary, Subir Chaudhary. Yes. How many? When she died?
She died on 14/8/2023.
Where is the death certificate?
At page, my lord, at page 12.
Vidya Devi, 14th August 2023.
Yes, ma'am.
What about her husband?
Husband, I have pleaded in paragraph 3 of the petition. Sajan Kumar Chaudhary is the husband and one son Anuj Chaudhary and daughter Archana Bagla.
Husband is there.
Yes, my lord.
There. Yes.
He's
So,
alive.
so when have they all have been given?
Yes, my lord. Consent is there.
Affidavit of assets. Anuj Chaudhary,
Archana Bagla, daughter.
Sanjan Kumar Chaudhary, Sajan
Sajan.
is the husband,
Yes, ma'am.
and Pritish,
Archana Bagla, daughter. Consent.
Archana Bagla.
She's the daughter.
Yes, Archana Bagla. Who is the attesting witness?
Anuj Chaudhary.
Huh?
Anuj Chaudhary, son.
Attesting witness.
Yes, ma'am.
Where is that affidavit?
At last, affidavit of
Bagla, Sajan Kumar, Anuj Chaudhary.
affidavit of
Chaudhary.
attesting witness found on 20th day of March 2024.
You not file the separate affidavit of the attesting witness.
No, madam. Only one affidavit of
But kindly come to his affidavit. He is not stated. Stated. He is not stated.
in point number 3, madam.
I hereby given my consent. This is being granted. Execute. I was waiver of service. He has not stated that the father or the executor or executor executed the will in his presence, having good capacity and fit state of mind. File a separate affidavit as an attesting witness.
But my lord, in affidavit,
Where is? Show me.
in attesting witness, affidavit of attesting witness in point number 3 and 4, my lord.
Anuj Chaudhary.
Yes, my lord.
Yes.
He signed in the presence of Surbi Chaudhary. Surbi Chaudhary was present.
That is the will. In the affidavit of the attesting witness, what are the contents?
In paragraph 4, my lord. Sound mind and good health and the testament.
Where it is?
In paragraph 4.
Paragraph
page
4
number
of?
2, of the affidavit of attesting witness of Anuj Chaudhary.
It is the kindly see. I am having this.
In
Yes,
affidavit of consent. Affidavit of
where is? That's why I am asking. Where is the affidavit of attesting witness?
is there in the record.
Acha, ye. Sir, tell you he has filed a separate. That's why I am asking you.
Paragraph 4. my lord.
Paragraph 3.
3 and 4.
Yes. So and so opening for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 10th of July 2023 of the testatrix Vidya Devi Chaudhary. Counsel for the petitioner submit that the testatrix died on 14th August 2023, leaving behind her husband Sajan Kumar Chaudhary, her son Anuj Chaudhary, and her daughter Archana Bagla. Archana Bagla, BAGLA. Counsel for the petitioner submit that all the legal heirs have filed their affidavit of consent stating that they have no objection for grant of probate. As the petitioner is one of the son.
Petitioner is grandson.
Anuj Chaudhary.
Petitioner is Pritish Chaudhary, executor.
Pritish Chaudhary, okay. Thank
The
you.
grandson.
No, grant of probate of the last will and testament to the petitioner in terms of the will. Counsel for the petitioner submit that the one of the son, that is Anuj Chaudhary, is also one of the attesting witness of the said last will and testament, and he has also submitted an affidavit stating that the testatrix has executed her last will and testament in her presence and in presence of the another attesting witness while possessing good health and fit state of mind by appointing the petitioner as executor of last will. Consider the submission made by the counsel for the petitioner, peruse the original will, death certificate of the testatrix, affidavit of consent of all the legal heirs, affidavit of the attesting witness. This court find that all the legal heirs have filed their consent, stating that they have no objection for grant of probate, and the attesting witness also stated in his affidavit that the testator has executed his last will and testament in his presence and in presence of another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executor of her last will and testament. Considering the above, this court finds that the petitioner has proved the will and entitled to get the probate. So the department is directed to grant probate to the petitioner of the last will and testament dated 10th July 2023 upon completion of all formalities. Upon completion of work, at the time of grant of probate, the copy of the will be made part of the probate. PLA number so is disposed of.
Item 40.
Perhaps my lord doesn't need any refreshment of memory with regards to this matter. That circular transaction. This word, I think perhaps your lordship after this.
Now the defendant, my lord, is successful in making your lordship fade away with the memory. This has been heard quite some time back.
My lord, if your lordship recollects, on the last occasion, Mr. Thakkar had submitted on facts. Mr. Mitra is leading us. I've been told Mr. Jayanto Mitra is on his way, my lord. My lord, if your lordship recollects, on the last occasion, we had filed a supplementary affidavit. There are two parts to this matter, my lords. The two parts, my lord. The first was when they filed the application, we used a reply. We put down all the circular transaction factually, which we thought was relevant for this matter, my lord. We had put it on affidavit. Thereafter, my lord, we did not have certain documents in our possession. They were referred to in the main affidavit. We sought for leave to file a supplementary affidavit disclosing those documents, which are majorly the bank statements of the plaintiff and other companies in which the money flowed. On the last occasion, Mr. Thakkar placed the entire supplementary affidavit and the chart, my lord, if your lordship takes the chart, that chart would refresh the entire memory in the supplementary affidavit. But at page 3 of the supplementary affidavit, this is the affidavit affirmed by one Mr. Bubna on 18 June 2024. Page 3 of the supplementary affidavit.
Yes.
But this was the chart showing the entire transaction, the money flowing from one party to the other. And we say that it has been returned back. And we were just a conduit in the entire transaction. I was just refreshing on facts. That's the only.
I'm sorry, but I've become very slow in movement.
No problem. I am fast. This court is fast.
No, your lordship is absolutely on time. I should have been here. Well, your lordship now has heard the entire facts. The case of the plaintiff is money lent and advanced. Money lent and advanced, and my lord, by way of evidence, it is an oral agreement. That is admitted position. In paragraph 4 of the plaint, your lordship will be pleased to see. It is saying that because this will have some important bearing on my submission. Paragraph 4 at page 19 of the petition.
Yes.
The plaintiff agreed and the parties entered into a contract whereunder the plaintiff agreed to grant such accommodation loan. So and so the last sentence, such agreement would be evident from the conduct of the parties hereunder. So it is an oral agreement. Now, my lord, by way of the amount lent in advance is 3 crores. And by way of evidence of this, the balance confirmation, reliance has been made on the balance confirmation, and also, my lord, the TDS certificate, which according to the plaintiff shows the acknowledgement of liability.
Yes.
And this, perhaps your lordship will please to make a note of it in paragraph 6 of the plaint. Balance confirmation and deducted at source. Now, on the as against that, my lord, my learned junior, Mr. Thakkar, has made his extensive submission showing that it was really a sort of circular transaction. And in the supplementary affidavit, which has been placed before lordship, there, in short, my lord, a chart had been given at page 3, and it is showing how, my lord, these transactions have been made. Sagittarius to Pranava, 2 crores, Sagittarius to Pranava. Now, my lord, your lordship will be pleased to look into this and compare this. In support of this has been
transaction, yes.
Yes, the
bank
account at page 11. Your lordship can make a note of it. At page 11, the 1, 2, 1, 2, 3, 4, 5th entry. 2 crores, Pranava Electronics. And then another entry, the next one, 1 crore. This is, my lord, tallying with 1 and 2. If your lordship, my lord, looks into this balanced
this statement of account, your lordship will please to find that this tallies with the statement which has been given, the bank statement.
Yes.
If your lordship kind of comes to page 8, another bank account. This is of Pranava Electronics.
Yes.
Barclays Bank.
Yes.
Lordship will kindly come to page 8.
Yes.
There your lordship will see the 1, 2, 3, 4, fourth entry from the bottom, 2 crores, and 6th entry from the bottom, 1 crore. This telling. Then 12th March again, Pranava Electronics 2. This was in to KR Pradeep. This is 1 crore. This is item 3 at page 3 of the affidavit. And then the next one, 1 crore. This is the item 4 in the this 1 crore. Similarly, if your lordship looks into the next page, your lordship will please to find that the second entry, the 5th item, 1 crore. Like that, my lord, these have been disclosed before your lordship to show that this amount had been sort of going round. Similarly, my lord, if your lordship comes to page 13, the final one, at page 13 of this, HDFC Bank, 22nd March 20, your lordship sees?
Yes, yes.
And they are GAN traders, 3 crores, 15 lakhs.
Yes.
Your lordship will please to tally this with, my lord, affidavit in opposition, the main affidavit in opposition, page 114. Your lordship sees that page 114.
Page 114 of AO.
Of the AO. There the GAN traders account has been disclosed.
Yes.
Sagittarius Credit Capital.
Yes.
3 crores 15 lakhs, second item. So, my lord, this what has happened is this what is being said in the affidavit in opposition, that this is a show transaction. The whole thing is a sham transaction. It is not actually money lent in advance. It is, my lord, the
circulation.
Yes. For the purpose of, my lord, and this is what has been said in Bubna's affidavit. Your lordship will please to see, come to paragraph. I just very quickly, this has been placed before lordship. Your lordship kindly comes to paragraph, subparagraph 5 at page 3.
Of affidavit?
Affidavit, main affidavit in opposition.
Yes. Page?
Page 3. In fact, my lord, it starts at subparagraph 4 at page 2. The transaction, how it went on, this KR Pradeep Patni, they are the persons, my lord, the KR Pradeep is of Pranava.
Raju Patni.
Raju Patni is of Sagittarius. And my lord, this is how this conduit has been explained here in this paragraph.
Yes.
And it says that and the pure question of evidence has been shown. And my lord, it is shown that the profit of these persons would be 2%, 9% lent, 11% return, and 2% margin of profit back.
Correct.
Then subparagraph 5.
Yes, that is there.
Your lordship has been pleased to see this. I am not going to trouble your lordship with this. And this has been placed, and this is how the transaction had taken place. My lord, my respectful submission is this is an application under Order 12, Rule 6. Therefore, my lord, the admission has to be unambiguous, clear. Well, 3 terms have been used in this Supreme Court judgment. Your lordship judgment is there. I am very strongly relying upon this. I am not going to waste your lordship's time. These decisions have been placed before your lordship from time to time, and your lordship has been pleased to consider all those. I shall just only refer your lordship to this. Three judgments I am going to refer to your lordship and hand up to your lordship. One is this 2011, 15 Supreme Court cases, 273. This has been considered by your lordship, and that is, it has to be, the admission has to be conscious, deliberate, and categorical. So if there is any controversy with regard to the evidence, then, my lord, I respectfully submit to your lordship that Order 12, Rule 6 application will not lie. This is 2011-15 Supreme Court cases, page 273, at page 276 to 277, para 11. 276, 277. Well, I can hand up to your lordship this. No. Kindly give me 1 second. 22. I misplaced here. Your lordship will be please just to look into my lord this paragraph 11, page 276, 277.
Of the judgment?
Of the judgment, para 11.
Yes, it is true the judgment can be given on admission.
It is true that a judgment can be given on an admission contained in the minutes of a meeting, but the admission should be categorical.
Correct.
It should be conscious and deliberate. So categorical, conscious and deliberate act of the party making it, showing an intention to be bound by it. Order 12, Rule 6 being an enabling provision, it is neither mandatory nor peremptory, but discretionary. The court on examination of the facts and circumstances has to exercise its judicial discretion, keeping in mind that a judgment on admission is a judgment without trial, which permanently denies any remedy to the defendant by way of an appeal on merits. Therefore, I submit to your lordship that when there is at least some evidence has been brought before your lordship, which may be an acceptable evidence at the hearing, then, my lord, I will respectfully submit to your lordship that it is not a conscious or deliberate act, and, my lord, it is not, my lord, an admission which can be said to be categorical to be accepted by the court. This is one. And then, my lord, then 2022 10 Supreme Court cases, page 496. I shall very quickly take your lordship to that. 2022 10 Supreme Court cases, page 496. My lord, one paragraph. Sorry, I should say one or two or three paragraphs. Paragraph 19 at page 504. Here, paragraph 19, of course, is setting out the provisions of law. I'm not troubling your lordship. Kindly come to para 23. Para 23, Order 12, Rule 6 confers discretionary power to a court who may, at any stage of the suit or suits, on the application of any party or on its own motion, without waiting for the determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admission. Thus, legislative intent is clear by using the word may and as it may think fit, quote unquote, to the nature of the admission. The power is discretionary, which should be only exercised when specific, clear, and categorical admission of facts and documents are on record. Otherwise, the court can refuse to invoke the power under power of Order 12, Rule 6. So, my lord, facts and documents are on record. I am submitting to your lordship the facts and documents which have come on record after the filing of the affidavit in opposition creates sufficient evidentiary value, evidentiary material, which perhaps will enable the court to say that I shall hear the matter out at the time of hearing of the suit. And then he said the provision has been brought with the intent that if admission of facts raised by one side is admitted by the other, and the court is satisfied to the nature of admission, then the parties are not compelled for full-fledged trial and the judgment and judgment and order can be passed without taking any evidence. Therefore, my lord, the issue perhaps will be before your lordship that is there some evidence on record which will entitle the court to relegate the parties to trial? This is the short and simple question. Then, my lord, then para 26, 27, reliance has been placed on certain judgments. I am not troubling your lordship with this unnecessarily. Then, my lord, we come to on this aspect of the matter, the last judgment. This also your lordship has been pleased to consider. 2019-20 Supreme Court cases, page 425. I am only referring to paragraph 25, 26 to 28. But these are the paragraphs which are reiterating the same proposition. And my lord, finally, on this aspect of the matter, I rely upon your lordship's latest judgment. Which judgment? Yes. This is, my lord, ordered on 11th January 2023. This is Jayashree Steel Private Limited with the Shivam Dhatu. Here, your lordship has been pleased to have taken the trouble of considering all the decisions on the suspect. And my lord, this is this should be very useful to the junior members of the bar. it's a
company oral contract.
I see. Sorry.
2019, Mr. Thakkar, 2019 you are having?
Yes. Well, this is Meenakshi Goenka versus Canon Properties. That's the judgment which has been delivered by your lordship, which consider all the 15 January 2025. This is the latest judgment. And by the author is your lordship, and assisted by Mr. Thakkar. Well, I am relying upon this judgment fully because it considers all the decisions. 2019.
2019, which paragraph you are relying on?
I am relying on paragraph 25. 25, my lord, and 26, my lord, these are considering Himani Alloys, SM Asif, and then Balraj Taneja.
Yes.
Really, my lord, the same thing has been reiterated. I am placing it for record. Actually, পড়বার দরকার নেই. Joseph এগুলো সমস্ত consider করে দিয়েছেন judgment. My lord, lastly, my lord, I will submit, or rather, I have got two other points. First is TDS certificate, which has been relied upon, that has been held by the Bombay High Court, is only, it does not amount to acknowledgement of liability. It is only to an acknowledgement with regard to the deduction of tax at source. Nothing more, nothing else. My lord, that is for that I am relying upon 2008 SCC Online Bombay, page 15.
Acting Chief Justice.
99.
Acting Chief Justice.
Yeah, I shall give you. I think I don't remember the cost title.
Chief Justice. Division Bench of the Chief Justice.
Yes. This is a Swatantra Kumar.
Yes, Swatantra.
Chief Justice.
And Devgar.
Which was
Here, my lord, para 8 is the paragraph which your lordship can look into, and here it has been said. I'm just reading it out. The issuance of TDS certificate does not amount to an acknowledgement of the defendant within the meaning of Section 25 of the Indian Evidence Act, and the full bench judgment of this court in the case of Josna puts the matter beyond doubt. The TDS certificate is primarily to acknowledge the deduction of tax at source. The certificate does not refer to any amount of loan or even the rate of interest which is payable on the said principal amount. It does not refer to any contract between the parties and even a transaction. Well, lastly, sorry.
Yes.
My lord, lastly, it has been stated after, my lord, the affidavits have been filed. In the reply, it has been contended. I am just foreseeing the argument. It says that what had been stated in the affidavit opposition will tantamount to, my lord, varying an agreement between the parties. And therefore, it is barred under Section 92 of the Evidence Act. There, my only submission is this, that Section 92 of the Evidence Act, if your lordship looks into the Evidence Act, it is only in respect of a contract which is required by law to be reduced in writing. It is applicable only
Between
in
the parties and instrument represented interest.
A contract which is by law is required to be reduced in writing. Only in respect of that kind of a contract, Section 92 is applicable. Section 92, it does not apply if it is an oral contract.
Correct. So,
and
with regard to the oral contract, then the party has to prove the case.
That's right. And therefore, my lord, section 92 will have no application. On that, your lordship can just make a note of it. 1982, one Supreme Court cases, page 4.
1982?
One Supreme Court cases, page 4, para 11. Para 11, my lord.
Yes.
Photocopy them. And they are also exactly on this point, considering section 91 and 92 both of which, my lord, considers a case where the contract has been reduced in writing.
Yes.
So, my lord, in respect to an oral contract, section 92 has got no application. Lastly, my lord, I thought that this would be the last point. Another point I have been asked to address to your lordship. This is something which I have not really, to be very frank, I have not come across any decision on this point. My lord, I was just wondering, is it contract? Your lordship has seen all these are companies. And this is the point, this is a brainwave of Mr. Thakkar. I don't take any credit for
Always.
I don't take any credit for this. If there, under the new Companies Act 2013, I asked this question to myself, can two companies enter into an oral contract?
As per the Companies Act, it is bar.
Earlier Companies Act, my lord, if your lordship looks into this section, is very interesting point. I am not very sure as to
Old Act.
Old Act. Section 46. Section 46, form of contracts. And it says the contracts on behalf of the company may be made as follows.
Yes.
A contract which, if made between private persons, will by law be required to be in writing, signed by the parties to be charged therewith. May be made on behalf of the company in writing, signed by any person acting under its authority, express or implied, and may be in the same manner be varied or discharged. Then B, a contract which, if made between private persons, would by law be valid, though made by parole only, and not reduced into writing, may be made by parole on behalf of the company by any person acting under this authority, express or implied, and may in the same manner be varied or discharged. So there was the concept of oral contract under the old. Well, significantly, section 46 is not there in the new act.
Correct.
It is just
repealed.
Lordship looks into, I was looking into this comparative this thing. Section 46, my lord, that is where a comparative statement of the sections in the two acts, the new act and the old act. There is no equivalent section like 46 in the new act. But in the new act, there is section 21. This is with regard to authentication of documents, not with regard to the form of contracts, which was there in the earlier one. It says that same as otherwise provided in this act, a document or proceeding requiring authentication by a company, or B, contracts made by or on behalf of the company, may be signed by any key managerial personnel or an officer of the company duly authorized by the board in this behalf. Section 21. This is of course not with regard to form of contracts. This corresponding section is not there in the
Document requiring authentication by the company made on behalf of the company may signed by any key manager. Yes.
as to whether we can draw the inference that under the new Companies Act, the company is only entitled to enter into contracts in writing. Previously, of course, Section 46.
So what this say? Is there any that old act is repealed or amended?
No, the old act has been repealed, replaced by the new act.
So that cannot be.
And Section 46 corresponding section
Cannot.
Not. So, my lord, I am, my lord, inspired by that, my lord, omission of the section of Section 46 in the new act to urge before your lordship that perhaps a company cannot enter into a contract orally, verbally.
No, that is also in the companies itself there.
In the new Companies Act.
Yes, it is there. It cannot be. Companies, contact between the companies should be in the writing.
Has to be in
Yes,
writing.
yes. That is 400. Mr. Thakkar is.
Check karo. আমি দেখে নিব।
I have dealt with, I think so that, but I have dealt with.
Your lordship has still.
Dealt
Then, my lord, I am. I don't want to make any further submission. My lord, I put the ball back into your lordship's court.
Sir, we have.
Not put that. Jayashree still.
Yes, in this one.
Well, I shall give you lordship the paragraph, and this is. I have not seen this judgment, to be very frank.
Page 14, sir. Page 14,
Page-
second time.
Page 14, second.
Sir, को दिया? नहीं, hello.
My lord, I am grateful to you, my learned friend, and to your lordship. Well, paragraph, page 14, second paragraph.
Yes.
So, my lord, I am fortified by your lordship judgment. That's good enough for me. Well, I rely upon this, and I therefore submit to your lordship that perhaps this contract cannot be enforced in the way my learned friend is seeking to do so. Well, these are my responsible submissions.
আর কিছু আছে ইবিএস এর উপরে দিল্লি হাইকোর্ট আছে বম্বে আপনি দেখিয়ে দিয়েছেন দিল্লি হাইকোর্ট সেজ দ্য সেম
Same thing.
Yes, Mr. Dutt was there in that matter.
দিল্লি হাইকোর্ট আছে দিল্লি প্রতিবাদ সিনহা
Yes, বলে দিই আমি।
হ্যাঁ
এতগুলো জাজমেন্ট দিয়েছো আমি একটু বলি।
2018 SCC online 2018 SCC online
ও প্রতিভা বি সিং।
लेकिन सर एक तो हमको एक मतलब दो
Yes, my lord, I think paragraph 20, 19.
paragraph 19
19. Paragraph 19.
this was in appeal citation
Sorry. এটা হচ্ছে 2018 SCC online Delhi 9096 on the issue that TDS certificate does not amount to acknowledgement of liability.
this is in appeal
TDS, yes.
appeal
Because
after
this is
decree
regarding
also.
TDS. So on TDS, my lord, I've got two judgments. I've given you a lot of
This judgment, Mr. Banerjee,
Yes.
had the knowledge. Yes, I did that. In other matter.
Now the estoppel now
You have cited and you have
Now it is difficult for the lawyers to cite the judgment.
and then get out of it.
But fortunately not today.
No.
But these are my response submissions.
Thank you. Yes.
My lord will fix the matter any other day. I know, my lord, your lordship has been pleased to keep the matter fixed also as at 2 o'clock tomorrow. But Mr. Dutt is in some difficulty tomorrow, my lord.
Not tomorrow. Then it will go again long.
But any time
The commercial,
in
no?
February, if your lordship can.
Commercial, non-commercial, no?
সব ওজন করে আপনার ব্রিফে লাভ নেই
Yeah, they don't. So I am not taking this point. Companies Act, I am not taking one.
That's it.
Mr. Tucker, are you relying upon?
Yes.
Yes, yes, we are.
Then the old act may be given. Then I will. Okay, I will.
We'll keep a copy. We'll hand over a copy to your lordship.
Yes, yes, that will be better.
46 and 21.
So and so appearing for the plaintiff. So and so appearing for the defendant. Counsel for the defendant has concluded his argument in connection with GA1, na? GA1? GA1 of 2021. Also, counsel for the plaintiff prays for time. Accordingly, case is adjourned. It is fine from the report. The matter is fixed tomorrow at 2 p.m. But learned counsel for the plaintiff submitted that he is having some difficulties and prayed for fixing the matter to some other date. In view of the submission made by the counsel for the plaintiff, the hearing of the case on 20 date on 22nd January at 2 p.m. is cancelled. Let the matter appear. Give the date. How much time will take? 1 hour?
1 hour.
The matter appear on the 12th February at 11:30.
12th February.
12th February, 11:30.
11:30. My lord, the only other thing I wanted to point out, well, we have made an application GA3 for application for my lord taking for extension
Written
of
statement.
Yes, for the written statement. That application is pending
With
before
the written
lordship.
statement.
This is non-commercial,
And my lord, written statement copy has been annexed.
Non-commercial.
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 Written statement copy is annexed. to it.
In the written statement also taken this plea.
Yes.
Yes.
And what has happened to the appeal order one ruled?
Well, that was said that if the written statement is taken on record with a counter
Automatically come out.
yes, counter claim, then I can again apply for it because I will become plaintiff there. Your lordship's appeal court has upheld said you will become plaintiff in your counter claim, then you get them added.
Because at that time I was thinking that all the application, but it was taken up for hearing. Otherwise, this all application, then this controversy would not have been arise.
Grateful.
My lord, very
Keep your
grateful.
Thank you.
Take care.
Yeah, okay.
What's your list? New motion. Item number 8.
Item number 8, my lord, I am for the plaintiff, my lord.
Plaintiff?
Plaintiff, my lord. There
Yes.
is an interim application for
My lord, I am for the defendant.
restoration application, my lord.
Restoration?
Yes, my lord.
To dismissed?
It was, my lord.
For default?
Yes, my lord.
When?
My lord, it was dismissed on 6th
December
2024.
When you filed the application?
I filed the application
January.
on, my lord,
16 January, after a month. 40 days.
There was a delay of 10 days, my lord. I have
Yes,
explained it, my lord.
Yes, my lord.
What is your objection? Any objection?
No, my lord. We don't have any objection if they file the restoration.
Division service.
Record an order. So and so appearing for the plaintiff. So and so appearing for the defendant. The plaintiff.
My lord, we want it to be expedite the.
What is the stage? Have you filed the written statement?
Yes, my lord. They have filed framing of issues, my lord. Next.
No, discovery inspection completed. Affidavit of documents. Okay, I am restoring it. I am fixing a short date. Let the record come.
Oh,
Then
yes,
I
my
will
lord.
see.
Yes, my
Then if
Obliged,
it's
my lord.
discovery inspection completed, I will frame the issue and fix for evidence.
Yes.
So and so appearing for the plaintiff and defendant. Plaintiff has filed the present application being GA Com 1 of 2025, praying for recalling of the order dated 6th of December 2024, wherein this court has dismissed the suit of the plaintiff for default. So counsel for the plaintiff submit that. Submit that. On the date fixed, the learned advocate on record could not appear before this court due to his sudden illness, as he was suffering from cough, fever, and cold. Full stop. Had the learned counsel for the plaintiff perused the application, this court finds that sufficient cause has been shown for non-appearance of the learned advocate for the plaintiff on the date fixed. Accordingly, this court is of the view one opportunity should be given to the plaintiff to proceed with the matter. Full stop. Order. Full stop. In view of the above, order dated 6th December 2024 is recalled. Full stop. CS Com 377 of 2024 within bracket old CS 104 of 2022 is restored in its original file. Full stop. GA number GA Com 1 of 2025 is disposed of. Full stop. Let CS Com 377 of 2024 be placed before this court on 28th of January 2020.
Okay. Item number 9.
I am for plaintiff in this suit, my lord. My lord, I have filed an application judgment upon admission. Last occasion, my lord had given direction to file affidavit of in opposition and reply. My lord, they have filed their opposition out of time. I am seeking 2 weeks time to file my reply.
Just indicate my learned senior is absolutely right. By your lordship's last order, your lordship had given us leave to file the affidavit in opposition within 1 week from the reopening of the winter vacations. However, we filed it belatedly on the 16th, where she's right. So if an opportunity could be granted to them, I won't stand in the way, of course.
So suffering for the plaintiff. So suffering for the defendant. Plaintiff has filed the present filed an application being GA Com 2 of 2024, praying for judgment upon admission. Full stop. The defendant has filed affidavit in opposition after serving the copy to the learned counsel for the plaintiff. Where is your affidavit?
Your lordship.
Let the same be cut with the record. Counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply be filed by 2 weeks. By 2 weeks. Full stop. This is the matter on 18th of February 2025 for hearing of GA2 of 2024.
Number 10.
Under the adjourn motion, no? Adjourn.
Item 10, I appear on behalf of the petitioner.
10?
Yes, your lordship.
Yes.
Your lordship, may kindly take up your lordship's last order dated 10th of January 2025. Your lordship, this is that matter where the respondent had been taking time on some ground or the other. Thereafter,
Not file the affidavit of assets.
no affidavit of assets served. They did not deposit the money before the registrar original side as directed by your lordship. So I am praying for appointment of a receiver. Your lordship was pleased to consider my prayer on the last occasion, and as a last chance had given them an opportunity to file their affidavit of assets. So no affidavit of assets has come forward, nor are they represented today. So I am asking for prayer F.
So appearing for the plaintiff. None appears on behalf of the defendant. By an order dated 23rd of December 2024, this court has directed the defendant to deposit an amount of rupees 22,59,740 before the registrar original side of this court on or before 7th of January 2025. In spite of the order passed by this court, the defendant has not deposited the said amount. Full stop. The matter was taken up for hearing on 10th of January 2025. 10th of January 2025, and this court has directed the defendant to file the affidavit of assets on or before 20th January 2025. Full stop. 20th January 2025. Full stop. When the matter is taken up for hearing, none appears on behalf of the defendant. No accommodation is sought for. Counsel for the plaintiff has informed this court that the defendant has not complied with the order dated 10th of January 2025 by filing, and counsel for the plaintiff informed this court that the defendant has not filed the affidavit of assets. Full stop. Learned counsel for the plaintiff submit that in spite of the order passed by this court, the defendant has neither deposited the amount nor has filed the affidavit of assets, and as such he prayed for appointment of receiver to take control and possession of all the assets of the defendants. Defendant or defendant?
Sole defendant.
Of the defendant. Of the defendant with क्या बोला? Control, take possession, assets and property of the defendants. Considering the circumstances mentioned above, this court find that the defendant willfully and deliberately, in spite of the order passed by this court, neither deposited the amount before the registrar nor has filed the affidavit of asset. You are appearing?
No, Lordship, item 11.
Affidavit of asset. Accordingly, this court has no other alternative but to appoint a receiver in terms of prayer F of the present application. Full stop. Who will be there? If this one first.
Receiver.
Can you be appointed a receiver? So and so is appointed receiver. To take the control and take possession of all the assets and properties of the respondents of the defendants, including the original documents pertaining to the present suit, and to file the report before this court within 3 weeks. Within 3 weeks? We are in Calcutta only?
That's all based in Calcutta.
Within 3 weeks from date. Full stop. The remuneration of the special officer is fixed rupees 35,000. The plaintiff is directed to pay the remuneration to the special officer, to the receiver, and the plaintiff is the receiver. Full stop. Let the matter appear on is a commercial matter?
Yes, Your Lordship.
On 21st of February 2025 for filing report by the special office, by the receiver.
Lordship, 2 indulgences. 1, Your Lordship, police assistance if any. And police assistance if any.
Or next?
And next, Your Lordship has directed in Your Lordship, when Your Lordship was pleased to direct him to deposit the money with the registrar, Your Lordship was pleased that since he is settling, only the original amount, only the principal amount of 22 lakhs.
Let the report come, assets come, then I will continue.
Very well, Lordship. Your Lordship, my prayer in the application is for 44 lakhs.
That I will see, because
very well.
Full stop. It is made clear that if the receiver is facing any resistance from the defendant to act as a receiver in terms of this order, the receiver is at liberty to make appropriate request before the concerned police authority, and if any request is made by the receiver for police assistance to perform his duty as receiver in terms of this order, the concerned police authority can provide sufficient police support to the receiver to act as receiver in terms of this order.
Grateful, Lordship.
Lordship, I'm appearing on behalf of the defendant.
Yes.
Lordship, I beg apology for delaying in filing the affidavit in opposition.
Affidavit or not?
Affidavit in opposition.
I'm appearing for the plaintiff. This was
plaint filed for recovery of amounts due and payable on the basis of a admission with regard to a check of 80 lakhs which was dishonored. My lord had passed an order in April 2024 which has been extended from time to time. The defendant has not been appearing. Firstly, one person had appeared and had sought time. Thereafter, the particular advocate had not appeared. My lord, my learned friend had appeared on 22nd of November and indicated that the defendant's father was unwell and he had sought some time to he was going to Shillong for treatment and had sought some time to file their affidavit in opposition. My lord, after that, on 20th December, the matter had appeared. Well, in the meantime, I had taken steps to inquire and I had come to learn that a particular property which is owned by the defendant, I had sought leave to file a supplementary affidavit to bring that on record. My lord had granted me that leave by the order dated 20th December. My lord, may I file the supplementary affidavit? My lord, here, my lord, there's an admitted claim in respect of 80 lakh rupees. Along with interest, I have made the claim. My lord, the bank account of the defendant has approximately 32 lakh rupees. That has been indicated by the one of the banks, which is Standard Chartered Bank, Shakespeare Sharoni branch. And my lord, insofar as the remaining amount, my lord, I had already filed a letter of 2nd May 2024. I've already placed that on record. My lord has also recorded that particular letter. And my lord, the remaining amount is could not be traced. So insofar as the remaining amount and on the basis of the conduct of the defendant, I am seeking a prayer of attachment in respect of the particular asset which belongs to the respondent. Because my lord, there was a direction also to furnish the entire amount lying with Standard Chartered Bank with the registered original site. Even that has not been complied.
If you kindly allow me to file the affidavit in opposition.
Who are you?
Lordship appearing on behalf of the defendant.
Sole defendant?
Sole defendant. Lordship, the amount as portrayed in the petition of 80 lakh is false because there is no due of 80 lakh lying with the petitioner at the
What
moment.
is the amount is due?
Lordship,
What is the admitted amount? Tell me.
Lordship, the admitted amount is 35 lakh, which the petitioner defendant needs to pay after the clearance of the customs amount, which is lying with the customs at the moment. And
what is lying in the custom?
Lordship, the security amount, the security deposit is lying with the customs at the moment, and the petitioner has made a declaration. The petitioner and the defendant has made a declaration that once the customs amount gets cleared, then only he is going to clear the entire amount. And in the meantime, the defendant has already paid an amount of 26 lakh, Lordship, and he is in no position to pay back the entire amount right now. And Lordship, as mentioned, the amount of 1 crore 79 lakh is false because the petitioner has paid an amount of 7 crore.
Okay, you give the
7 crore 32 lakh, and the defendant has already forwarded 5 consignments amounting to rupees 6 crore 73 lakh.
Okay, you give the copy. File the affidavit.
I've got the copy with me. If your lordship allow me, I'll serve the copy.
Serve the copy. You serve the supplementary.
My lord, I have already served, my lord.
Served?
Yes.
So and so appearing for the plaintiff. So and so appearing for the defendant. The plaintiff has filed the supplementary affidavit after serving a copy to the learned counsel for the defendant. Have you filed the wakalatnama?
Not yet.
Why?
No, not really.
কি বলছে? Copy of the same to the learned counsel for the defendant. Let the same be kept with the record. Full stop. The defendant has filed affidavit in opposition in connection with GA1. GA-Com 1 of 2024. After serving the copy to the learned counsel for the plaintiff, let the same be kept with the record. Counsel for the plaintiff press for time to file affidavit in reply.
My lord, 7 days. But my lord, the interim order has to be extended.
Within a week from date. Police. Counsel for the plaintiff submitted interim order granted earlier is going to be expired on 27th of January 2025 and prayed for extension of interim order. In view of the submission made by the counsel for the respective parties, अच्छा नहीं उसमें reply बोला Considering submission made by the let the matter appear on.
My lord will kindly grant me 2 weeks time, my lord.
2 weeks further. Let the matter appear on 24th of February 2025. The interim order granted earlier, which is going to be expired on 27th of January 2025, is extended till 28th of February 2025. You file the wakalatam in the department.
Lordship.
Yes.
I am for the plaintiff decree holder. Dependent hai na.
So what is the application for? Decree holder, what you filed?
My application for setting aside of an ex parte decree. In which case, my lord, I become the petitioner.
My lord, kindly see their conduct. Only one line, my lord, your lordship has recorded, my lord. Kindly see it in the order. Page 16, my lord. Page 16, my lord.
Senko.
Senko, my lord.
My lord, let me, my lord.
And again, one application will come.
My lord, kindly see, they have admitted their liability. They asked for time. That kindly, the defendant has sent a reply on such and such where the defendant has stated above. Please give us time so that we can pay by the 30th July. After 30th July, my lord, I have initiated mediation proceeding. They never appeared. Thereafter, they have not. After writ of summons served, they did not appear before the court. According to the original side rules, my lord, they have to appear.
But what is the contention?
No defense, my lord.
What is your defense? Tell me, I will
My
hear
lord,
it out.
Dishonored, my lord.
My lord, the date of the decree, my lord, if my lord sees, is 24th of September 2024. My lord, if my lord comes to page 22 of this application, my lord, is the cause list for the same date, my lord. If my lord remembers, this is also the date my lord had passed orders in that ITC matter as well. My lord, this was certain matters were taken, my lord, with pressing urgency, my lord. In this case, my lord, item number 10, my lord, is the matter where my name was to appear, my lord, in the cause list.
Item number 10.
Yes, my lord.
Yes.
My lord, at page 23, my lord, the first matter. My lord, in this matter, my lord, if my lord notices, my lord, only the name of the petitioner is there. My lord, in this case, my lord, the problem that I will have to apologize, my lord, the advocate on record, my lord, is not someone who is regular in this in the court, my lord, at this point. And my lord had not checked according to the case number and had checked according to the case name. My lord, in this case, my lord, Senko Gold, my lord, if it had been appearing, my lord, it is, my lord, my submission that there would have been an appearance. And my lord, this was the first day that this matter had come up before this court. My lord, in such a case, my lord, it was not possible for my lord, without any orders passed, my lord, there had been no direction for any kind of leave to defend. My lord, if there was any opportunity granted to the petitioner in this, my lord, in this application, my lord,
affidavit in opposition is not.
Nothing, my
No,
lord.
you're not appeared.
My lord,
may I submit,
my lord, this is the.
May I submit, my lord?
I will. Yes.
My lord, for me to appear, my lord, then the matter needs to be taken up. My lord, it was never taken up before this. If my lord,
without the affidavit, this court is never. There's no
My lord, may I
affidavit
submit, my lord?
direction.
Since my lord, kindly see your lordship's order. They have given undertaking, my lord, by their letter. Kindly see
No,
page
that is
16.
letter
On
different.
that basis, my lord, first they do not have any defense, my lord. Checks were dishonored. It is they do
Yes,
not have
kindly
any.
my lord, that is
If they
for
come
that,
with
that is
if they
page
come with any
15,
substantial
page
defense,
50,
my
yes,
lord,
my lord,
paragraph.
only the reason, my
Date
lord.
of summon and the same was served upon the defendant on 15 July. Inspector receipt of the date of summon. Neither defendant nor its representative appeared in the suit. Subsequently, plaintiff has filed praying for judgment upon admission.
My lord, this
The
was
present
possibly an
application was
order
also
under
served
Order
upon
30.
the defendant on 2nd August 2024, but in spite of receipt of notice, how are you telling that without the notice and without the chance?
My lord, the notice, my
The
lord.
court, this court, though passing an order, but without giving an opportunity, this court is not
My
passing
lord,
such orders, sir.
without opportunity, my lord, I was given notice of the application itself, my lord, but not an opportunity to defend.
What,
the
you're not appeared with the court will go to your house?
No, my lord.
Then,
My lord,
what is the meaning of opportunity?
my lord,
Notice is to be given to the person for informing the date.
Yes, my
If the notice has been given, you're not appeared, what further opportunity is required? The court will shift to your house or your showroom.
My lord, none of that, my lord.
Kindly see, my lord, page 20, my lord. This was the last information, my lord. Page 20. Please find enclosed with a copy of application along with master summons filed on behalf of the plaintiff. The matter will appear in the list before your lordship on 20th September. And 20th September, they are entitled to watch the list. A matter was taken up on 24th, my lord. So this plea cannot be done, my lord. And unless they file
You will
wakalat,
file affidavit.
no, my lord. Unless they file wakalatnama, my lord, their name will not appear in the list.
That's
my
correct.
lord.
That is the marriage.
They have not filed.
He has filed an application. What is the submission? You want to file affidavit?
My lord, may I submit, my lord? In original side rules, my lord.
Sir, that's correct. I appreciate. That's why this court is taking the affidavit of service and passing an order, taking into consideration CPC and original side order. Now he has filed an application under Order 9, Rule 13 of the CPC for setting aside the ex parte decree or order, whatever it may be. Now you want to file affidavit. You file affidavit. You want to argue the matter, then I will hear the matter. Up to you. The court is not disclosing the mind now.
But may I file? May I file? Can you give me 2 weeks time? Or my humble prayer is, my lord, one thing, my lord, can you consider, my lord? My lord, I am a small jeweler, my lord. And
so you do one thing.
My lord,
you
yes,
tell
my
your
lord.
client to deposit the amount. I am allowing this.
Humble prayer is, my lord. Let them
My lord,
deposit
I
the
shall
amount,
come
my
back
lord.
Then go to let the deposit the said amount. I am allowing this. You contest the suit. He will not withdraw the amount. It will be in the fixed
Yes, ma'am.
deposit. If they will lose, you will
After
get the interest.
disposal of this application, I will withdraw.
My lord, let me come back with that, my lord.
Correct. I am fixing the Friday. Take instruction. What is the amount? What is the decretal amount?
My lord, approximately 31 lakhs.
31 lakh.
For one ornament, my lord, they are getting 31 lakh. And they are displaying
Nothing. 31 lakh. You will not get the 1 gram finger ring.
one ornament. And my lord, kindly appreciate, my lord, when I sold them the gold ornament, the price was 63,000 per gram. Now
Okay,
it is,
you do
my lord,
one thing.
now
I am
today,
fixing on Friday.
Yes, ma'am. Great.
Take instruction. If your client is ready to deposit this amount,
I shall
let
come
the
back.
deposit, and this they will not enjoy. This will be in the court fixed deposit. If you will win, you will take the amount along with the interest. If they will win, they will take the interest.
Great,
Take.
my lord, the affidavit. Affidavit of service, my lord.
on Friday, my lord, let them come on Friday with the
Friday I am fixing. So and so suffering for the plaintiff, so and so suffering for the defendant. Defendant has filed the present application being GA Com 2 of 2025, praying for setting aside the judgment passed by this court dated 24th of September 2024. Setting aside the ex parte judgment. Okay, dated 24th September 2024. Full stop. Counsel for the and the plaintiff, the defendant has filed affidavit of service. Let the same be kept with the record. Counsel for the defendant prays for 2 days time for taking appropriate instruction. In view of the submission made by the counsel for the defendant, let the matter appear on 24th January under the same heading.
Grateful, my
Come on that.
I shall do that.
Bring the amount.
They have already earned 20,000 per gram from my goods, my lord.
That's
They've
why I am
already earned.
telling. Let they come. He deposit the amount. So he will get the. Then you will get the opportunity.
My lord, my application, my lord, I beg to appear online. My application for judgment upon admission. If your
Yes.
lordship kindly takes page
I-
23.
Pay.
My lord, I am led by Mr. Bhattacharya in this
I
case.
am appearing for the defendants, madam.
Here is the affidavit of service.
File affidavit in opposition.
Why you not paying the amount?
Clear
They are
admission.
telling that you have admitted the amount.
PDC is dishonored.
That I have to take
Plethora
instruction.
of
When you will pay?
That I have to take instruction.
You will file affidavit.
Or
File affidavit.
Yes, madam.
May I just show a couple of documents, my lord, whether it would be necessary or not? My lord, just 1 or 2 documents. For my satisfaction.
Acharya, I will record your name. I will record that you argued the matter at length, but it is a suffering for the plaintiff, suffering for the defendant. Full stop. The plaintiff has filed an application and
Order 12, Rule 6.
Order 12.
Yes, my lord.
Order 12, Rule 6.
Order 12, Rule 6.
Order Code of Civil Procedure for judgment upon admission. Full stop. Counsel for the plaintiff submit that there is no defense submitted from the record itself shows that the defendants have defendants have admitted
Defendant, my lord, that is the directors have been made parties. Technically, they are not required to.
and the check issued by the defendants have already been dishonored. Thus, there is no defense of the defendant, and as per the record, it is crystal clear that the defendants have admitted the claim of the plaintiff. The learned counsel for the defendant prays for time to file affidavit in opposition. May the time be made only for the purpose of giving an opportunity to the defendant. Time to file full stop. The defendant is directed to file affidavit in opposition by 2 weeks. 2 weeks. Reply, if any, there to be filed within 1 week. Yes, my lord. In 1 week. Full stop. Release the matter on 25th February. Under the heading adjourn motion. Next.
Now, the plaintiff has instructions to withdraw the suit.
And I can't oppose this, but I was led by Madam Manot Millard, Madam Manju Agarwal. Mother has passed away. Kindly keeps it next week.
But I'm withdrawing the suit. I'm
Kindly
not
see,
wanting
Millard,
liberty to file afresh.
No.
I want to
The
withdraw the
only
suit.
point is, Millard, let it happen under her presence. And my learned colleague Millard has waited for some time. He can wait for one more
When
week.
will be available?
Next week.
But I am not praying for any liberty to file afresh.
Because Millard, the last order
withdraw
records
the suit. Simply
last order
withdraw.
Millard, records something which may require attention and
Whatever
clarity.
the parties have settled, I want to withdraw. They don't have a counterclaim. They don't have a counterclaim. I want to withdraw my suit.
It required parties, Millard, to take certain steps.
Come next week.
But I want to. I don't
Okay,
want
no
to liberty
problem.
to file
But
afresh.
on the last occasion, you are not there, Mr. Gupta.
Hey, last
Because they have stated that yes, Mr.
But I have been instructed by an email that there's an
that's
MOU.
correct. That's correct.
This terms has to be there before
Where is
the
the
court.
MOU?
Because that's the direction.
No, that is. Well, may I humbly say?
This is the last order. Have you gone through the last order?
I want to simply say I don't want a consent decree. Then something else could have been there.
Okay, no problem. I am fixing it next week. Because there is some personal difficulty, nothing else. So appearing for the plaintiff, so appearing for the defendant. Police plaintiff, counsel for the plaintiff submit that he has received a written instruction from the plaintiff that the plaintiff do not want to proceed with the matter and prays for withdrawal of the suit. Counsel for the plaintiff submit that the arguing counsel is having some difficulty to appear before this court and prayed for fixing the matter on the next week. In view of the submission made by the counsel for the plaintiff, let the matter appear on 5th December. No, these are commercial, na? 7th February.
Deeply obliged.
Wait, please, Your Lordship. I appear for the plaintiff. This is the second subway suit.
I'm appearing for the defendant number 1, my lord.
I'm appearing for defendant number 2.
My lord, the thing is, pre-termination notices are sent. It is like a warning that please correct this defect. These are the defects. So if we don't send a pre-termination notice, any store will run in any manner whatsoever.
Correct.
Then our defense of running a store in a global standard goes. So how can we injunct it from sending a pre-termination notice? It is not even a termination. There have been a termination before also, but they have never come across. So
my situation, Lord, is slightly different. I have, as defendant number 2, nothing to do with this quarrel at all. I supply to the plaintiff on the instructions of defendant number 1. Now, my lord, what has happened here is that there is no contract, no privity of contract between the plaintiff and me. Now, under this judicial order, they are forcing a term upon me, which is not there in the contract because there is no contract. They want to me to supply on credit, whereas I am saying that I will supply to you. I have no problem. I want to buy, sell, you want to buy. Please pay advance, because if their dispute goes somewhere else, I have no recourse. Who will pay for my goods? That is my concern, my lord. So therefore, I am very respectfully praying that my lord's order may be either vacated against me or it should be modified to somehow secure me. My concern is only this, that my money should be secured for the supplies that I will be making to the plaintiff. That's my submission.
So as per your submission, this is not the termination notice.
this is the
I am recording your submission and vacating this. These are not termination. They are not going to terminate. And before the termination, you will give an opportunity. You will give the notice.
Or if they don't comply with the pre-termination, anyway goes out of the window.
I am recording the submission. This is not a termination.
The pre-termination notices were on the basis that I have not remodeled. But, my lord, your lordship will remember that they had agreed to buy on an as-is whereas basis without my remodeling.
My lord,
They had given me that valuation of 3 crores 60 to buy my 8 stores.
that is not at all an agreement, my lord. If you, my lord goes through the
May I
page
complete?
seven-
May I
seven-
complete?
Yes.
So, my lord, once they agreed that they will buy my 8 stores for a value of 3 crores 60 lakhs, my lord, on an as-is whereas basis, my lord, and then they issue a pre-termination notice saying that I have not remodeled it. Second is, my lord, as soon as the pre-termination notice is issued, the defendant number 2 stops the credit facility. Now, my lord, pre-termination notice here is in respect of 4 stores. Defendant number 2, what he has done is he has cancelled the credit period for all the 8 stores.
My lord, there is no contract between us. So how can my learned friend complain that I am doing this or that? Because I can put whatever terms I like, because there is no contract between us. So I am not violating any term of the contract, and I should be secured for the supplies which I made. That is my concern.
That's not
my learned friend is not addressing that.
Court has not passed any order.
Yes, my lord, I understand.
Regarding you,
Yes.
with supply of anything.
No, my lord, because my lord has said that they are insisting, my lord. My client got a letter from there.
That's no order. Because what the court has passed an order. Restraint for giving any further effect or to pre-termination notice. Nothing else. This court has not passed an order to supply the materials or supply the goods without any nothing. There is
Very well,
nothing
my lord.
on there.
My lord,
And my lord, second is, apropos what my learned friend for the defendant number 2 has submitted, he has not said that I have defaulted in making payments.
He is telling that you are telling with regard to this court has passed the interim order only with regard to the pre-termination.
Once the pre-termination notice.
This court has not passed any order with regard to defendant. You have to pay, not to pay, and you have to supply. That is not the court has not adjudicated that, and that court has not passed any order to that effect. This court, you have prayed for an interim order with regard to the pre-termination notice. The pre-termination notice has been installed.
My lord,
correct.
My lord, in fact, I'm sorry, ma'am. Just one thing I want to point out. Now that my lord has clarified this, I'm a bit surprised because the solicitor who is representing the plaintiff has written a letter to my client saying that if you do not supply on credit, you will be guilty of contempt. My lord, I have that letter.
That is different thing. That is different thing.
my lord, on the document which is based on, which is at page
Okay, you do one
77.
thing, madam. You do one thing. Have you filed the affidavit?
No,
No,
this is
we-
coming after first.
Affidavit. I am fixing a short date. Come with an affidavit. You decide expeditiously. No problem.
Obliged.
Already interim order is
Because,
there.
just one thing I would like to point out. The offer we have made, it's called a NBIO, non-binding indicative offer.
That's why. That's why.
It's the term
This
itself
court.
is
This
good
court
enough
has already gone through, but it is final 3,60,000 not binding. But you are agreed for the 3 crore 60 lakhs, and subsequently you are telling that no, it is to be remodeled. If the 3 lakh, see, suppose
Remodeling has been there in the website since.
yeah, that may be. Suppose I wanted to purchase this thing, and amount has been fixed, then you cannot say no, this is to be, then you have to fix the AC and you have to fix this, then that concept this court has taken into consideration and passed the interim order.
I completely understand, my lord, but it was never finalized. The
Okay.
NBIO order business transfer.
Okay, come with the affidavit.
My lord, may make one observation vis-a-vis me, my lord, that I am under no
I am not going to any change in this, otherwise it will be amount to the modification. So
But I have served, my lord.
Census suffering for the affidavit of service filed. Census suffering for the plaintiff, census suffering for the defendant number 1, and census defendant number 1.
Yes, ma'am.
And so we are for the 2.
Yes.
What about the other?
My lord, I may be allowed to file my affidavit just for the formalities. And also, we have not received the writ of summons in the suit.
Writ of summons you will get. Kevin? Full stop. The counsel for the plaintiff has filed affidavit of service. Let the same be kept with the record. Full stop. The defendant number 1 and 2 press for time to file affidavit in opposition. Let affidavit in opposition be filed by
3 weeks, my lord.
3 weeks, comma, reply if any there to be filed within 1
Lord
week.
gives me 2 weeks because
2
I have
weeks.
I have 2 affidavits.
Within 2 weeks thereafter. Full stop. Let the matter appear on Let the matter appear on 28th of February 2025 or until full stop. The counsel for the plaintiff submit that the interim order granted earlier is going to be expired on
today.
Expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 4th of March 2025 or until further order, whichever is available. Come on.
My lord, I have nothing to show that my client will not be committing contempt if he does not pay back that.
Come, let the file, we'll see that.
Very well.
3 बजे का matter नहीं.
My lord, I appear on behalf of the petitioners.
Yes.
My lord, during the last occasion, my lord had directed
Item number
16. I appear on behalf of the plaintiffs. My lord, during the last occasion, my lord had directed the defendants to file their affidavit in opposition.
Your Lordship, the matter has become infructuous. It was relating to letters of credit. Your Lordship may remember just before vacation it was moved. We had cited the UCP 600 that the bank was supposed to make payment. The payments have been done. Your Lordship may see the prayer.
My lord,
None of the prayers can be granted.
My lord, if you just check the last order, if I draw your attention to the last order, my lord had not set aside the GA1. It was just the initial finding that the
No,
my
Your
lord
Lordship,
given-
it was
direction
now
was
it is
given them.
infructuous.
Direction was given them to file an opposition. They may say that there's an opposition.
Yes.
They may say that in their
This
opposition.
court has not granted the identity injunction.
That's right.
Correct.
Yes.
Not granted. You revoked whatever it may be. If you wanted to file your affidavit, if not, I will record your submission, then I will hear without the affidavit.
No, because Your
Very
Lordship,
well, my
the
lord.
only predicament was that there is an arbitration clause. We wanted to file a Section 8, but we could not get an apostille. It's a Singapore-based company. From the Indian embassy, we could not get the apostille.
You
in
not
time.
file the affidavit. This appeal, you are not prepared an appeal.
No, my lord, we haven't.
Because Your Lordship,
My lords,
the
they might
money
say-
has already gone.
So my lord, they might say that in the
So
opposition.
if you say that you will not file affidavit, I will record and I will fix the matter for
Very well, my
hearing.
lords.
Then-
If you say that you want to extension of time to file affidavit, I will grant
But
time.
Your Lordship may then take my prayer for filing a Section 8 application because
That
I do
you-
not
My lords, that
wish
cannot
to.
be.
So
That
this
Your
cannot
Lordship
can-
knows I
that
do
cannot
not
be
want to
decided,
file
my
any.
lords.
I do not want to file an
regarding
affidavit
what
because
application you want
yes,
to
Your Lordship.
file.
Your Lordship may only record my submissions on that.
So and so suffering for the plaintiff, so and so suffering for the defendant. Police counsel for the defendant submit that in view of the order passed by this court dated 23 December 2024, wherein this court refused to grant ad interim order, and as such, the application filed by the plaintiff being GA number 1 of 2024 has become infructuous. Full stop. Counsel for the plaintiff submitted, though this court has refused to grant ad interim injunction but has directed the defendant to file affidavit in opposition, but till date the defendant has not filed affidavit in opposition. Police counsel for the plaintiff defendant submitted, the defendant will not file affidavit in opposition, but they will take appropriate steps for filing an application under Section 8 of the Arbitration and Cancellation Act. Considering the submission made by the counsel for the plaintiff, this court is of the view that the defendant is not intending to file affidavit in opposition. Let GA1, 2024 be placed for hearing under the heading adjourn motion on 14th of February 2020.
Very well.
Grateful.
Much obliged.
Okay. Next. What is the chamber application?
My Lord, GA2 is my application, my Lord. It's an application for amendment of the cost title, my Lord. The defendant's addresses were incorrectly placed in the cost title, and the writ of summons which had been lodged by us had returned. We have obtained the report from the Sheriff's Department, my Lord. The amendments are procedural in nature, my Lord. If your Lordship takes GA2,
Page 16, only the cost title?
yes, my Lord, only the cost title. My Lord, if your Lordship takes the pleading at page 6, para 16 at page 7, the defendant number 1's cost title, it's a proprietorship concern. We want to incorporate the new address that we have found of the defendant number 1 proprietorship business and the residential address of the proprietor. And my Lord, as far as the defendant number 2 is concerned, Lord, if your Lordship takes para 22 at page 9. Well, the defendant number 2 was in CIRP and has now been resolved. Resolution applicant had come forward, my Lord. The resolution applicant has taken over the company. The registered office is now changed. My Lord, we have obtained it from the master data of the company, my Lord. My Lord, if your Lordship takes page 58, we have annexure X. It is the amended plaint. The amendments are at page 62. It's just the cost title of page 62, my lord.
Yes, I'm there.
My lord, if these amendments can be allowed, then fresh writ of summons has to be issued, my lord, after affirmation, reaffirmation, and re-verification of the plaint.
Since suffering for the plaintiff. Plaintiff has filed the present application being GA Com 2 of 2025, praying for amendment in the cost title of the defendant number, cost title with regard to the address of the defendant number 1 and 2, as well as in paragraph 2, as well as in paragraph 2, 3, 2 and 3 of the plaint. Consider the submission made by the counsel for the plaintiff. Peruse the proposed amended application. This court find that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Accordingly, prayer A to D of the master summon is allowed. GA2 is displayed. DPU.
My lord, in this suit, my lord, the right to file written statement, my lord, has been lost. My lord, your lordship's order, my lord, if your lordship kindly sees, my lord, compilation of orders, though. My lord, I have a compilation of orders. My lord, kindly take, my lord, page, my lord, 34. My lord, it's an order dated 14 June 2024, my lord.
Yes.
My lord, kindly come to, my lord, paragraph 1. My lord, sorry, my lord, para 3. My lord, at page 34, defendant has filed the present application, praying for leave for filing written statement by defendant number 1 within a period of 120 days or such other time as may deem fit and proper in connection with. Now, kindly come to page 38, my lord, after considering the facts of the case. My lord, 38, fourth line. In the case reported in 2022 SCC, the Honorable Supreme Court has categorically held that the judgment passed by the Honorable Supreme Court in the case of so-and-so, reported in so-and-so, time for filing written statement in commercial suit is mandatory in nature and courts lacks direction to condone the delay for filing. Honorable Supreme Court in the case of SCJ contracts categorically held, court has no powers to extend time period. In the present case, admittedly, defendant not filed, though it is affirmed on 15, but affirmation is irrelevant. Defendant number 1 has filed application on 13 June 2023, that is after the period, and as such, this is viewed as not filed. Such, this court has no powers to allow defendant number 1 to file written statement. Accordingly, application stands dismissed. Now, my lord, there are certain consequences to this. We আগের অর্ডারটা দাও তো যেখানে ফিক্স করেছিল order 8. My lord, kindly come to, my lord, the next, my lord, order, my lord, 9th of July. My lord, third paragraph, my lord, page 39.
Yes.
Counsel for defendant draws the attention of this court to the order dated 14 June, wherein this court has dismissed the application being GA filed by for extension of time. Counsel for plaintiff prays for fixing the matter so as to enable the plaintiff to argue the matter on merit for grant of degree in terms of Order 8, Rule 10 of the court. Learned counsel has drawn attention of this court to the orders dated so-and-so and prayed for time to file affidavit in terms of the said orders. The court has granted time to defend to file, but till date has not been found. Let the matter appear under the heading so-and-so. So, my lord, lordship will find, my lord, that this is, and then, my lord, they, my lord, filed order 7 rule 11. Then they filed, my lord, GA6, my lord, page 41, my lord, page 41. Defendant number 1 has filed an application praying for dismissal or in the alternative to return the plaint, affidavit, etc. And, my lord, the order of dismissal, my lord, is at page 47. My lord, 11th of November, my lord, 2024. My
Yes.
lord, Order 7, Rule 11. My lord was dismissed. Kindly come to page 52. My lord, where your lordship, my lord, discusses, my lord. And my lord, lastly, my lord, para 24. My lord, para 24, in the present case, the plaintiff has prayed for perpetual injunction against and the suit at declaration, settled law, that part of the plain cannot be. This court is with regard to an issue which can be decided in is disposed of. So, my lord, Order 7, Rule 11, my lord, also fails. Now, my lord, again, we are pressing for, my lord, judgment in line with, my lord, Order 8, Rule 10. Now, my lord, one aspect, my lord, your lordship kindly sees, para 17, my lord,
Para
page, my
17
lord,
of?
50 of this order, my lord, page 54.
Yes.
Now, my lord, section 21C, commercial code definition, etc. Partnership agreements. Then
Yes.
this court finds that the present case is relating to distribution of shares of deceased Dinobandhu Mondal, who was one of the partners of the plaintiff firm. In terms of clause 17 of the partnership deed, plaintiff has decided to distribute the shares to his, out of which two of the sons have accepted, calculated by but the defendant number 1 has not accepted and disputed with regard to his share. The issue in the present case is with regard to interpretation of clause 17 of partnership deed regarding distribution. Thus, the case is covered. So, my lord, this is, my lord, and the only issue here today, my lord, is, my lord, interpretation of clause 17, my lord, of the partnership deed. My lord, what would be the entitlement, my lord? Now, my lord, kindly have a look at the amended plaint. No. My lord, kindly, and my lord, page 53, your lordship has quoted in para 16, my lord, clause 17.
Yes.
My lord, of, my lord, the partnership deed, the death or retirement of a partner shall not dissolve the partnership, but the partnership shall be carried on by the surviving partners. The partnership account shall be made up after 2 years from the date of death, retirement of a partner, but within 3 years from the said date, the share of the deceased or retiring partner in the outstanding bills upon the date of his death, retirement, which have been realized within a period of 2 years from his death, retirement, less the cost of realization assessed at 30% of the amount realized on these bills, shall be paid to the retiring partner or the legal representative of the deceased partner on account of his share of, kindly note, profit and goodwill of the firm. So, my lord, on account of profit and goodwill, my lord, computation is provided in the partnership deed clause 17 itself. The amount payable for the share of profit and goodwill of the deceased partner to be calculated in the manner aforesaid shall be determined and then paid in the manner decided by Dinobandhu Mondal in his absolute discretion, and the heirs of the deceased partner or retiring partner shall not be entitled to raise any question. So, my lord, computation method is provided, and my lord, one of the partners, my lord, at the time of, my lord, in this particular deed, Dinobandhu Mondal was to decide. Now, here, my lord, Dinobandhu Mondal has, my lord, expired. So, it is to his sons. My lord, that, my lord, his heirs, my lord, that payment has to be made. And, my lord, this is as per clause 17. And the interpretation of clause 17 is involved, my lord, in this case. There is, my lord, no dispute as to facts. And, my lord, I just want to point out, my lord, 2 paragraphs in the affidavit filed, my lord, by, my lord, the defendant number 1. That's, my lord, the only son, my lord, who is disputing, my lord, what has been computed. Other 2 sons have taken, and, my lord, there's no problem. My lord, the same amount. Now, kindly come to, my lord, in, my lord, GA1, my lord, which is before your lordships, my lord, the affidavit of defendants, my lord, which have been filed, defendant numbers 1 and 2, my lord, para 6G.
Arun Mandal?
No, my lord, this is, my lord, an affidavit of, my lord, Somobroto.
Formed on 31st January 2023. In GA1.
31st January.
Yes. My lord, kindly take 6G at page 7.
Yes.
I say that the documents annexed to the said petition would show that I always tried to settle the accounts relating to the share of my deceased father who was a partner of the plaintiff firm, kindly mark this, in terms of clause 17 of the deed of the following correspondence, etc. Then, my lord, kindly come to I, my lord, at page 8, 6I. While I was consistently requesting the plaintiff firm and its partners to hold the fund and disburse upon discussions with all stakeholders, they disbursed funds to my brothers on the basis of an alleged settlement arrived and behind my back. It is the contention of the plaintiff firm that in respect of the entitlement of the legal heirs of Dinobandhu Mondal, I am entitled to receive rupees 89,89,000 being share of balance lying in the capital account of late Dinobandhu Mondal in the firm as on 30th June. The plaintiff further contended that between July 2020 and June 2022, that is, my lord, 2 years from the date of death, my lord, a sum of 3 crores could be realized, out of which 30% should be deducted as cost. Accordingly, in terms of partnership deed of 2014, a sum of 58,58,000 has been allocated as an amount payable to the estate of Dinobandhu Mondal, and on such basis, the plaintiffs determined rupees 17,14,501 to be my entitlement in this regard. However, no amount of now, my lord, kindly note this. However, no amount of goodwill has been offered to me. Thus, the plaintiffs have been seeking to deprive the legal heirs of Dinobandhu Mondal, including me, in respect of the entitlement of Dinobandhu Mondal on account of goodwill, which is contractually payable. So, my lord, the calculation, my lord, was of profit and goodwill, which we, my lord, offered. He says, no, goodwill has to be separate, but contract provides for it. And the only contractual clause, my lord, is clause 17. Which, my lord, mentions, my lord, that sum to be both profit and goodwill. Correct. So, my lord, that's the interpretation. Is there anything more? And, my lord, I've shown. Now, my lord, kindly come to, my lord, the amended plaint. Achha. My lord, kindly have a look at, my lord, KT character copy. Kindly have a look at, my lord.
Amended plaint. Amended plaint.
Decree. Declaration that defend number 1 is entitled.
Page?
My lord, sorry, my lord, page 15.
50.
15, my lord, 15. Just the praise I want.
Yes. Declaration the defend number 1 is
entitled to this. That's the figure, my lord, which is mentioned in, my lord, paragraph 6I. And, my lord, declaration is only entitled to claim in terms of clause 17. This is an admitted position. Because in his para 6 G and I, my lord, he stated that. And, my lord, from claiming any amount of money against share of so-and-so other than as pleaded in so-and-so. And decree restraining him from claiming anything. So, my lord, this is, my lord, the suit is, my lord, is this what he is only entitled to? Correct. And, my lord, that, my lord, we are, my lord, willing to pay. And, my lord, there's no dispute. Others have accepted this. So, my lord, this is, my lord, what we say, my lord, he's entitled to. And, my lord, in para 22, your lordships will find, my lord, the breakup, my lord, we have, my lord, given at page 11. The same amount, my lord, which he mentioned.
89,
my lord, 89 and 17 lakhs. Now, my lord, kindly take a few provisions of, my lord, the code.
So that's why you are not mentioned with regard to the goodwill in that breakup. He is asking for the goodwill.
in terms of clause 17.
We said, my lord,
where is the breakup of goodwill?
Now, my lord, kindly come to, my lord, order 8. My lord, rule 8 commercial code. Commercial code. Amarta kothay. Sir. My lord, kindly take, my lord, order 8. My lord, in the Commercial Courts Act, kindly take the schedule, my lord. My lord, kindly see the amendments, my lord, which have been introduced.
Yes.
My lord, kindly take, my lord, clause 4, which is amendment of the first schedule to the court. Kindly take D, my lord, of that, 4D.
Order 8.
In order 8.
Correct.
Now, my lord, kindly take subclause 2. My lord, after rule 3, the following rule shall be inserted, namely, this was a commercial suit, my lord, already, my lord, held to be so by your lordships.
Yes.
My lord, denial shall be in the manner provided in sub-rules 2, 3, 4, and 5 of this rule. Then, my lord, the defendant in his written statement shall state which of the allegations and the particulars of the plaint he denies, which allegations he is unable to admit or deny, but which he requires the plaintiff to prove, and which allegations he admits. Where the defendant denies an allegation of fact in a plaint, he must state his reasons for doing so, and if he intends to put forward a different version of events from that given by the plaintiff, he must state his own version.
Yes.
If the defendant disputes the jurisdiction of the court, he must state the reasons, and if he is able or give his own statement as to which court, so and so. If the defendant disputes the plaintiff's valuation, he must state his reasons for doing so, etc. Then, my lord, kindly come to, my lord, order 8, rule 5 now, my lord.
Order 8, rule 5.
My lord, if your lordship keeps the code without the amendment, and my lord, with the amendment as well,
Yes.
my lord, kindly see, my lord, every allegation of fact in the plaintiff not denied specifically or by necessary implication, or stated to be not admitted in the pleading of the defendant, shall be taken to be admitted except as against a person under a disability, provided that the court may in its discretion require any fact so admitted to be proved otherwise than by such admission. Now, my lord, kindly see the proviso introduced by, my lord, the schedule. Provided further that every allegation of fact in the plaint, if not denied in the manner provided under Rule 3 of this order, shall be taken to be admitted except as against a person under a disability. Now, my lord, he is not a person under a disability. And in a commercial suit, my lord, this, my lord, is, my lord, it is taken to be, my lord, admitted.
Yes.
Unless, my lord, and then, my lord, in, my lord, now kindly take order 8, rule 4. My lord, kindly see. My lord, order. Judgment. Yes. Now, my lord, kindly take, my lord, 3. Yes, my lord. Now, my lord, kindly take 2, where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of facts contained in the plaint, except as against a person under a disability, but the court may in its discretion require any such fact to be proved. Then, my lord, 3, in exercising its discretion under the proviso to sub-rule 1 or under sub-rule 2, the court shall have due regard to the fact whether the defendant could have or has engaged a pleader. Then, my lord, 4, whenever a judgment is pronounced under this rule, a decree shall be drawn up in accordance with such judgment, and such decree shall bear the date on which the judgment was pronounced. So, my lord, here, my lord, there is no question of fact involved. My lord, it's only an interpretation, and that, my lord, judgment is binding inter partes. Now, my lord, kindly have a look at, my lord, 10, order 8, rule 10, where any party from whom a written statement is required under rule 1 or rule 9 fails to present the same within the time permitted or fixed by the court, as the case may be, the court shall pronounce the judgment against him or make such order in relation to the suit as it thinks fit, and on the pronouncement of such judgment, a decree shall be drawn up.
Yes.
Now, my lord, here, my lord, the only issue, my lord, is he entitled to anything more
Further.
on account of, my lord, goodwill? Now, kindly have a look at clause 17 and the fact, my lord, that, my lord, what he claims, he says, my lord, is, my lord, contractually payable. Now, the deed of partnership clause 17, my lord, in the order, my lord, passed by your lordships, my lord, at my lord, the order compilation, page my lord 53, if your lordships kindly read it once with me.
Yes.
The death or retirement of a partner shall not dissolve the partnership, but the partnership shall be carried on by the surviving partners. The partnership accounts shall be made up after 2 years from the date of death / retirement of a partner, but within 3 years from the said date. The share of the deceased or retiring partner in the outstanding bills upon the date of his death retirement, which have been realized within a period of 2 years from his death / retirement, less the cost of realization assessed at 30% of the amount realized on these bills, shall be paid to the retiring partner or the legal representative of the deceased partner on account of what? His share of the profit and goodwill of the firm. Then, my lord, so goodwill is covered under this. The amount payable for the share of profit and goodwill of the deceased retiring partner to be calculated how? In the manner aforesaid, shall be determined and pay, and then disbursement and paid in the manner decided by Dinobandhu Mondal in his absolute discretion. So, my lord, determination is, my lord, as per the clause.
Correct.
Manner of payment, my lord, whether installments or anything, my lord, Dinobandhu Mondal was to decide. But, my lord, here Dinobandhu Mondal has, my lord, died. We've come to court, my lord, saying, my lord, we are ready to pay, my lord, this amount. And in his absolute discretion, and heirs of the deceased partner or the retiring partner shall not be entitled to raise any question or objection thereto. Now, my lord, this is, my lord, what is, my lord, due and payable on account of, my lord, both goodwill and, my lord, profit, share of profit.
Yes.
Now, my lord, the case which has been run, my lord, in para 6I at, my lord, page, my lord, 8 of the affidavit also admits, my lord, that, my lord, goodwill, my lord, what is to be paid on account of goodwill, my lord, is, my lord, not pursuant to any statute or any, my lord, common law, but, my lord, which is contractually payable. My lord, at page A9 of the affidavit in opposition, my lord, it starts, my lord, at page 8, 6I. My lord, kindly come to. However, my lord, last 5 lines of I, however, no amount of goodwill has been offered to me. Thus, plaintiffs have been seeking to deprive the legal heirs of Dinobandhu Mondal, including me, in respect of entitlement of Dinobandhu Mondal, on account of goodwill. And, my lord, how is it payable? Which is contractually payable, which is clause 17. There's no other contractual clause. In fact, this is also, my lord, recognized, my lord, in 6G. I say that documents annexed to the my lord, at page 7 of that would show that I always tried to settle relating to share of my father who was a partner in terms of clause 17 of the deed.
He is relying upon only telling that you have not given the goodwill.
Yes, and, my lord, I have calculated
as per the contractual case.
And, my lord, this is, and there is no, my lord, no, my lord, allegation that, my lord, calculation is wrong. It is, my lord, based on, my lord.
That's why he has not given any his contract claim.
Yes.
He has not given his contract claim. No, I am
nothing,
not entitled to
nothing,
89. I am entitled to 2 crore. Whatever.
I'm grateful. Now, my lord, if that is the situation, then in my respectful submission, my lord, yeah, my lord, whatever discretion is there, my lord, under Order 8, Rule 5 and Rule 10, my lord, has to be exercised, my lord, against him and in favor of the plaintiff. One, because, my lord, there's no disputed question of fact. Second, my lord, it's an interpretation, my lord, of, my lord, clause 17. That, my lord, determination is final between, my lord, parties, inter-parties, and, my lord, there is, my lord, no other claim, my lord, which he, my lord, has foisted, my lord, by way of a counter claim, my lord. He has no right, my lord, really, my lord, to file a written statement. Now, my lord, kindly take, my lord, the Supreme Court decision, my lord, 2012, 5 Supreme Court cases, 265. এতগুলো স্টাইল করে ফ্ল্যাগ লাগিয়ে আনো এটা কি দিচ্ছ? 2012 5 Supreme Court cases, page 265. C.N. Ramappa Gowda versus Chandra Gowda.
2012?
My lord, 5 Supreme Court cases, 265. You have a copy here?
Yeah, yes.
Hmm?
Yeah.
What is the paragraph?
My lord, it's my lord paragraph, my lord 25 to 27.
Yes.
My lord, I'll get a. This is unbelievable. It comes physically for the. My lord, kindly, my lord, may I hand up, my lord, from here? My lord, it's slightly marked.
Yes.
Now, my lord, this was, my lord, on, my lord, the basis of order 8, my lord, that, my lord, judgment had been, my lord, prayed for. My lord, kindly see para 25. We find sufficient assistance from the apt observations of this court extracted here and above, which has held that the effect of non-filing of the written statement and proceeding to try the suit is clearly to expedite the disposal of the suit and is not penal in nature, wherein the defendant has to be penalized for non-filing of written statement by trying the suit in a mechanical manner by passing a decree. We wish to reiterate that in a case where written statement has not been filed, the court should be a little more cautious in proceeding under Order 8, Rule 10, CPC, and before passing a judgment, it must ensure that even if the facts set out in the plaint are treated to have been admitted, a judgment and decree could not possibly be passed without requiring him to prove the facts pleaded in the plaint. Now, my lord, we have an advantage here. The facts pleaded in the plaint were also pleaded in the petition. And, my lord, there is an affidavit here from his end. But, my lord, more than that, there is, my lord, a determination by the court, second, in the, my lord, Order 7, Rule 11, my lord, proceedings, my lord, which, my lord, for extension of time to file written statement, that, my lord, there is, my lord, only issue, my lord, is interpretation of clause 17, which is, my lord, a question of law. Now, my lord, 26, it is only when the court, for recorded reasons, is fully satisfied that there is no fact which needs to be proved at the instance of the plaintiff in view of the deemed admission by the defendant. Here, my lord, it's explicit also. The court can conveniently pass a judgment and decree against the defendant who has not filed the written statement. But if the plaint itself indicates that there are disputed questions of fact involved in the case arising from the plaint itself, giving rise to two versions, it would not be safe for the court to record an ex parte judgment without directing the plaintiff to prove the facts so as to settle the factual controversy. In the event the ex parte judgment, although may appear to have decided the suit expeditiously, it ultimately gives rise to several layers of appeal after appeal, which ultimately compounds the delay in finally disposing of the suit, giving rise to multiplicity which hardly promotes. However, if the court is clearly of the view that plaintiff's case, even without evidence, is prima facie unimpeachable, and the defendant's approach is clearly a dilatory tactic to delay the passing of a decree, it would be justified in appropriate cases to pass even an uncontested decree. What would be the nature of such a case ultimately will have to be left to the wisdom and just exercise of discretion by the trial court who is seized of the trial of the suit. Now, my lord, here, my lord, 4, my lord, important issues, my lord, I mentioned. My lord, 1, my lord, they have admitted, my lord, that clause 17 is applicable, my lord, for determination of this issue.
Yes.
Second, in any view of the matter, the court itself has held, my lord, all that is, my lord, involved, my lord, in determination of the suit is interpretation of clause 17, my lord, of the deed of partnership, the reconstituted deed of partnership. Third, my lord, if that is the case, third, my lord, there is, my lord, no other case, my lord, as to what amount is payable on account of goodwill.
That is not made out.
Not made out at all. That's a surrounding circumstance. And fourth, my lord, he has himself in his, my lord, affidavit says, my lord, that this is, my lord, goodwill is to be determined not by reference to a statute, not by reference to common law, but by reference to the contract of partnership itself. Now, my lord, that being the position, my lord, no question of fact is to be decided, and my lord, the court can straight away, my lord, go into, my lord, a question, my lord, of, my lord, the interpretation of clause 17 and determine. Now, my lord, one case I wish to rely on here, that interpretation is a question of law. My lord, kindly take, my lord, 2017, 5 Supreme Court cases, 1 to 7. My lord, kindly have a look. My lord, paragraph 15. My lord, print page 4, but it's, my lord, of the report, page 130. As a matter of fact, I'm sorry.
Yes.
As a matter of fact, in our view, having regard to the nature of controversy and the issues involved regarding ownership based on interpretation of documents, questions did constitute substantial questions of law. Para 17, my lord. When the court is called upon to interpret the documents and examine its effect, it involves questions of law. It is therefore obligatory, etc. So, my lord, interpretation of documents, my lord, is, my lord, a question of law. And, my lord, there cannot be, my lord, any dispute, my lord, with regard to that.
Yes.
Now, my lord, based on this, my lord, there are several judgments, my lord, of, my lord, your lordship, my lord. My lord, may I, my lord, just, my lord, cite those judgments? My lord, the first one I rely on, 2022 SCC Online, Calcutta 2516. My lord, your lordships, my lord, relied on the Supreme Court judgment I cited. Kindly come to para 9. My lord, print page 3, I think, my lord. Thank you. Yes. Order 8, Rule 10 had been inserted by the legislature to expedite the process of justice. The courts can invoke its provisions to curb dilatory, often resorted to by defendants by not filing written statement, by pronouncing judgments against it. At the same time, the courts must be cautious and judge the contents of the plaint and document on record as being of an unimpeachable character and requiring any evidence to be left to prove its contents. Supreme Court in so and so. Then, my lord, para 10, my lord, of your lordship's judgment. Accordingly, for invoking the provisions under Order 8, Rule 10, this court must put to test the averments in the plaint and consider their veracity. Present case has been primarily filed by the plaintiff to protect its trademark HON'BLE as well as its copyright in the ORIA. At this juncture, deems it appropriate to produce so and so. Then, my lord, your lordship considers, my lord, the design, etc. And, my lord, finally, kindly come to at, my lord, paragraph 19. The present suit is also a commercial suit, as is here, within the definition of the commercial code, commercial so and so. And it was the clear intention of the legislature that such cases should be decided expeditiously and should not be allowed to linger on. Accordingly, if the defendant fails to pursue his case or does so in a lackadaisical manner by not filing, the court should invoke the provisions to decree such cases. Resultantly, having been satisfied with the averments made and duly supported by documents and affidavit, no written statement being on record, this court deems it fit to invoke the provisions of Order 8, Rule 10 of the Code of Civil Procedure. Then, my lord, kindly take, my lord, the next case, my lord, which is 2022 SCC Online Calcutta 3514. My lord, paragraph 25. My lord, para 27, your lordship also relies on a Delhi High Court, which we shall also rely on, my lord. Delhi High Court.
Yes.
Order has been inserted to expedite, etc. Then, my lord, para 28, Because the defendants continue to infringe, support has also annexed colored photographs as per record, filed the suit and interim order when the same was duly forwarded, etc. View of their court is of the view, contents and relied on is an unimpeachable character. Now, my lord, here, my lord, admitted fact, my lord, death of the partner, my lord, in June 2000, my lord, 2 years, my lord, is, my lord, after
period.
that, my lord, whatever is recovered,
Yes.
my lord, that minus 30% is, my lord, goodwill and profits. And we've given the accounts, my lord, with our claim, which is not, my lord, challenged at all. Now, my lord, kindly take, my lord, the, my lord, Calcutta High Court, another Calcutta High Court decisions, my lord, 2024, SCC Online, Calcutta 6157, my lord, paragraphs 18, 19, 35 and 36. My lord, the Supreme Court.
Chaudhary collected my all judgment.
Yes.
Not all of them. Up to date.
And these are, my lord, IPR matters, my lord, which your lordships, my lord, decided, where actually there can be, my lord, a greater scope of a disputed question of fact. But, my lord, here, my lord, in our case, my lord, then, my lord, your lordship satisfied, para 35, 36, 37. After, my lord, relying on the
You
Supreme.
have not filed any, there is no appeal to that order.
No, nothing.
18, 19 chilo ka na?
My lord, 18, 19, 35 and 36.
This service kara kare, appear karini, undefended, order 8 will take
Yeah.
19.
And, my lord, the Supreme Court, which I cited, my lord, has been relied on.
Yes.
Now, after this. Then, my lord, kindly take.
How much time it take, Mr. Mayor?
2 minutes, man. Kindly take 2016 SCC Online Delhi 5961. My lord, I'll just give the para numbers, para 11 and 12 and 28 and 30. My lord, this is, my lord, Delhi High Court, which your lordships relied on also. And this Delhi High Court also relies on Supreme Court 10, 11 and 12.
Yes.
And, my lord, 28, 29. And, my lord, the decision, my lord, which I cited, my lord, the Supreme Court, my lord, which I gave on the iPad, my lord, I have a copy of that also.
Yes.
Section 58, there is still the accept with the data.
My lord, here, my lord, there's no question of fact involved. It's only interpretation. And, my lord, there is no calculation given. My lord, on that interpretation on clause 17.
That's why if section 17, if is agreed by that, then he has to give the calculation. No, this has not been calculated. This
Yes.
amount is further.
And nothing. And the accounts we've given, no dispute.
Yes.
My lord, those are my.
I understand this was the final arguments in the suit. So Mr. Mukherjee is pressing for a decree. Kindly have
Come
the
on the next day.
Come.
When suffering for the plaintiff, when suffering for the
pressing for
defendant. The plaintiff has concluded his argument with regard to passing final judgment and decree under Order 8 Rule 10 of the Code of Civil Procedure. Due to paucity of time, counsel for the defendant could not argue the matter. According case adjourned, let the matter appear on. Give the date. Commercial, hai na? Tomorrow, 2 p.m. available?
Yes, ma'am.
What is the date? 22nd at 2 p.m. 22nd January at 2
Other matter got cancelled. My other matter got cancelled.
Yes. Yes, next. ये कोई
Affidavit
पानी
का-
अच्छा No evidence है, witness है.
Yes.
Mr. Mitro,
Yes.
your matter, but other matter, witness is present. But in the other matter, witness is present. The 345 matter.
Yes, my lord.
How much time will take?
My lord, 5 minutes.
5 minutes.
We'll wait.
My lord, I have filed probate application, my lord, without. Huh?
Madam, pick the 345, item number 6 of the non-commercial list.
My lord, I have filed probate application, my lord, with the death certificate not issued by the municipality, my lord, but issued by the hospital, my lord. And that is why, my lord, your lordship directed me to proof.
What is?
একটু প্রবেট অ্যাপ্লিকেশনটা দেবেন?
অসুবিধা হচ্ছে তাহলে ঠিক আছে চেয়ার দিতে বলবো।
Say required chair, give the chair.
তাড়াতাড়ি অসুবিধা হচ্ছে তাহলে চেয়ার দেওয়া ঠিক। আপনি আজকে প্রথমবার আসছেন, বাংলায় বলবেন তো? আমার সাথে বলুন। বলুন, আমি শপথপূর্বক বলছি।
আমি শপথপূর্বক বলছি
এই মামলায় সাক্ষ্য দিতে এসে
আমি
যা বলবো সত্য বলবো,
সত্য বলবো,
সত্য বই মিথ্যে বলবো না,
সত্য ছাড়া মিথ্যে বলবো না,
কোনো কথা গোপন করব না।
আপনার নাম? রুবি রয়।
রুবি রয়, RUBY?
হ্যাঁ।
RY?
না, হ্যাঁ, ROY রয়।
আপনার স্বামীর নাম?
বিকাশ রায়।
বিকাশ রায়। আপনার বয়স?
67।
কি করেন আপনি?
আমি হাউসওয়াইফ।
বাড়ির ঠিকানা বলুন আস্তে আস্তে।
RN ট্যাগর রোড, সোদপুর।
RN
ট্যাগর রোড, সোদপুর।
পিনকোড বলতে পারবেন কিছু?
পিনকোড হলো নাম মনে
জিজ্ঞেস করবেন না।
পিনকোড হলো ভুলে যাই। পিনকোডটা ভুলে যাচ্ছি।
ঠিক আছে ম্যাডাম, ডোন্ট টেক্সট আস।
Mrs. Roy, I am showing you a document. Kindly see the document properly and tell my lord what is the document is. What is the document?
ডকুমেন্টটা ভালো করে দেখুন এবং মাই লর্ডকে বলুন যে এই ডকুমেন্টটা কি।
এটা আমার শ্বশুরমশাই বন্ধু গোপালের ডকুমেন্টস।
কি ডকুমেন্ট বলুন?
আমাকে যে উইল করতে দিয়েছে, আমাকে উইল করে দিয়েছে।
This is the will of my father-in-law, namely Mr. বন্ধু গোপাল
রয়।
বন্ধু গোপাল রয়। আপনাকে দিয়ে গেছে বলেন?
হ্যাঁ।
By his will, he had bequeathed his property to me.
Mrs. Roy, kindly see the last page of this document and tell my lord who has signed this document.
এই উইলের শেষ পাতাটা দেখুন এবং বলুন যে উইলে কে সই করেছে।
বন্ধু গোপাল রায়।
The will was signed by Mr. বন্ধু গোপাল রয়।
What is the relation with বন্ধু গোপাল রয়?
কার সাথে?
What is the relation with you with বন্ধু গোপাল রয়?
আপনার সাথে বন্ধু গোপাল রায়ের সম্পর্ক কি?
শ্বশুরমশাই হলেন বন্ধু গোপাল, আমি তার বৌমা।
He was my father-in-law and I am his daughter-in-law.
Mrs. Roy, kindly see the document and tell my lord what is the document.
এই ডকুমেন্টটা দেখুন এবং মাই লর্ডকে বলুন যে এই ডকুমেন্টটা কি।
কোনটা বলবো?
এই ডকুমেন্টটা দেখে বলুন এটা কি।
বন্ধু গোপাল রায়। এটা হলো বলরাম সেবা মতো হসপিটালে বন্ধুগোপালের বন্ধুগোপাল রায়
Mr. Bondhugopal Roy died at Sri Balaram Sheba Mandir
Sheba-
Hospital. This is the death certificate of Mr. Bondhugopal Roy.
What is the date of the document?
এই ডকুমেন্টের তারিখ কত আছে বলুন?
12/12/2004
The document is dated 12th December 2004.
Can you tell, my lord, who has signed this document?
আপনি কি বলতে পারবেন যে এই ডকুমেন্টটা কে সই করেছেন? কে দিয়েছেন ডকুমেন্টটা? কার সই?
বন্ধুগোপাল রায়
বন্ধুগোপাল রায় তো মারা গেছিলেন। এই ডকুমেন্টটাতে সই কে করেছেন?
সই সই আছে আমার যে
আপনি বলতে পারবেন সইটা কার?
হ্যাঁ
বলুন কার সই?
সব আমার ননদরা আছে হ্যাঁ, বন্ধুগোপাল রায় সিগনেচার
These are the signatures of my sister-in-laws.
Is this document signed by the registrar of Sri Balaram Sheva Mandir Hospital?
হ্যাঁ
এই ডকুমেন্টটাতে কি বলরাম
হ্যাঁ 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 শ্রী বলরাম শিব মেডিকেল হসপিটাল
Yes.
Do you have the original document of this document?
এই ডকুমেন্টটার অরিজিনালটা কি আপনার কাছে আছে?
অরিজিনাল ডকুমেন্টসটা আছে কিন্তু যেখানে আমার বার্নিং হয়ে
I have the original of this document. বলুন।
হ্যাঁ আমাকে বার্নিং যে ফোনে করা হয়েছিল ওই ডকুমেন্টসটা আমাকে দেয়নি তার বদলে অন্য একটা ডকুমেন্টস দিয়েছে
At the burning ghat, the original document was taken, and instead of that original document, another document was given to me.
Mrs. Roy, I am showing you a document. Kindly tell my lord, what is the document?
এই ডকুমেন্টটা কি মাই লর্ডকে বলুন।
এটা হলো পানিহাটি পৌরসভা যেখানে ইয়ে করা হয়েছে দাহ করা হয়েছিল তার সার্টিফিকেট
What is that? Sorry.
This is a certificate of Panihati municipality where he was cremated, where Mr. Bondhugopal Roy was cremated.
What is the date of the document?
তারিখ কত?
12/12/4
The document is dated 12th December 2004.
Who has issued this document?
এই ডকুমেন্টটা কে ইস্যু করেছেন? কে দিয়েছেন এই ডকুমেন্টটা?
ওই যে ইয়ের থেকে পানিহাটি পৌরসভা
This document was given from Panihati municipality.
My lord, I forgotten, my lord. My lord, it will be, my lord, exhibited, my lord. Kindly mark it as exhibit A, my lord.
Document?
Yes, my lord.
The original one?
Yes.
My lord, the death certificate is a photocopy. This is original.
This is not the original. Where is the original?
Yes, my lord. What happened, my lord? No, my lord. What has happened, my lord? After depositing this document, my lord, they have issued the cremation certificate, my lord. This is the procedure, my
Where is
lord.
the
That is
cremation
why,
certificate?
my lord, I have, my
So
lord.
you should
My lord. My lord.
give it to the witness.
Mrs. Roy, I am showing you a document. Kindly tell my lord what is the document.
এই ডকুমেন্টটা কি মাই লর্ডকে বলুন।
এটা হলো পানিহাটি মিউনিসিপ্যালিটির অফিস আচ্ছা এটা পানিহাটি মিউনিসিপ্যালিটির সেই ডকুমেন্টসটা
This is a cremation or the burial certificate which was given by the Panihati municipality office.
What is the date of the document?
তারিখ কত ডকুমেন্টটার?
12/12
The document is dated 12th December 2004.
Kindly see properly and tell my lord what is the date of the document.
ডকুমেন্টের তারিখ দেখে ভালো করে দেখে বলুন কত তারিখে এই ডকুমেন্ট ইস্যু করা হয়েছিল। স্যার প্লিজ
যে পানিহাটি মিউনিসিপ্যালিটি
তারিখ দেখে বলুন।
ডেট হলো ডেট অফ ডেট 12/12/4 পানিহাটি ডেট 12/12/4 9/2/8
The document is dated 9th February
এই যে
2005
এই যে 5 এটা না
5
দেখতে পাচ্ছি না।
9th February 2005.
My lord, kindly mark it as exhibit A, my lord. This is the first exhibit, na? My lord,
Title
kindly.
certificate, huh?
My lord, original.
Yes. Anything further?
My lord, two documents, my lord.
Give.
Mrs. Roy, kindly see the document and tell my lord what is the document.
এই ডকুমেন্টটা দেখুন এবং মাই লর্ডকে বলুন যে এটা কি কি ডকুমেন্ট এটা
ডেট রিপোর্ট আছে
কার ডেথ রিপোর্ট দিস ইজ দ্য ডেথ রিপোর্ট অফ মিস্টার বন্ধু গোপাল রয়
বন্ধু গোপাল রায়
What is the date of the document?
তারিখ কত ডকুমেন্টের ভালো করে দেখে বলুন The document is dated 12th January 2011.
Who has issued this document?
ডকুমেন্টটা কে ইস্যু করেছেন কে দিয়েছেন ডকুমেন্টটা
এই যে বাবা ইয়েতে এটা কি লেখা আছে
আস্তে আস্তে দেখে বলুন ভালো করে
May I ask otherwise, my lord? Is it issued by the ward master of that particular hospital?
এটা কি ওই নির্দিষ্ট হসপিটালের ওয়ার্ড মাস্টার দিয়েছিলেন yes this document was given by the ward master of that particular hospital
Let it be exhibited, my lord, as exhibit C, my lord. This is original, my lord. Last document, my lord. B exhibit. I'm sorry.
the previous question right
Yes, next.
Last and exhibit, my lord. I'm showing you a document. Kindly see it properly and tell my lord what is the document.
এই ডকুমেন্টটা ভালোভাবে দেখুন এবং মাই লর্ডকে বলুন যে এটা কি ডকুমেন্ট কি এটা
পানিহাটি মিউনিসিপ্যালিটির অফিসে আর এটা হলো কি লেখা আছে বন্ধু গোপাল রায় পানিহাটি বার্নিং ঘাট
This is a cremation or burial certificate issued by the Panihati Municipality Office, Municipal Office.
These are all documents, my lord, to prove the death of the testator, my lord.
See.
These are all my available documents, my lord, in original to prove the death of the testator, my lord. Exhibit C. May I indicate one thing, my lord? My lord, the annexure A, my lord, this is the Xerox document, my lord. This cannot be, my lord. Original is not with me, my lord, because it should be, my lord, deposited in the burning ghat and they will supply me the cremation certificate. And that is why, my lord, this is the Xerox, my lord.
Okay, you've given the criminal
My lord, my lord. I'm grateful.
So offering for the plaintiff. Plaintiff witness is present. During her evidence, 3 documents were marked as exhibit A, B, and C. List of examination plaintiff witness is closed. Counsel for the plaintiff submitted. She will not adduce any further evidence. Accordingly, case is evidence of the petitioner is closed. Not plaintiff. Petitioner hoga jahan mein bhi ho. Full stop. Let's list the matter on 24 January.
For argument, my lord.
For argument.
I'm grateful, my lord. I'm grateful.
Yes.
I have just one more topic left, that is the approbate reprobate, and then I go to the prayer. This lordship may recall is that suit. My suit for specific performance of an agreement of October 2023 by which they were to transfer their shares at 63 rupees per share. They were not doing so, compelling us to file a suit for specific performance. In the suit, there was an injunction order passed after hearing both sides. In the year 2015, sometime in March 2015. Now, this order continued, I will cut it short, till 2022 or 2023. I was not willing to specifically perform any more after a certain point, and I withdrew. I could have allowed the suit to get dismissed on its own if I had not come lack of evidence, that the suit would have been dismissed because there was no counterclaim from them. So this is a case where I just I correctly came and told the court I am not willing to proceed. I could have let the matter go and then the outcome would have been the same. One thing happened before that. Before that, there was an application filed by them just before the suit was dismissed, around a month or so, 3-4 weeks before. They wanted to specifically perform the application.
Not the counter.
Not counterclaim. And counterclaim was anyways long time bar. So, my lord, because that application, even if a court couldn't have granted a decree on the defendant's application when there was no counterclaim. Now, my lord, lordship, yes. So, what about that to me? Yes, that application I have referred to specifically perform. However, I've got 2 points. That one is the approbate reprobate. Having taken the stand that this agreement is invalid, not enforceable, can they now seek restoration of the suit? So that what will they ask? They will ask for enforcement. That's my point. And then lastly, I will just show that the reliefs which they've claimed anyways can't be granted. Now, lordship, on the approbate reprobate point, it is a short point. I have a short note prepared. That was some reason missed out. While opposing an injunction application in CS 54, while opposing an injunction application CS 54, the respondent's specific contention was that the MOU dated 30th October is hit by Securities Contract Regulation Act, is unstamped, inadmissible in evidence, and thus unenforced. This will appear from the order of 31st of March, 13th of May, and 29th of August, which I've given the first volume. Yes. Volume 2. Those orders are there which record his submission. Applying the doctrine of approbate reprobate estoppel, the respondents are not permitted to take a contrary stand and seek enforcement of the very same MOU. For this, lordship kindly takes a look at my principal note where in the list of dates, their whole case is I had withdrawn the suit after the date of 1st of March 2023. Page 192. No, GA4. 1st of March 2023. That is in my list of dates. This was the application they made for performance of the MOU. Or you can see the prayers.
Of the application?
Of the application, which are set out at page 191 of GA4. GA4 is the restriction application. Yes. 191.
191.
Next year. Volume 2, it will be volume 2.
Yes.
Or you kindly see the prayers, order directing transfer of the 12 lakh shares of MBL and 12 lakh shares of bonus shares of MBL. That is also another point taken. They were not willing to perform by the petitioner upon payment of rupees 15.30 crore, being the aggregate value of 24 lakh shares in terms of the MO 63 rupees. And this is a specific, because this is a specific performance claim. Specific performance claim. And their case is that upon this application being moved, we withdrew the suit. That is paragraph 17 and 18 of this GA4. Pages 8, 9, 10, also paragraph 21.
17, 18, and 21.
Can I see paragraph 21 first? 21 is I can go backwards, it'll be easier. Page 11 of the application.
Yes.
The whole cause of action is this. paragraph 21. It is submitted that by withdrawing the suit, the plaintiff respondent has the most dishonest and malafide manner attempted to frustrate said application. Said application is this application referred to at paragraph 17. Paragraph 7. See the hidden agenda of withdrawal was to avoid honoring the terms of them.
Yes.
Now, when their own stand earlier was that this application is unenforceable. Can you take a contrary stand? After all, we are in a court of equity and restitution is an equitable relief. Yes. This is clearly recorded, especially in the order at page 160, 29th August. 29th August order specifically records this in full detail, page 170. Why this is page 169. All the grounds on which. Now I'll show just two judgments. Karam Kapai. Restitution is an equitable remedy. An equitable remedy, can you approbate and reprobate? Karam Kapahi's judgment to a 10-4 SCC 753 at 768. Paragraph 50. The phrase approbate and reprobate is borrowed from Scots law, where it is used to express the common law principle of election, namely that no party can accept and reject the same instrument. This is that MOU we are talking about. In the instant case, while filing its suit and questioning the title of the trust, the club seeks to reject the lease deed. At the same time, while seeking the equitable remedy under Section 140 of the Transfer of Property Act, the club is relying on the same instrument. Legally, this is not permissible. Or Justice Cotton in Versha Cremeries, which has been approved by a Constitution bench, the principle of election has been very felicitously expressed in the treatise Equity, a course of lectures by Maitland. The learned author has explained the principle thus: the doctrine of election may be thus stated, that he who accepts the benefit under a deed or will or other instrument must adopt the whole contents of that instrument, must conform to all its provisions, and renounce all rights that are inconsistent with it. In the old equity case of Streetfield versus Streetfield, this principle has been discussed in words which are so apt and elegant that I better quote them. Election is an obligation imposed upon a party by courts of equity to choose between two inconsistent or alternative rights or claims in cases where there is a clear intention of the party of the person from whom he derives one that he should not enjoy both. Every case of election therefore presupposes a plurality of gifts or rights with an intention expressed or implied of the party who has a right to control one or both, that one should be a substitute for the other. The party who is to take has a choice, but he cannot enjoy the benefit of both. But the principle is stated thus in Jarman on wills, that he who accepts the benefit under a deed or will must accept the whole contents of the instrument, conforming to it, all its provisions, and renouncing every right inconsistent with it. The principle of the doctrine of election is now well settled. This principle, doctrine of election, I'm not, Lordship, the second judgment, I'm not placing once more, Lordship, paragraph 65 of the second judgment, same principle, 38 SCC. Now, Lordship, I come to the prayer made in this GA4. The notice of motion. Oh, master summons. So master summons, no? Master summons. Kindly see the master summons and whether he can get
Master summons.
Master summons in this.
Yes.
Recalling the order dated 28th of March, passed by your lordship, dismissing CS 54 and restoring the suit for hearing the present application. If the suit is restored, also gets restored as is their pleading in paragraph 21, their application gets restored. Because for hearing this application, you don't need restoration because it's a restitution application. Because restitution application is after a suit is disposed of. One wants to be, or once the order is gone. Now they want to restore, as is their pleading at page 11, paragraph 21 I just now placed. That is their exact pleading.
Withdrawing of the suit has not been dishonest.
Don't frustrate the said application. That is the application for specific performance. So, Balad, firstly, I am submitting restoring the suit and only for the purpose of hearing an application go not supported by counterclaim and not within limitation. And second prayer, Lordship. Now this is the another prayer they've made. An order directing the plaintiff respondent to pay by a restitution 1 crore 23 lakhs. Kindly see, their basis is paragraph 39 and 42. Kindly come to paragraph 39 of this application, page 17 of the affidavit in support.
Yes.
Page 17, paragraph 39.
Yes.
It is submitted that the respondent is liable to compensate the petitioner to the extent of the following difference in price of the aforesaid shares as on March 23, 2015, when the order of injunction was passed, and as on 28th of March, when the caption suit was withdrawn. Now, this prayer anyways cannot be made, apart from all other dehors, all other points. 23rd of March 2015, he had to serial number in this. 23rd of March 2015 is the order of injunction. That is, kindly take my list of dates one. Because I want to show that is serial number 4. 23rd of March 2015. Agreement about good. 8 about. 8 about. Page 151. 23rd of March is the interim order is passed.
Correct.
Now, Lordship kindly comes to serial number 6. Sorry, no, serial number 6. My mistake, serial number 5 next. By way of an amendment to the MOU, the validity thereof was extended. So that is a mutual act. Kindly see page 150. At 150 of this. Volume 2. Of volume 2. Volume 2, page 150. This is nothing to do with court. Out of court is a mutual agreement for performance, for extending the time to perform the page 150. This is important. How can they go back on the injunction order when the parties out of court on their own enter into an amendment for extension of the page volume 2, page 150. 150.
Yes.
First document in the second one.
Yes.
Amendment to the MOU, whereas the MOU of so-and-so was entered. Actually, this is a short next page, page 151. By mutual consent, the validity of the MOU dated 30th of October 2013, as per clause 4.1 of the 31st of March 2016. So, when the parties themselves agreed that this agreement will be performed till March 16, how can they take the injunction or the order as the basis for the restitution? Because the injunction, they're taking the price as of the date of the injunction order.
2015.
That is some 600 rupees or something they have claimed. When And this is recorded in the order also, that's a subsequent order that they've agreed. So when the parties have themselves agreed to extend the MOU, they've given up their, I mean, even if they had the not so honest motive of breaching the agreement and selling the shares, that is waived when they subsequently agreed to extend the time.
So they not claim with regard to the 2015.
2015 claim, they have mutually by parties
Mutually agreed.
extended the time. And not only this, my lordship, kindly then sees.
So what is the suit for?
The suit is my suit is for specific performance of this of the original agreement of March of October 30th, October 2013, MOU of 30th October 2013. I want to specifically perform it.
Correct.
They were not willing to, and I had to file a suit for specific performance. They were injuncted from selling outside
Selling this,
or acting to the contrary.
Correct. And subsequently you have withdrawn that.
Subsequently, I withdraw 2023.
Correct.
But in between, after the injunction, the parties themselves out of court extend the MOU till March 16.
Correct.
So they were so they have themselves, by their conduct, agreed not to sell the shares to anybody outside till March 16. So how can they take this? I'm asking, how can they take the price of March 15? When the injunction really has been given a go by, when the parties themselves agree to extend the MOU. Kindly see this in juxtaposition with.
So whether it was brought on by way
record.
of
Yes,
amendment?
yes. This was brought on record by way of an order passed on
6 May 2015.
6th May.
May 2000.
6th May 2015, page 154. This is the order I also want to show otherwise. 6th May, page 154. That is by serial in my list of dates. It is serial number 7.
108.
A supplementary affidavit has been filed by the plaintiff stating that during the pendency of this matter, the parties have entered into a memorandum of understanding and the order of status quo may be varied in order to enable the parties to discharge their reciprocal obligations as contained in the original MOU as well as amended MOU. This is my contention. In view thereof, the order of status quo is varied to the extent that the parties shall discharge their reciprocal obligation in terms of the MOU as also the amendment of the MOU. The status quo order, the parties not only give a waiver to it, but by order of court, neither side object.
So what was the GA 845?
GA 845 was the injunction application.
For the bonus shares.
Oh.
Injunction application for the bonus shares. Company
845.
Yes, GA 845.
Your injunction application? Because that was disposed of.
No, that was not disposed of. That was pending.
So 845, what was the 845?
No, 23rd March, page 106. That was my injunction application, not to act in breach of the MOU.
845.
845. Lordship, there only the order was passed the 23rd of March, which is page 106. Page 106. Let's say the score was passed.
Status quo in terms of prayer B.
Prayer B, I have quoted in my list of dates.
Correct.
Can you
Yes.
see?
23rd March.
Yes. From so
Serial
this
number 4.
Yes. This application was pending.
So this now as per this it has been modified.
Modified
by the 6th May 2015.
6th May. After first comes the amendment, parties extend, and this order is modified by allowing both sides as per the MOU to act in terms thereof. It is not their case that after this MOU, they approached me to perform the agreement, and I did not. Then they would have. There is nowhere their case, and in fact, that is. I will show that cannot be their case.
And you have not made amendment in the plaint or the prayer after this memorandum.
No, Lordship is absolutely right. I will just check this. There was no amendment of the frame as modified by
order dated.
It's because partly infractuous. Yes, Lordship. So as modified, it was not there. In fact, both sides took the order as was passed on this May 2015 that both sides shall discharge their obligation. So, Lordship, after this, can you still say that 23rd March.
If you go by this, so the first order become
Infructuous.
and this order come into force, and as per this order, your prayer has become infructuous because it has been modified.
Yes. Exactly. So,
So
that's
your
what I-
original MOU has been modified by the subsequent
subsequent
MOU.
amendment, and then this order. And also, can see in the view of thereof that the status quo order is varied. Page 10
That's
is second
why.
paragraph. Status quo order is varied. And this appears to be by more or less by mutual consent because just after the MOU.
That's why. What is the 845?
845 was the injunction application where we had said specific performance of the MOU of October 15th.
23rd March.
They should not be allowed to sell their shares contrary to the MOU. They should transfer it to
That
me.
is that's why 23rd March 2015.
23rd March order is passed in
845.
and that is the
That
status
was-
quo order.
That was
which
modified
extended
by
on
6th
6th
May 2015, and that was disposed of.
Because 23rd March was extended on 6th April and viewed that nothing remains in GS. So this gets disposed of by this. So the status quo order is not there anymore. That's I'm coming to that. So how can they ask for restitution on the basis of the March 15 order, which lost its force? You give me 15 minutes. I will finish it. I will. This will just one or two more orders, and I'll just finish for 10 minutes. 10 minutes.
Let it continue in the list. Maybe tomorrow. Let him conclude it tomorrow.
Tomorrow then it will be after 3:30. I have a same difficulty after 3:30 tomorrow. Anytime.
Or
after nahi hai na?
Sorry.
All the time
3:30 I can do, or 3:34 or whatever time.
3:15 tomorrow.
3:30. 3:30. I have this ongoing partner matter which is going on.
11:30 morning tomorrow.
Alipur commercial. Alipur commercial. But it's after 3:30. Alipur after 3:30 because I have if it's possible, or else on Friday I can do it. Friday Lordship is little light. I can do it. If Friday many people will not come, as Lordship has seen. Friday many a person will not come. If that commences any time on Friday.
24th में है देखो खाली.
First thing in the morning or later, whenever.
3:45 में है.
3:45 unlikely.
Morning तो नहीं बोले.
No. Friday.
Friday 11:30.
Yes.
Friday 3:30. 11:30. 11:30 is fine.
11:30.
So suffering for the plaintiff, so suffering for the defendant. Police counsel for the plaintiff has argued at length in connection with GA4 of 2023, but due to paucity of time, hearing could not be completed. Let the matter appear on 24th January at 11:30 AM.
Deeply obvious.
My lord, I apologize for troubling your lordship. My lord, that Fox and Mundell matter, which was fixed tomorrow at 2 p.m. and some difficulty tomorrow, my lord. Very sorry, my lord. I spoke to
You do one thing, you inform Mr.
I've informed Mr. Mukherjee, my lord. He said he has no difficulty if your lordship keeps it on any other day.
I will take them because
To 28th, if your lordship could fix, if your lordship's board permits, my lord. I'm so sorry, my lord. Tomorrow I might be not coming to court. That if it is convenient, my lord, any other date next, other than this is a commercial matter.
Commercial matter. तो आप लिया था order कौन सा लिया था नहीं? Then 28 में 11:30 fix है क्या?
12 o'clock, there's a matter fixed, my lord. My matter, my lord. That 12 o'clock and 4 o'clock, two matters are fixed. I know, my lord. Both are mine.
29th
29th, I'm not in.
fix है.
30th, if you
सब fix है. 11:30 भी fix हो गया. 7th of February.
Yes, sir. I'm not in Calcutta. Sorry. Not in Calcutta. 10th, my lord. 10th, 11th, any day, my lord, that week, other than
13th at 11:30.
I'm so grateful. I'm sorry for.
बोल देख लेना उसमें किस कौन दिया dictation.
I'm sorry for troubling your lordship.